court officer.
ಸರ್ ಆಡಿಬಲ್ ಇದೆ, ಆಮೇಲೆ ಸಾವಿರ ಬರ್ಲಿ.
Okay.
ಆಡಿಬಲ್ ಇದೆ ಇವ್ರೆ.
Okay, okay, no problem.
ಏನಾರು ಮಾಡಿ ಇನ್ನೊಂದು ತಿಂಗಳು ಮುಗಿಸಿ ಹೋಗ್ಬಿಡೋದು. ಈಗ ವಾತ್ಸಲ್ಯಕ್ಕಿಂತ ಸಾವಿರ ಬೆಟರ್ ಅದಾರಲ್ವ. ಈಗ ಅವರು ಅಂದ್ರೆ ಅವರು ಈಗ ನಮ್ ಸೂರ್ಯ ಸರ್ ಸಂಜೆ ಕೂಡ ಹಂಗ ಒಂದ್ ಸ್ವಲ್ಪ ಫ್ರೀ ಆಗಿರ್ತಾರಲ್ಲ, ಹಂಗಿರಲ್ಲ ಇವ್ರು. ಇವ್ರು ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾತಾಡ್ದಂಗ. ಪೊಲೀಸರಿಗೆ ಇಲ್ಲಿದ್ರೆ ಎದ್ದು ಹೋಗಲ್ಲ. ಆ ಪೊಲೀಸ್ ಎಲ್ಲ ಫೋಟೋ ಬಡ್ದ ಅಂತ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಏನಂತ ತಿಳ್ಕೊಂಡಿದ್ದೀನಿ. ನಮ್ಗ ನಾವೆಲ್ಲ ಬೇರೆ ಸಾವಿರ ಮಾಡಿರ್ತಲ್ಲ ಅವ್ರು ನಮ್ಗೆ ಮಾಡ ಅವರೆಲ್ಲ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಜಾಸ್ತಿ ಮಾಡ್ತಾರೆ. ಬೆಟ್ರ್ ಧಾರವಾಡದ ಭಾಳ ಕರೀತಾರೆ ಕಲಿಗಿಂತ ಧಾರವಾಡ ಭಾಳ ಕರೀತಾರೆ. ಈ ಕೋರ್ಟ್ ಆಗಿದ್ರೆ ಈ ಕೋರ್ಟ್ ಆಗ್ಬೇಕಾಯ್ತು. ಮಾಡಲೇಬೇಕಂದ್ರೂ ಕಷ್ಟ. ಇಟ್ಬಿಡೋಣ ಸುಮ್ಮನೆ ಮಾತು ಬಿಡ್ತೀವಿ. ಗೊತ್ತಿದ್ರಿ ಮರ್ತು ಬಿಡ್ತೀವ್ರಿ ನಾವು. ಹೇಳ್ರಿ ಮೇಡಮ್. ಏನೆಲ್ಲ ಮತ್ತು CPC ಹಾಕ್ಬಿಟ್ಟಿದಾರಲ್ಲ. ಆಲ್ಮೋಸ್ಟ್ ಅದೆಲ್ಲ CPC ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಒಂದು ಬುಕ್ ಅಲ್ಲೇ ಇಟ್ಬಿಟ್ರೆ ನಾನು ಬುಕ್ ಅಂದ್ರೆ ಕೆಳಗಡೆ OS ಅಲ್ಲಿ ಅರೇದಲ್ಲಿ IA ಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿರ್ತಾರೆ. ಮಂಡೆ ಕೊಡಿ ಸರ್. ವಿಡ್ರಾ ಇದ್ರೆ ಕೊಡಿ. ಲಿಬರ್ಟಿ ಗಿಬರ್ಟಿ ಇದ್ರೆ ಶುಕ್ರವಾರ ಬರುತ್ತೆ ನೋಡ್ರಿ. ಇಲ್ಲ ಏನ್ ಹೇಳಿದ್ರು. ಏನ್ ಸರ್ ಸೇಮ್ ಎಲೆಕ್ಷನ್ ಸೇಮ್ ನೋಟಿಸ್ 30 days ರೀ. ಗುರುವಾರ ಏನಿಲ್ಲ ಸರ್.
Memo for posting, my lord.
May I submit memo for posting at the end of the list?
Why?
Election is on Monday. And
Election matter, my lord, my end of the list, my lord.
Yeah, the election.
Monday.
Told.
So one matter on Monday, tax matter. If you want to withdraw that, I have filed a memo for withdrawal.
Pretty good.
Monday it may kindly be posted.
That's correct.
Thanks. We'll be reading adjournments, serial number 22, number 23 to 30.
My lord, serial number 22, my lord.
Ah,
My lord. In this matter settled before the parties, my lord.
they will close it.
Yes, my lord. It does not survive for consideration, my lord.
Yaradu? Who's there, Duke?
SV Rodgi.
Huh?
Yes, why Rodgi, my lord.
Mr. Sidramappa Y. Rodgi, the learned counsel for the petitioner submits that the parties have settled the suit before the trial court and therefore this petition has become infructuous. The submission is noted and the petition is dismissed as having become infructuous.
Oh, bless.
Number 23 to 30. Number 31 to 35. Number 36 to 40. Number 41 to 44. Number 45 to 50.
My lord, serial number 50, my lord, kindly grant weeks time, my lord.
Suit is filed in which year?
But actually file misplaced in the office, that's what I am taking time, my lord.
Learned counsel for the petitioner seeks time list on.
My lord, serial number 48, my lord. I'm referring for the respondent number 1, my lord.
J. Augustine.
Yes, my lord.
ಯಾಕದು ಮಾಡಿ
Out of station is there, my lord, kindly next week, my lord.
ಅಲ್ಲ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ನೀವು ಬರೋದೇ ಇಲ್ವಲ್ಲ ಅಗಸ್ಟಿನ್ ಅವರು.
And next week, my lord.
ಲರ್ನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
50th.
ಶಿವಾನಂದ್ ಪಾಟೀಲ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್ ಇದು?
13, my lord.
ನಂಬರ್ 48.
13, my lord.
48 13
ಹೌದು 2013 ವಯಸ್ಸಿದೆ, my lord.
ಮತ್ತೆ
ಇಲ್ಲ 48 48 48
ನಂದೇ ಅವ್ರು ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್
ಶಿವಾನಂದ್ ಪಾಟೀಲ್, ಪ್ರತಾಪ್ ರೆಡ್ಡಿ, ವರುಣ್ ಪಾಟೀಲ್.
This is an interim order, I think so.
Huh?
Interim order ಇದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Suit is filed in which year?
2022.
Suit sir, suit.
ಸರಿ 2013
ನೋಡ್ಕೊಳ್ಬೇಕು.
ಮತ್ತೆ ಹಂಗಿರಿ ಕಾಯ್ಬೇಕು.
ಇಲ್ಲ ಅಗಸ್ಟಿನ್ ಸರ್ ಬಂದಿಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಬರ್ದೇ ಪರವಾಗಿಲ್ಲಪ್ಪ. 2013 suit I will not allow it to be adjourned, sorry.
December 51 to 55.
My lord, kindly 1 week later.
Huh?
Kindly
ಯಾವುದು serial number?
1 week.
Serial number.
Serial number 53.
53. ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು? ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಇದು?
23.
2016.
ಹಾ.
OS.
2000?
The respondent number 150.
2016?
16.
ಹಾ, ಯಾಕೆ?
Senior is out of station.
No, let him go on with the matter. ಹಳೆ ಸೂಟ್ಸ್ ಅಲ್ಲಿ ನಾನು ಐ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಏನೋ ಹೊಸ ಸೂಟ್ ಇದ್ರೆ ಐ ಕ್ಯಾನ್ ಗ್ರಾಂಟ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಸಾರಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
ಹುಷಾರಿಲ್ಲ ಮಾಡ ಅವರಿಗೆ.
ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಪ್ಪ.
Serial number 54, your lordship.
Please argue the matter. Let us see. If there's any difficulty, I'll help you.
Yes, ma'am.
Just the way your senior helps you, I'll also help you. Please argue the matter.
Okay.
Serial number 54, your lordship. Kindly take it next week.
ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟಮ್ಮ?
Not seeing.
ನೋಡ್ದಕ್ಕ ಬಂದು ಹೇಳಿ.
10.
56 to 60.
ಶ್ರೀಲಂಬ
56 to 60.
56 to 60. Yes, next. Yes.
Memos, memo. Service matter, may not there in hurry to issue the appointment order.
Service matter?
In a hurry to issue the appointment order, selection committee's orders I have challenged. Kindly.
ಅದು Monday,
on
ಯಾವತ್ತು
Monday.
ಬರುತ್ತೆ?
ಯಾವ್ದು ಬಂದು ಸರ್ವಿಸ್
Comes on
ಬುಧವಾರ
Thursday.
ಬುಧವಾರ
Monday.
Can't it wait till Thursday?
ಬುಧವಾರ
It can come on Thursday. Correct?
They have passed 15 days ago.
What is the date of the selection?
Minutes on.
Selection list ಯಾವಾಗ? Final selection list, when was it announced?
10 days ago minutes.
Ah.
Now I have learned that.
Thursday, let it come on Thursday.
That similar matters minutes where Pharmacy Council of India's matters were issued, notices were issued.
Passing off?
Pharmacy Council of India matters, my lordships a notice, Monday minutes.
Number one, non-compliance of office objection 4 times. Bill number 1, Shiv Kumar Kallu.
Lordship, the matter is infractuous. The
What's your name?
SM Patil.
Mr. S.M. Patil.
Yes, my lords.
S.M.
Yes, my lords.
M for mango.
Yes.
Mr. S.M. Patil. Appearing for representing Mr. Shiv Kumar Kallu. Submits that the writ petition has become infructuous. The submission is noted and the petition is dismissed as having become infructuous. Serial number 2,
Serial number 2, orders Shivanand Patil.
Shivanand Patil.
Already did the process.
Then dismissal ಅಂತಿದೆ.
ಅದೇ ಡಿಸ್ಮಿಸಲ್ ಓನ್ಲಿ ಫಾರ್ R4 and R5 ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಇಲ್ಲ, ದಟ್ ಇಸ್ ದ ಸೇಮ್ ಅಡ್ರೆಸ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಅಪೇರಿಂಗ್ ಆನ್ ದಟ್ ಅಡ್ರೆಸ್.
But ಏನ್ ಮಾಡಿದ್ದಾರೆ
ದಿ
ಇವತ್ತು?
ಇಶ್ಯೂ ಆಫ್ ನೋಟಿಸ್ ಮಾಡಿಸಿನಿ ಆಲ್ರೆಡಿ. ಐ ಪೇಡ್ ದ PF ಟುಡೇ.
But whether you paid, given the correct address?
No, that is the correct address only.
No, no.
That is the only correct address.
It is returned unserved.
Let it be go, let it go this time, my lord. If it does not come upon, then I'll issue paper notification.
The Land Council submits, Land Council for the petitioner submits that the address of the respondent 4A, 4B and 5 is correctly mentioned. He submits that he has issued, he has paid the process and deposited the other requisites to issue notice to R4B and 5.
I may also be, in addition, I may be permitted to serve on the council also.
Man's office is directed to issue notice to the unserved respondents. It is also open for the petitioner to serve the Land Council who represents the respondent number 4B,
B and R5.
4B and R5. Who appear before the
Interim order
trial court. Suit is filed in which year?
2012 or 13 months.
ಏನ್ suit ಅಂತ ಹೇಳಿ ಅದು ಮುಗಿಸ್ಕೊ.
ಏನಿಲ್ಲ, simple. I am the proposed respondent now. The petitioner is the proposed respondent. It is not the plaintiff who has filed the application to implead me, nor I have filed an application. Another defendant who is not concerned to the property that I have purchased has made an application, and that is not permissible.
What
Either
is
the plaintiff must make or I must come voluntarily on the record.
Who has filed the application?
R1 to 3 are the plaintiffs. R4 is defendant number 2.
Who has filed the application to implead you?
R4, R5, my lord, here.
Is there any counterclaim?
There is no counterclaim. That is the import. There is no counterclaim.
ಎಲ್ಲಿದೆ application ಎಲ್ಲಿದೆ?
That's at your lordship will find it at an.
Only defendant number 2 is a necessary party.
Defendant number 2 has filed the application.
ಇದ್ರಲ್ಲಿ defendant number 2 ಯಾರು?
Defendant number 2 is one of the purchaser from the defendant number 1.
ಅಲ್ಲ sir, ಈ writ petition defendant number 2 is R5.
Ade R5 has filed the application.
Then why is defendant number 1 be necessary? Why should notice be issued to defendant number 1B? We are wasting
It's not necessary, but udori issue madinantappa we should be issued.
We are
R5
wasting-
has to be issued nonetheless.
Or wasting judicial time.
Allala, R5 had to be issued. So I just I added that.
Madam, ಅದು ಇದು ಹಿಂದೆ ನೋಡ್ದಾಕಿ. The impugned order is passed on an application filed by the respondent number 5 in this writ petition. And it's notice to respondent number 4, respondent of 4B is dispensed.
They have remained expectant.
Full stop. The Land Council for the respondent, petitioner submits that the notice, that the address of the respondent number 5 mentioned in the cost title is the correct address. And that he has paid process to issue notice to respondent number 5. If process is in order, office is directed to issue notice, notwithstanding the order dated 13/6/2024. It is made clear that if the process is not in order, the petition shall stand dismissed against the respondent number 5. Next para. Yeah, here
Pardon?
R5 has filed the application.
Yes, well,
Earlier the-
R5 has filed the application. R5 is one of the purchasers from R1.
Where is the application?
That application, your lordship will find it at
Page number 22, Malada.
page number 22.
What the annual affidavit?
I state, I am the defendant number 2 in the above case. I state on oath that I have taken a specific plea in my pleading on paragraph number 3 that there are other suit properties, that is survey number 109, 5 acres, 16 guntas. I state on oath that till recently, the plaintiff number 3 in collusion with other plaintiffs of the case and defendant number 1 have sold the above said property with malified intention to deceive my right over the suit property to one Dr. Kalappa. White so and so sale deed number. Therefore, it is necessary that the above said purchaser is a necessary party to the above suit.
Where is the written statement filed by this defendant number 2?
Defendant number 2, your lordship will file that there. I think page number
16.
16, my lord.
Suit ಏನಾಗಿದೆ?
Suit in a pending.
Pending check ಮಾಡಿ madam.
Check ಮಾಡಿ.
265 of 2012, OS number 265 of 2012. Before the
Pending.
second additional senior civil judge in JMFC. Second additional senior civil judge in JMFC, Raichur. Check ಮಾಡಿ ಏನಾಗಿದೆ? Yes. Let pass over.
Much.
Santosh A.
It's, huh?
Santosh, number 3.
ಏನಾಗಿದೆ? Huh? The notice issued to the petitioner is served to him. There is no representation for the petitioner. Since the suit is filed in the year 2018, this petition cannot be kept pending for long. Hence, the petition is dismissed for non-prosecution. Srinivas B. Nayak.
Number 4, Srinivas B. Nayak. Srinivas B. Nayak.
Srinivas B. Nayak. Yeah, who is this respondent number 1? Contesting respondent ಯಾರು?
Respondent number 1.
ದಾನಪ್ಪ. Where is the impugned order? G. Yes, whether respondent number 1 is a necessary party. Huh?
Contesting.
Fifty-three, 7, 2000. There is no representation for the petitioner. No attempt is made by the petitioner to serve the respondent number 1 through court or through substituted service. Full stop. Hence, the petition is dismissed for non-prosecution.
Number 5.
Sachin Mahajan.
Sachin Mahajan.
Non-furnishing of process fee. Who is R1?
R2, my lords, filed the wakalat for R2, my lord. It indicates that,
Will you accept notice for respondent number 1?
my lord, see, R2 is died, bringing a last application hakide.
R2 is dead.
Indicate it,
ಇಲ್ಲಿ
you know,
ನೋಡ್ರಿ notice issued to R2 ಏನಾಗಿದೆ? Wakalat in respect of LRs of deceased R2 by Mahadev S. Patil,
also.
advocate.
Step will be taken. Short a condition.
I will dismiss it, madam. Do whatever you want, Barkul. The petition is filed, the suit is filed, the suit from which the present writ petition arises was filed in the year 2013. The impugned order was passed on
Only possible.
28/10/2014.
Nine,
Huh?
19.
Impugned order was passed on 28/10/2019.
Please, my lord.
Till date, steps are not taken to ensure service of notice to respondent number 1, and no application is filed to bring the LRs of deceased R2. Hence, the petition is dismissed for non-prosecution.
Number 6. Vinayak Apte.
Dismiss for non-prosecution on the madam.
Sir.
Mahadev Patil, Sachin Mahajan. Office is directed to intimate the trial court to proceed with the suit in view of the dismissal of the writ petition.
Please, my lord.
Yes.
Number 6, Vinayak Apte.
Acceptance of
Divergent findings on injunction application. It was allowed by the trial court and
Shankarappa Chimmalagi.
Kindly pass on.
Suit is filed in which year? 2000? There's some 1977 suit. Pass over.
77 ಮುಂಚೆ ಡಿಗ್ರಿ ಆಗಿದೆ ಸರ್.
ಆಯ್ತು. Pass over.
Till number 7.
ಎಷ್ಟನೇ ಸೂಟ್ ನೋಡ್ಬೇಕು?
Ganesh Subhash Chandra Kalaburagi. 17
2000? Yeah.
File necessary applications.
Do it today, otherwise I am dismissing the petition.
Today only.
Today only, please do it.
We will do it. The process will be paid, your lordship, according to.
Do
the same
whatever
matter.
that needs to be done today.
Today only we will do.
Pass over.
Till number 8.
ಎಷ್ಟನೇ ಸೂಟು? 2011. Pay the process now.
Some of them have died.
Do whatever you want, but do something today.
Please.
Something has to be done. Some action has to happen today.
Yeah, in fact,
Huh?
it can be taken up on merits also.
ಆಯ್ತು ಹೇಳಿ ಕೊಡಿ.
Suit for partition filed by respondents.
Suit is for partition.
Partition.
Yes.
Response number, petition in interest of response number 1 to 5 was the plaintiff. The suit was filed before the civil judge, that is junior division,
Senior division.
junior,
Senior.
only civil judge, senior.
Senior division ಅಂತಿದೆ annexure A.
How? Thereafter, my lords, I had filed an application to return the plaint on ground of valuation, pecuniary jurisdiction. The same, my lords, issue was framed regarding the same. In fact, it was filed before the junior division, my lords, as seen from the plaint, order. ಅದ್ ಮೇಲೆ ಏನೋ ತಪ್ಪಿ ಬರೆದಿದ್ದಾರೆ, additional civil judge ಮುಂದೆ. I filed an application to treat issue number, this thing, as preliminary issue, additional issue number 1. Whether defendant number 6 proves that court has no pecuniary jurisdiction. There, my lord, I had produced 33 documents, of which exhibit number 22 to 31 are extract from the sub-registrar valuation. That have not been considered at all. In fact, the court has misunderstood the issue when court fee, whether it is paid sufficient or not, and it has confused the issue to be that.
What is mentioned in the plaint about the valuation for the purpose of jurisdiction?
14 lakh is the total value of the property.
Plaint ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
ಅದೇ, page number 18. Total valuation for purpose of jurisdiction was valued at 14 lakh and plaintiffs have claimed 1/7 share, which is valued at 2 lakhs. Total acres is 77 acres.
The plaintiff values it at 14 lakhs.
Yes, ma'am. The below that prayer, my lords, scheduled property, 22 survey numbers are there. Measuring anywhere between 2 acres 32 gunta to 8 acres 18 guntas. Total calculated, it comes to 78 acres, more than.
Suit is filed in which year?
2011.
11.
The most it may be kept open issue and it can be
Barcode. Evidence ಎಲ್ಲ ಆಗಿದೆಯಾ?
ಇದು ಎವಿಡೆನ್ಸ್ ಮೇಲಾಗಿದೆ.
ಅಲ್ಲ, preliminary issue ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ. The additional issue, my lord, page number 51, bottom of the page.
No, but where is evidence reduced?
I have marked, examined myself as DW1 and I have produced 33 exhibits. That is not referred at all.
33.
That has not been referred at all. I have marked my copy of my deposition also on issue number 1 at page number 42.
Barcode. No, but if you have to allow this writ petition, then
Keep open it to be tried along with others.
even for that, we have to hear the other side.
Only 1 to this thing are necessary parties.
Huh?
Response 1 to 5, they alone are the plaintiffs.
Correct, all of they represented.
No, nobody is represented.
1 to 5 are plaintiffs, but 1,
Response 1 to
2,
5.
3, 4 ಎಲ್ಲ ಸರ್ವ್ ಆಗಿಲ್ವಲ್ಲ?
Yes.
1, 2, 3, 4 are not served. 2, 3, 4.
Yes.
And 2, 3, 4 are not served.
Yes. Regarding other response, it may be dispensed with.
Cool. The counsel for the petitioner is directed to pay process to the respondent number 2, 3, and 4 who are the contesting plaintiffs, who are the contesting respondents in this writ petition during the course of the day. If process is paid, office is directed to issue notice to the respondent number 2, 3, and 4. Notice to the other respondents, notice to the respondent 6 to
43.
43 is unnecessary and the same is dispensed.
Yes.
In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent number 2, 3, and 4 before the trial court.
Yes.
List on date ಕೊಟ್ಬಿಟ್ಟು. Sorry. Praveen Kumar Raikote. Praveen Kumar Raikote.
Issue number 9. Praveen Kumar Raikote.
2000. ಯಾವ notice issue ಮಾಡಿ ಕೊಡಿ. The suit is filed in the year 2010. And this court issued emergent notice on 19/11/2024. However, process is not paid till date. Since a petition is dismissed for non-prosecution. Shivanand Patil.
Number 10, Shivanand Patil. 2 days.
Today, ಎಷ್ಟನೇ ಇಸ್ವಿ suit?
Notice to 1 to 7 may be dispensed.
Pass over. Pay the process today.
Notice to 1 to 7 may be dispensed with, my lords. I'll pay.
1 to, yeah, Who is the necessary
Oh,
respondent?
R8, my lords, R8.
R8,
R8, R8 only.
The learned counsel for the petitioner submits that the contesting respondent in this writ petition is respondent number 8. Hence notice to respondent number 1 to 3 and 5 to 7 is dispensed.
Will pay PF in the course of the day.
The learned counsel is directed to pay the process to issue notice to respondent number 8 during the course of the day. Full stop. It is made clear that if the process is not paid to respondent number 8, the petition shall stand dismissed without reference to bench. Yes.
Interim order.
Interim order granted alleged extent till the next date.
List.
Number 11, Shivkumar Kallu.
Yesterday is suit.
11.
Shivkumar Kallur.
For the petitioner in this case,
Huh?
there are some office objection. I'll do the needful in the course.
Not office objection, pay process.
Process.
Do it today.
I'll do them.
2011 suit.
This is the appointment of court commissioner.
Do what? Sir, I'm not on merits. Please do this preliminary job.
I'll do it.
2011 in the sumne inge pending. What should happen to the litigant who comes to the court? He lose confidence in the court, mister. And from 2022, you're not taking steps to issue notice to R2. Yeah, R2, yeah. So disgusting. R2 is not a necessary party. You don't even make a submission. R2 is a co-plaintiff. But yak bekaru. Notice to respondent number 2 is not necessary, as the contesting respondent is respondent number 1. Hence notice to respondent number 2 is dispensed. List on.
Short.
ಬಂದಿದ್ದಾರೆ ಶಿವಕುಮಾರ್ ಅವರು ಬಂದಿಲ್ವಾ? 2011 ಇಸ್ವಿ ಸೂಟು. It doesn't work on Saturdays, is it?
Yes, my lord. He's out of station, my lord.
Huh?
He's out of station, my lord.
ಮತ್ತೆ ಏನು ಹೇಳ್ಬಿಟ್ರಿ, ಫ್ಯಾಕ್ಟ್ಸ್ ಏನು ಅಂತ ಹೇಳ್ಬಿಡ್ರಿ, ಕ್ಲೋಸ್ ಮಾಡೋಣ.
Short accommodation.
ಪಾಸ್ ಓವರ್ ಫೈಲ್ ನೋಡಿ ಹೇಳಿ. 2011 ಸೂಟ್ ಫೈಲ್ ನೋಡಿ ಹೇಳಿ. ಪಾಸ್ ಓವರ್.
Number
Number 12.
EP Ambekar.
ಎಷ್ಟನೇದು?
Matter has become infructuous.
Learned counsel for the petitioner fairly submits that the writ petition has become infructuous.
It may be dismissed.
The petitions, the submission is placed on record and the petition is dismissed for not,
Yeah.
for as having become infructuous.
Yes.
Number 13, I seek dispensation of notice for respondent number 4 and respondent number 8.
The learned counsel for the petitioners seeks, submits that the respondent number, notice to respondent 4 and 8 be dispensed, as they are not necessary parties.
I'll carry out the necessary amendment.
Pass over, correct it. Carry
Please.
out the necessary amendment.
Please.
Learned counsel for the petitioner has carried out the amendment. Office is directed to check and verify.
Please.
A date could be fixed, your lordships.
ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ, whichever.
Is a impleading application, your lordships, which has been allowed, challenging that, your lordships, the present.
ಏನ್ ಸೂಟ್ ಹೇಳಂಗೆ ಹೇಳಿ ಕ್ಲೋಸ್
Yes.
ಮಾಡ್ರಿ.
No, my lord, suit for partition separate.
Filed in which year?
Suit is of the year
2020.
2020, my lords.
20.
Yes, my lords. Plaintiff,
ಯಾವತ್ ಬೇಕು ಹೇಳಿ. You're ready to argue, I'll take it up now itself.
it can be taken up any date. my lords.
ಕೊಡಿ.
Now also. my lords.
Suit is filed for what?
Suit for partition in separate position, my lords. Filed by the petitioner, my lords. The impleading applicant, my lords, is a stranger to the family, my lords. It's the plaintiff, plaintiff and defendants, my lords, out of the joint family funds, my lords, have invested the property in a certain firm, my lords, which is the impleading applicant herein, my lords. They say that, my lords, my specific pleading is that out of the joint family funds, my lords, the other properties were purchased by the firm, my lords. Now, this impleading application is filed by the firm, my lords, to get them impleaded in the suit for partition, my lords.
Yeah, what is their claim?
Their claim is that, my lords, the properties at Schedule D, my lords, are the properties purchased by the firm, my lords. I have also not denied that it is purchased, my lord. We say that the amount is been invested by the other joint family, family of plaintiff as well as the defendant number 1 to 9, my lords. And thereby, my lord, the property is purchased. They are the, all are the,
Why shouldn't they come on record if they say that it is purchased by the firm? Why shouldn't they come on record?
The application is allowed by the trial court, my lord. That is what question before this honorable. court.
Other, why shouldn't they come on record is what I'm asking you. So
No,
they claim that this whatever property,
All the plaintiffs and the defendants are the partners of the firm only, my lords.
then the firm also should be heard. The firm also has to be
But
heard.
if at all they have any grievance, my lords, they could appear before the final legal proceedings, before the family.
Correct, Mr. The property is purchased in the name of the firm. Maybe they are partners of the firm. But shouldn't the firm be made a party? Firm is a legal person. Property belongs to the firm. Is it purchased in the name of the firm?
Yes,
Yes,
my
sir.
lords. Copy of the sale was enclosed along with the application, my lords.
So then they are bound to be heard.
That's my contention was that, my lords, they are, first thing, my lords, they are stranger to the family. Second thing, my lords, since the plaintiff as well as the defendants are the partners of the firm, my lords.
Good.
And my specific question is also that, my lords, out of the joint family funds, my lords, the property, the amount was invested in the firm. And thereafter, the properties were purchased, my lords. My entire pleading is on the very same aspect.
No, all those things we established were good. The plaintiff in OS number 58 of 2020 on the file of so-and-so is before this court challenging an order dated so-and-so by which an application filed by the firm na party ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Madila, my lord, subsequently impleading application is filed, my
ಅವರೇ
lord, that is
impleading
allowed.
ಅವರೇ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಸ್ವಾಮಿ ಈಗ. Firm was,
Impleading application ಹಾಕಿದ್ Govardhan Finance.
ಅವರೇ that is the firm.
That he was the impleading applicant, my lord, due to oversight, I was not made them as a party.
ಏನು ಮಾಹಿತಿ? By a partnership firm to come on record was allowed. Next part. The suit in OS number 58 of 2020 was filed for partition and separate possession.
Claiming 1/6 share. my lords. Claiming 1/6 share, my lords, page number 34, my lords.
Partition separate possession of his 1/6 share
Please.
in the suit schedule properties.
Schedule A, B, and C. C and D, my lords.
Whether in the plain they mentioned about this Govardhan Finance.
Yes, my lords, I have mentioned, my lords. At page,
Next, full stop. The plaintiff inter-alia contended that the defendant number 2 taking undue advantage of certain
para 14, my lords.
Taking undue advantage of certain situations has started asserting that house which was allotted to his share, he became a partner of Govardhan Finance and its sister concern. And out of the income earned from the income earned from the business of Govardhan Finance, he went on purchasing the properties in the name of his wife and sons. It was also contended that defendant number 2 with the sole intention had created a false partition deed of the year 1989. And the business was shown to be that of a proprietary concern. Though the businesses and the properties that stood in the name of the defendant number 2, his wife, his sons and daughters, were all joint family businesses. Full stop. The suit was contested by the defendant number 2, who denied that the suit properties were properties of the joint family. Based on these contentions, the suit was set down for trial. Later, an application was filed by Govardhan Finance contending that the suit A, B, C, and D properties were all purchased by the firm
Only D, my lords. Next,
Only D, na?
Only schedule D.
Schedule D properties.
Suit D properties were purchased by the firm in its name. Therefore, the said property was not available for being partitioned. And thus desired to come on record in the partition, in the suit, so as to non-suit the plaintiff in so far as it related to the Schedule D properties. The application was contested by the plaintiff, claimed that the firm had no right or locus standi to claim that the Schedule D properties were purchased by the firm. Next para. The trial court, after perusing a sale deed enclosed along with the application filed by the firm under Order 1 Rule 10(2), held that the firm was interested in the D Schedule properties, and therefore any decree that may be passed concerning the Schedule D properties would cast a cloud on the title of the firm, and therefore the firm was entitled to come on record so as to non-suit the plaintiffs, so as to contest the claim of the plaintiff, So being agreed with the said order, the plaintiff is before this court. Next, for the learned counsel for the plaintiff contends that the Schedule D properties were all purchased out of the nucleus of the joint family, and therefore the Schedule D properties was available for partition, notwithstanding the fact that the same was purchased in the name of the firm. Full stop. However, the learned counsel for the firm submitted, whom do you represent?
Proposed as a different number 10.
ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
On last date of hearing, my lord, application
We
was
filed
allowed-
impleading application, your lord.
And they have come on record as response number 10.
That is non-amendment.
However, the learned counsel for the respondent number 10 submits that it is indisputable that Schedule D properties were purchased in the name of the firm, which not only comprised of the defendant number 2, but various other partners,
Yes, sir.
various other partners who are not members of the family of the plaintiff. Full stop. He therefore contends that the firm was entitled to come on record and contest the claim of the plaintiff that he was entitled for a share in the D Schedule. Next para. It is right, TRITE, it is right that in a suit for partition, the members of a family would alone be arrayed as parties, as non-family members would be in no position to assist the court answering the issues that may be framed, such as whether the plaintiffs and defendants constitute members of a joint family, and whether the suit properties were properties of the joint family, and whether the plaintiff or any defendants are entitled for a share therein. Full stop. However, if a property that does not belong to the joint family is sought to be proceeded against, the rightful owner of the said property is entitled to come on record in the said suit only for the limited purpose of contesting the claim that the property does not belong to the family, and thereby non-suit the plaintiff insofar as that property is concerned. Full stop. Therefore, full stop. In the instant case, the respondent number 10 is a partnership firm duly registered, and the partners of the firm are not members of the family.
They are members
Some
of
of
the
the
family. They are members of the family.
All of them,
Yes, ma'am.
all of them.
All
All of them are members of the family.
Your Lordships, I have no, it is stated that Your Lordships depend number two.
Why don't you guys look at the application, mister?
Yeah, in the application, Your Lordships,
There is some mention about some 9 partners.
yes.
Para 3 of the
9 partners and
9 partners minutes. In
Yeah.
para
Partners of the firm, all the partners of the firm are not members of the family, joint family. If that be so, if that be so, and if the Schedule D properties stand in the name of the firm, which is an independent entity entitled to sue and be sued in its name, can come on record and contest the claim of the plaintiff that the Schedule D properties are not available for partition as it belongs to the firm. Full stop. There is no error in the trial court permitting the respondent number 10 to come on record and contest the claim of the plaintiff insofar as Schedule D properties are concerned. Hence, the petition lacks merit and is dismissed. Yes.
please. I may permitted to carry out the amendment.
Amendment.
Please.
File code amendment.
Please, oblige minutes.
Mr. Biradar.
Take the, during course of the day, take the process.
Yes, suit, sir.
2011.
11. Kodi. Yen facts on here.
The fact is that the injunction under 39 rule 192 against the defendant to order restraining them to not to interfering in the agricultural land. They not filed any appeal or not. During the plaintiff made a complaint to the concerned police station. Concerned police did not take any action to implement the order of the order passed by the trial court. Therefore, I filed an application before the trial court to directing to concerned authority, police authority to implement that. That IMA came to be rejected trial court.
What is the stage of the suit?
Now it is the stage of the evidence.
Issue frame model. Issues 11/3/2025.
And suit is for what?
Suit for declaration and injunction.
Declaration, injunction.
Injunction.
What is the suit property?
It is agricultural land.
Appeal Akilwa.
Hakila, they are not filed any appeal. They are not challenging the order of the I number 1 and 2 under order 39. The not implemented the order. The trial court will be taken into not taken into consideration. My application came to be rejected. Therefore, I will come to that court to seeking the implemented the order of the. Meanwhile, I will be take the notice to the counsel appearing on in trial court. Since the suit is pending, because of they are representing the advocate and filed the written statement and contest the suit.
Cool. 1 week time is granted to pay process to issue notice to the unserved respondents. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondent number
1, 3, 6, 8, and 9.
1, 2, 3, 4, 5, 6, 7, 8, and 9. AG is directed to accept notice for respondent number 10 to 12. Sachin Mahajan,
Number 15, Sachin Mahajan.
Krishneshwar,
That will be taken.
suit is filed in 23.
20.
1 week time is granted to do the needful. Madam Manisha Tale. Notice, please wait. Ganesh Kalaburagi. Is issued to the number 8 to 16 is refused. Hence notice to the said respondents is held to be served. Similarly, notice issued to the respondent number 17 is not claimed. The address of the respondent number 17 mentioned in the cause title of this writ petition corresponds with this address mentioned before the trial court. Hence, notice to the respondent number 7 is held sufficient. Office is directed to show their respective names in the cause list as served. Yes. ಅದ್ ನೋಡ್ಬೇಕು ನೀವು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂದ್ರೆ ಅಡ್ರೆಸ್ ಟ್ಯಾಲಿ ಆಗುತ್ತಾ ನೋಡಿದೀರಾ? ಯಾಕೆ ನೋಡಿಲ್ಲ? ಎಷ್ಟೆಷ್ಟು ನೀವು ಕಲ್ಸ್ಕೊಡ್ಬೇಕ್ರಿ ನಿಮ್ಗೂನು ಏನ್ ಇಂಪ್ರೂವ್ ಆಗಂಗ್ ಕಾಣಲ್ಲ ನೀವುನು.
Interlocutor application. Number 16, Harshvardhan R. Malipat.
IA 1/24 filing LR application.
Your Lordship, respondent number 2 is deceased in this matter. Your Lordship, we have filed necessary applications.
Respondent number 2.
Respondent number 2 is Malik Sa, son of Qasim Sa Bhagwan.
You are also a defendant. What is the order challenged?
Your Lordship, there was a compromise petition which was being challenged before.
Compromise petition
Please,
is
Lordship.
challenged.
Please, Lordship. Their LRs are necessary parties, Your Lordship.
Yes. IA notice ಹೋಗಿದ್ಯಾ? Notice ಹೋಗಿದ್ಯಾ ಇಲ್ಲ? Issue notice on IA 1, 2, 3 of 24. One application is enough, Mr. Why do you file 3 applications? Have you not seen the latest circular? One application for all 3 is enough.
Please, Lordship.
One for condonation, one for filing.
I'll follow.
ಬೇಕಾಗಿಲ್ಲ. One
Please,
application is enough.
Grateful.
Number 17, Ganesh Subhash Chandra Kalaburagi.
Lord,
Ganesh Subhash Chandra.
please, my lord, in this present petition, my lord, the petitioner is entitled for another, my lord, 2, my lord, additional attempts in terms of the, my lord, notification dated 14/8/2024 and 19/12/2024.
Yeah, what is the direction that you have sought for?
My lord, he has sought for revaluation and, my lord, answer sheet. But my lord, he could have, my lord, made use of the availability, my lord, facility given to the students immediately after examination within 5 days, my lord,
But he
which has
says that
not
he has
been.
paid the fees.
Pardon, Your Lordship?
You already paid the fees for this.
Yes, Your Lordship.
What,
I have paid the fees, Your Lordship. So the only request now which I am making is with regard to revaluation, Your Lordship.
Revaluation.
Lord, as per the norms, my lord, 5 days within he should
Regular
apply
students-
for. From the date of result, my lord, 11, my lord, 12/7/2024, my lord, soft copy, that is, my lord, result of the sheet sent to the college and soft copy sent to the, my lord, principal college, 11th July. And from that, my lord, date, he could have applied within 5 days, my lord,
For revaluation.
for revaluation. Lord.
They have not accepted. In fact, the petitioner student has went to the university also, Your Lordship, for applying revaluation.
Could have sent it by RPAD. You could have come to this court.
With regard to fees and all, they assured that, Your Lordship, the revaluation will be accepted.
I thought now that you have paid the fees, you take the examination.
If it could be, Your Lordship, if he clears his subjects in the revaluation, Your Lordship, he is not required to appear for another
You
exam.
must have come to the court, mister.
That's true, Your Lordship.
Then revaluation cannot be done just for the asking.
Yes.
If it is within time, Your Lordship, it can be done. The results of the present petition student was not declared along with the other students, Your Lordship. In fact, he has to come before this court for seeking.
Was it announced?
In the month of July, it was announced, Your Lordship.
We are in the month of January.
Yes, Your Lordship. In fact, in the previous application itself, Your Lordship, I have sought for revaluation.
Barkul, IA 1/25 is filed by the Learned Counsel for the petitioner, seeking for a direction to the respondents to revalue the answer script of
Your lordships, 8 some 1 subject, your lordships, that
What
is bearing
subject?
code number.
what subject?
I'll,
Revaluation of design and drawing of steel structures
yes, yes,
of which semester?
8th semester.
Of 8th semester. Full stop. It is contended that the petitioner was permitted to take up the examinations of the 8th semester. He claimed that though examinations were held during August, September 23, his results were not announced in time, though the results of other regular students were announced. Full stop. He therefore filed an application seeking for a direction to the respondent number 2 to announce the results of the examination. Accordingly, the respondent number 2 announced the result on 27/6/2024. Accordingly, this court directed the respondent number 2 to announce the results of the petitioner on this court, in terms of the order dated 27/6/2024, directed the respondent number 2 to announce the results. The results were thereafter announced on 11/7,
House.
11/7/2024. The petitioner contends that he had done fairly well in the design and drawing of steel structures. However, he was detained in the subject. Therefore, he has sought for a direction to the respondent number 2 to permit him to apply for revaluation. The said subject. Full stop. The learned counsel for the petitioner reiterated the aforesaid and contended that an opportunity be granted to the petitioner. Next para. The learned counsel for the respondent number 2, on the other hand, submits that the respondent number 2 has granted 2 opportunities.
Lord, 14/8/2024 and 19/12/2020. 2
To
notifications.
clear the subjects at the supplementary examinations scheduled on 14/8/24 and 19/12/24.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವತ್ತು?
Yet to commence. your-
ಅಲ್ಲ, they are the dates of notification, my lord.
ಯಾವತ್ತಿಗಿದೆ ಈಗ?
My lord, exams not yet been announced,
ಇಲ್ಲ,
but filing examination application last date is 6/1/2025.
Two attempts. And that the last date for paying the examination fee for the first attempt is 6/1/25,
6/1/25.
He therefore further submits that the petitioner could have approached the respondent number 2 immediately after announcing the results within 5 days
5 days.
for obtaining a copy of the answer script and also seek revaluation.
Please.
However, the petitioner has slept over his rights and has applied and has sought for revaluation after nearly 5 months, after nearly 6 months from the date of announcing the results. Next para. The learned counsel for the petitioner at this stage submitted that the petitioner has already paid the fees for the first attempt, that is provided by the respondent number 2 to clear the failed subjects. Full stop. Next para. In that view of the matter, full stop. Since the petitioner had failed to avail the opportunity provided by the respondent number 2 for revaluation of the answer script and has approached this court belatedly and at the same time paid the examination fee for the upcoming supplementary examination, it is not prudent to grant any opportunity for the petitioner to seek revaluation. Hence, IA 1/25 is rejected. It is open for the petitioner to file. It is open for the petitioner to face the examinations Supplementary examinations scheduled. Yavaga?
My lord, last date for filing examination application 6/1, my lord. In terms of my lord's order, he may be, my lord, permitted.
ಇಲ್ಲ,
We
he
will
is-
permit him to.
Exam ಇರೋದೇ
Exams, my lord, not yet been announced. 2 attempts are
He
there.
has been issued with all ticket also, your lordship.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
Date.
ಮತ್ತೆಲ್ಲ ಯಾಕೆ ಹೇಳಲ್ಲ ನೀವು? Application
Your lordships, it has been later issued, your lordships. In fact, yesterday I received the
ಏನಮಾಯ್ತು?
copy.
ಈಗ ಹಾಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಎಕ್ಸಾಮಿನೇಷನ್.
ಇಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗೋಗಿರೋದೇ ಇರ್ಬೇಕು ಸ್ವಾಮಿ.
21
ಯಾಕಂದ್ರೆ I do not have, my lord, further instruction.
21/1/2025.
ಇಲ್ಲ, that is the date of issuance of all ticket, your lordships. Exam has not yet commenced, your lordship.
ಅದೇ not yet been even declared also, date of examination. The date of examination not yet declared.
Examination fees and is accepted. All ticket has been issued. It is the issuance of all ticket date, your lordships, 21/1/2025.
21/1 ಇಲ್ಲಿ right hand side, my lord, top 21/1/2025.
ನೋಡ್ರಿ, admission ticket for BE Silver Jubilee Special Examination January 25 ಅಂತಿದೆ.
25.
So examination January 25 ಆಗ್ಬೇಕಲ್ವಾ?
30th ಗೆ ಇದೆ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, ಆದ್ರೆ ಪೋಸ್ಟ್ಪೋನ್ ಆಗ್ತಾ ಇದಾವೆ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್.
The dates not yet been announced.
ಆಯ್ತು. Supplementary examination. Full stop. Yes.
Lord, immediate.
6/1/25 ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು. You not mentioned about paying.
ಇಲ್ಲ,
the
6/9 ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ interim direction apply.
That was on 6/1. By
Yes,
which time you already paid the fees.
your lordship, later they accepted my fees. Considering the application which has been filed by the petitioner.
Next.
Please, much.
Annaraya.
Number 18.
I pay for the petitioner, my lord. My lord, we have produced the documents to show, my lord, that the notice, my lord, under form number 2, my lord, has been served on the petitioner, my lord, in item number 18, my lord, on 19/12/2024, my lord. And the meeting for no confidence, my lord, was scheduled on 3/1/2025. That makes it, my lord, 14 days, my lord.
Yes, government.
No, my lord. They have themselves, they have written 19/12 ಸ್ವೀಕರಿಸಿದ್ದೇನೆ.
ಆಯ್ತು, ನಿಮ್ ಪ್ರಕಾರ ಹೇಳಿ ಯಾವತ್ತು ಅಂತ. What is there to show?
On same day, my lord, produced on 17/12, it has served, my lord.
The document that I am producing, my lord, it also bears the signature of the BDO, my lord. I don't know how they are saying that there are other documents.
Yeah, but why will it come to the PDO?
It should not have, my lord, but the BDO has served it. Your lordship will see there is a signature.
That is right.
The
but why
PDO.
should-
Now, as per your lordship's new latest order, my lord, BDO should not step in at all. It is the entire duty of AC.
ಸಂತೋಷ್ ನೋಡ್ರಿ, ಕೊಡ್ರಿ ಅವ್ರು. ಇವಾಗ ಮೀಟಿಂಗ್ ಆಗೋಗಿದೆಯಲ್ಲ?
No confidence is passed, my lord.
It is passed.
Yes,
No
my
confidence is passed.
ಎಲ್ಲಿ ಮೀಟಿಂಗ್ ನೋಟಿಸ್ ನೋಡಿ.
But as per postal track member, petitioner has
ಫಸ್ಟ್
issued.
ಆಫ್ ಆಲ್ ಪೋಸ್ಟ್ ಮುಖಾಂತರ ಬಂತ, ಖುದ್ದಾಗ್ ಬಂತ ಅಂತ ಹೇಳಿ.
First it person.
My lord, and summons as well as postal, both they are sending.
Postal I have received on 21st. The second document I have produced.
Stand summons they'll serve.
When
then
did you receive? By hand ಯಾವಾಗ ಸರ್ವ್ ಆಯ್ತು?
On same day it has served.
Yes, Mr.
19.
Postal track my lord, petitioner has issued on 21/12.
That is okay. By hand ಕೊಟ್ಟಿರೋದು ಅದೇ.
By hand.
19th, my lord.
Page number 1, my lord, I have produced now.
There are
Issued
two
on
things.
19/12.
ಒಂದು ಪೋಸ್ಟಲ್ ಕಳ್ಸಿದ್ರೆ, ಒಂದು ಬೈ ಹ್ಯಾಂಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೋಸ್ಟಲ್ ಕಳ್ಸಿರೋದು 19 ಬಂದಿರ್ಬೋದೇನೋ ಬೈ ಹ್ಯಾಂಡ್ ಕೊಟ್ಟಿರೋದು ಯಾವ
21. Postal ಕಳ್ಸಿರೋದು 21 ಸರ್ವ್ ಆಗಿದೆ. By hand served on 19th. And it is also signed by the BDO. It is not only
Why
my
did you
signature.
not sign it on the acknowledgement given by
No,
you?
it is signed, but it is the notice itself. On the notice itself, I have signed. If your lordship sees, ದಿನಾಂಕ 19/12
There is some
24
document in the file of the assistant commissioner which shows that you have acknowledged the receipt of the notice, but you have not affixed the date.
Lord,
You not
on-
affix the date. Now, if you have affixed the date now on this notice which is placed before the court, which has to be believed?
Very well, my lord. If they are filing an affidavit that they have served on 17th itself, but they may do so.
No, they
They have not
produced-
filed an affidavit till today.
I have produced.
They have placed on record an acknowledgement given by you, which does not bear the date.
But I cannot put it across better than this, my lord, that I am showing an acknowledgement, my lord, which is countersigned by the BDO, which says 19th.
ಇದ್ಯಾವ್ದ್ರಿ ಇದು ನೋಡ್ರಿ ಇದು ಕೊಡ್ರಿ ಇದು. Who appears for the Panchayat?
My lords, I am for the respondent number 4, my lords.
Yes, why did you sign this notice, mister?
My lords, that petition papers and everything is not yet received, my lords. Instructions I sought for instructions, my lord, not yet received.
You sought for instructions. When will you get instructions?
But my lords, the petition papers also not received by me.
No, we'll issue a warrant to this fellow, yaru, Panchayat Development Officer. If he does not come and give you instructions.
I have informed my lords, but petition copies no serve ಮಾಡಿರ್ಲಿಲ್ಲ, that's why.
Why don't you serve a copy to him?
Wakalat, I have written a letter, my lords, papers and wakalat I had to receive.
Copy ಯಾಕ್ರಿ serve ಮಾಡಿಲ್ಲ ಹಣರಾಯ?
Yes, but.
Why you not serve the copy? Huh?
ಯಾವ ಕಾಪಿ?
ಯಾವ ಕಾಪಿ ಅಂದ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿ ರೀ. ಪಂಚಾಯತಿಗೆ ಅಡ್ವೊಕೇಟ್ ರತ್ನ ಶಿವಯೋಗಿ ಮಟ್ಟಿಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? Why you not serve the copy of the petition?
PDO.
Copy ಕೊಟ್ಬಿಡಿ. When will you get instructions, mister?
My lords, 3 to 4 days.
Monday, Tuesday, my lord.
Huh?
Monday or Tuesday, my lord.
Monday,
I will
Thursday.
3-4 days working days I need, my lords, at least.
3-4 days.
Working days, my lords. Thursday, sir.
LBC ಯಾವತ್ರಿ ಬರೋದು? ಗುರುವಾರ.
Please, my lords. Thursday, I will.
Mister, hand over the copy today itself. ಇಲ್ಲಾಂದ್ರೆ I'll dismiss the petition for not complying with the order.
Lord, in 18.1,
What is 18.1?
the same thing, Lord, but another, this is a different Panchayat. This is Rampuram Panchayat. Idralli, the notice is dated 16/12, served on 2012, by post on 23/12, my lord.
No, my lord.
And my lord, your lordship will see in the document, page number 5. It is their document. While serving, they have taken a photograph, which clearly shows it is served on 19/12, my lord. 19/12 and 20/12.
It's served on 2012.
2012, my lord.
My lord, kindly go through memo, my lord. Page number 8, my lord. In Panchanama, they had clearly mentioned that 16/12/24 ನೋಟಿಸ್ಗಳನ್ನು ಜಾರಿ ಮಾಡಲು ಹೋದಾಗ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರು ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ಅವರು ನೋಟಿಸ್ ಪಡೆಯಲು ನಿರಾಕರಿಸಿದ್ದು ಕಾರಣ ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು she has refused on 16/12, my lord. Subsequently, they have made Panchanama on 19/12. 16/12, it is deemed served, my lord, because she has refused, my lord. Taking into consideration 16/12, It is within 15 days, my lord.
What do the rules say regarding service of notice?
Lord, rules, my lord, provide for service by hand also, my lord,
And also by affixture.
affixture.
Delivering or tendering the said notice to such member not found by leaving such notice at his last known place or some within government to some adult member by registered post by putting such notice on some conspicuous part of the house, if any, in which the member is known to have last resided or carried on business within the. What is there to show that you were there in the Panchayat on that day? On 16th?
Lord, I can file an affidavit.
Affidavit against
No,
affidavit.
because they are giving, Lord, they are saying that I refused, my lord. If I had refused, my lord, you have seen the rules, my lord. They should have affixed it or given to somebody else. My lord, now I am showing, my lord, a document where I have signed it and also their own photograph, which shows 1912. Page 5, my lord, of the additional documents that were handed over just now, my lord.
This
Yes,
with some photographs.
yes, my lord. It is the photograph that they have taken while serving me.
Yes, my lord. It is at the time of Panchanama, a photograph has taken. Panchanama, it is clearly mentioned that she has refused to take notice. That's
Where
why
is 16
Panchanama was
Panchanama?
conducted on 1912.
Page number 5,
5 and 6, my lord. There are two petitioners. One is served on 19th, one is served on 20th.
Please read, what is that?
Lord, it only says, Lord, if your lordship sees latitude, longitude, then elevation, accuracy, and time, my lord. On 2012, that is 2024 at 11 o'clock.
I don't see that. Where is that?
Lord, at the bottom, my lord.
2112.
No, 2012, 2024 at 11:04. In the photograph, my lord.
So who are these? Who is the one who is receiving this notice?
My lord, this second one is, my lord, the first petitioner, my lord. Nourajan.
Noorjan.
Nourajan. No, sorry. This is Anil Dodmani, my lord. One is by Noorjan Nadaf, and another one is Anil Dodmani.
The second photograph is Yaro.
Anil Dodmani.
1912 is Noor Jahan, 2812 is Santosh. Anil Kumar, ma'am. President and Vice President.
Vice President.
So 19 and 20.
Yes, ma'am.
19.
Yavat is the notice? What is the date of the notice?
Date of notice is 1612.
1612. Served on
And
1912 and 2012.
2012. Meeting is on 2/1.
2/1.
Yes, it will be 11 and 12 days.
13 days aguttallri.
My lord, because she is refused to take notice on 1612, my lord. Panchanama, it is conducted, page number 8, my lord.
Now, what is it you are giving in this photograph to him? You photograph him.
Yes, my lord, later subsequent, she has refused going. Panchanama, they have conducted, my lord.
No, but then where's the need for you to serve the notice again? Nodidira?
I am not.
If you have already affix the notice on the outer wall of his house, where was the need for you to issue one more notice to him?
Anil Kumar.
This is not of Anil.
This is Anil Kumar. I have seen Noorjahan, Anil Kumar, I have not seen.
What do you want? We'll keep this also on Thursday.
Yes, ma'am.
This petition on Thursday.
Yes. Then, sir,
Item 19, also, my lord. Item 19 is also similar.
No,
It
my
is
lords,
simply-
19,
I appear, my lords. It is not similar, my lords. On the earlier round of litigation, I have filed impeding application, my lords. In the earlier round of litigation, they had filed writ petition challenging the same notice, my lords, that got
Not the
disposed
same
of.
notice, it was a different notice. Please be clear.
Today, what is the latest notice?
Latest notice is dated 13/12/2024.
Ah,
In earlier petition, my lord, what was challenged was an earlier notice dated. I'll tell your lordships.
anyway, that has become
14
academic now.
That
Yes,
is 14/11/2024. And they were given permission, liberty, my lord, to re-serve the notice. They have served the second notice. That is what is in challenge now.
Yavat servagiddu.
This is served, my lord, on 19/11/2024. It is at page 22 of the petition.
19/12/24.
19/12. I'm sorry, it's
19 or 18?
Lord, I think there is a mistake. Your lordship may have it on Thursday itself, my lord, because it says 1911 here. I think they have given the earlier.
For a moment, my lordship may kindly see my impeding application, the order attached to it.
Hmm.
First paragraph. The notice dated 13/12/24
Hmm.
that was challenged in the writ petition number 203944 or 24 before, and that has become infructuous, my lord, before my lordship on 15 January 2025.
That was
Now, my
recalled.
lords,
That was recalled.
and there now, my lords, lordship may kindly see the main prayer in this petition.
This is 203/944.
Let her argue.
Issue writ of mandamus or writ of directing the respondents not to initiate any proceedings till the tenure of completion till 5 years period.
ಅವ್ರು ಹೇಳಿದ್ರೆ ಆಗುತ್ತಾ ಅದು?
My lordship may now kindly turn to the interim prayer. Pass an interim order staying further operation execution of impugned notice issued by the fourth respondent initiated the proceedings for a no confidence motion on 18/1/2025.
Hmm.
That is at page number 31, Annexure F.
Yes.
This is election notice in persons of the no confidence motion which was successfully concluded.
Yes, when was this notice served?
What they say, my lords, they do not challenge this Annexure F for want of clear 15 days or 7 days. They say this no confidence motion which was successfully concluded, it was based upon a notice dated 13/12/24, which doesn't satisfy the clear 15 days notice, my lord, that has already been challenged and that has been concluded as infructuous.
Correct. Where is the challenge to this notice dated 9/1/25?
It is not.
9/1/25 is, my lord, is the subsequent thing, is the notice for, my lord, re-election of, my lord, Adhyaksha and Upadhyaksha.
Hmm.
Lord, so the notice which is challenged, my lord, is 13/12/2024, my lord, in WP number 203944, which is the
Yes.
writ petition which is which is before your lordship. And she is
Disposed
saying that has been
Disposed
disposed
of,
of
my
as
lords.
infructuous.
No, it is already disposed of.
If it is disposed of, it is listed today, my lord, before your lordship.
Illi.
Item 19.
No, item 19 is 200151 of 25. 200151 of 25.
It is as simple as that. 20151 doesn't challenge any of the notices based on the grounds on which the notices are.
Lord, I'm sorry, my lord, petition that is given to me is 203944.
Oh, it's all kichdi ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಅನ್ನರಾಯ.
Already I have given 200,150, but
You ask him to argue something and you have given him something else. 200151 is not given to you, is it?
Not given to me, my lord. I'm sorry.
ಕೊಟ್ಟಿದ್ದೀವಿ ಮಲ್ಲ ಬಟ್ ಅವ್ರಿಗೆ ಏನೋ ಕನ್ಫ್ಯೂಸ್ ಆಗಿದೆ.
ಅವ್ರಿಗೆ
ಇಲ್ಲ,
ಕನ್ಫ್ಯೂಷನ್
ನನ್ನ
ಆಗಿದೆ,
ಹತ್ರ
ನಿಮ್ಗೆ
ಇದೆ
ಕನ್ಫ್ಯೂಷನ್ ಆಗಿದೆ ಅಂತಾರೆ ನೋಡಿ.
There are 3 read petition ಅಲ್ಲ, ಅದು ಅರ್ಲಿಯರ್ ಒಂದು ಹಾಕೋದಿತ್ತು, ಅದರಲ್ಲಿ ಯಾವ್ದು ಕನ್ಫ್ಯೂಸ್ ಮಾಡಿಕೊಂಡಿದ್ದಾರ
ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮಿಸ್ಟರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್.
Lord, please have it on Thursday, my lord.
ಫಸ್ಟ್
Take it.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ, ಅವ್ರು ಕಳಿಸಿದ್ರು ಅಂದ್ರೆ ನೋಡ್ಲಿ. ಸುಮ್ಮನೆ ಎಲೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಸ್ಟಾಲ್ ಆಗಿದೆ. And already elections were to be held on 18/1.
If this order dated 15 January 2025 is allowed to remain,
Yes, my
then
lord.
what is wrong in holding in elections to the
Correct,
post
correct.
of
Lord, my lord, when the file is not with me, I will not make submission, my lord. Your lordship may pass orders.
Tomorrow 20, it may be passed on.
Passover? Shall I pass it over?
No, my lord, your lordship may pass order, because that order, my lord, seems to have been
That's
passed in my presence only. That day there was some confusion in 203944. Your lordship passed the order saying that it has become infructuous. That
That's
they should ask for recall of that order, my lord. Unless that is done, this fresh writ petition cannot be made.
The petitioner has sought for a writ in the nature of mandamus to direct the respondents not to initiate any proceeding under the Karnataka Panchayat Raj bracket motion of no confidence. Karnataka Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha rules 1994. The petitioners have also sought for a writ in the petitioner has also sought for a writ in the nature of prohibition to direct the respondents not to take any further steps till the disposal of this petition. Next para. The petitioner contends that she was elected as a president of the Panchayat, of the Gram Panchayat, Honnali village. On president or vice president of Honnali on 1/8/2023. Full stop. A notice was issued by the members in form number 1 expressing lack of confidence in the petitioner, consequent to which the respondent number 3 issued a notice dated 13/12/2024 proposing to hold a meeting of the members of the Panchayat on on 30th of December 2024. The petitioner contends that the said notice ಅದೇನಾಯ್ತು ನೋಟಿಸ್ ಅದು 30th that was stayed.
Included. No conflict. 13/12 was a notice. And meeting should be
Yes.
supposed to be, that is concluded successfully.
It's concluded.
The petitioner contends that the said notice was in clear violation of Rule 3(2) of the Rules 1994, as the copy of the notice was served upon her only on 19/12/2024. Full stop. Later, the respondent number 4, respondent number 2, by an order dated 8/1/2025, Next, F is some Taluk Panchayat. Later, the respondent number, there's a respondent number 2 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Later, the respondent number 4 issued a notice dated 9/1/2025 convening a meeting
On 18/1.
in the convening a meeting of the members to elect suitable
Upadhyaksh. Upadhyaksh.
convening meeting on 18/1/2025 to elect a Upadhyaksha. The petitioner is therefore before this court challenging the said order, said the proceedings taken out by the respondent number 4. Next para. The learned senior counsel for the petitioner contends that the no confidence motion was the no confidence motion taken out against the petitioner was not in accordance with the rules in 1994, and therefore the subsequent proceeding to elect a vice president is illegal and the same deserves to be set at naught. Full stop. However, the learned counsel for the respondent number,
Impleading responsibilities.
learned counsel for the allow ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ sir. Hello.
Learned counsel for the respondents 1 to 3, learned AGA for the response 1 to 3 submits that the writ petition that a writ petition was filed by the petitioner herein in WP number 203944 of 2024, challenging the notice of no confidence dated 13/12/2024, and that they said writ petition was dismissed as having become infructuous. He therefore contends that the respondent number 4, 2 and 4 are bound to take steps to appoint, to elect the vice president, and therefore the impugned notice is impugned notice is issued by the respondent number 4 regarding convening a meeting, convening an ordinary meeting of the Panchayat to elect a vice president. He therefore contends that there is no error or illegality warranting interference in this writ petition. The learned counsel for the applicants in IA 2 of 25 also voiced the same contentions urged by the learned AGA. Next para. It appears that the petitioner had earlier challenged a notice of no confidence dated 13/12/2024, proposing to hold a meeting of the members of the Panchayat on 30th of December 2024. And since the motion was held successfully, the said writ petition was dismissed as having become infructuous. Therefore, this office of the vice president fell vacant, and the respondents 2 and 4 have taken steps to convene a meeting of the Panchayat to elect the vice president by issuing the impugned notice. Full stop. The petitioner, having faced a no confidence, cannot stall the process of election to the post of vice president, and therefore no orders can be passed in this writ petition to scuttle the scuttle the process of election to the post of vice president. Consequently, this writ petition is dismissed. In view of the dismissal of the writ petition, IA 1 of 25, IA 2 of 25 does not survive for consideration. Yes.
My application should have been allowed, my lord, and amended.
Dismiss.
ಹೇಳಿಲ್ಲ ಅಂತ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಹಾಕಿ.
ನೀವು ಹೇಳಿದ್ರು
ಅದೇ applicant has submits the same ಅಂತ ಇದೆ. If it is allowed, because I am one who is
allowed
contesting for
ಮಾಡಿ
vice
ತಿರ್ಗಾ amendment application ಇದು ಕಾಸ್ಟ್ ಐಟ್ಲು ಬೇಕಾಗಿಲ್ಲ. I've already noted that you have made a submission. Yes, next.
Obliged.
Number 20 RS level.
Better appear for the petitioner. petitioners, my lords, are the members of Fifth Respondent Society, and the election
Petitioners are the members of the Fifth Respondent Society.
yes, my lords.
Ah,
It's a cooperative society, my lords, and elections are slated to be held on 27/1. Now, my lords, they are in the category of non-borrowers membership, my lords, and out of 450 members, my lords, only 25 have been shown as eligible members. Citing section 20B, my lords, holding that we have not attended 3 general body meetings.
hmm.
So, my lords, this honorable court, my lords,
Work. We are also giving orders just like that. AG is directed to accept notice for respondents 1, 2, and 3. Issue emergent notice to respondent number 4 and 5. Since the petitioners contend that their names are excluded from the list of eligible members on the ground that they have failed to attend 3 consecutive meetings of the society. Full stop. They all contend that denying the opportunity to participate in the democratic process is arbitrary and illegal and violates Article 243 and 243 ZO of the Constitution of India. So in view of the aforesaid submission, the pending disposal of this writ petition, the petitioners are permitted to exercise their votes at the election to the managing committee of the respondent number 5 scheduled on 27/1/2025. Full stop. However, they shall not be permitted to contest the elections. Full stop. The votes so cast by the petitioner shall be kept separately and shall not be counted. However, full stop. The returning office, the respondent number 4 shall declare the elections to the, shall declare the results of the election, which shall however be subject to the outcome of this writ petitions. Full stop. Yes, the votes cast by the petitioner shall be counted only after further orders from this court. Yes. Mr. Kaujalgi Chandrakant Lakshman.
Compromise petition is
Compromise petition is allowed.
petitioners and respondent are brothers.
Ah,
Respondent is filed a OS. OS already is compromise in Lok Adalat. ನಮ್ಮನ್ನು ಬಿಟ್ಟೆ ಮಾಡಿದ್ದಾರೆ. ನಾವು
ನಿಮ್ಮನ್ನ?
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅದರಲ್ಲಿ.
You are not a party to the
ಇಲ್ಲ
compromise.
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನಾವು both are brothers.
Parshuram.
Yes, Parshurama and Mahesh is brothers. Respondent. ನಮ್ಮನ್ನು ಬಿಟ್ಟೆ OS ಹಾಕಿ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ಯಾರ ಲೋಕ್ ಅದಾಲತ್.
Mahesh versus Sujata.
ಅವರು ಹಸ್ಬೆಂಡ್ಸ್ ಅವ್ರ ವೈಫ್. ಮಹೇಶನ್ ಹೆಂಡ್ರು ಮಕ್ಕಳು ಅವ್ರು ಮಾಡ್ಕೊಂಡಾರ. ಮಾಡ್ಕೊಂಡಾರ.
Issue emergent notice.
ಅಂಡ್ ರೆಪರ್ ಟು ಲೋಕ್ ಅದಾಲತ್.
Huh?
ರೆಪರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಮಾಡ್ತಾರೆ.
ಏನಕ್ಕೆ ಲೋಕ
ಏನು ಮಾಡ್ತಾರೆ ನಾನು.
ಅಲ್ಲ ಇದು ಲೋಕದ
ಅಲ್ಲ
ಸೆಟಲ್ಮೆಂಟ್
ಲೋಕತ್ನಾಗ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಮತ್ತೆ ಅಲ್ಲಿ ಏನು ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಸರ್, ಈ ಕಾಂಪ್ರಮೈಸ್ ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದೀರಿ.
ಹೌದು ಸರ್.
ಈ ಕಾಂಪ್ರಮೈಸ್ ಸೆಟಲ್ಸೈಡ್ ಆಗ್ಬೇಕಲ್ವಾ? ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಲ್ವಾ?
ಏನೋ ಲೋಕತ್ನಾಗ ಏನೋ ಬರ್ತಾರ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ
ಇದು ಫಸ್ಟ್ ಸೆಟಲ್ಸೈಡ್ ಆದ್ಮೇಲೆ ತಿರ್ಗಿ ಅದು ಹೋಗೋದು.
ಆಯ್ತು.
Issue emergent notice on the writ petition as also on the IA 1/24.
ಡೇಟ್
Process ಕೊಟ್ಬಿಡಿ.
ಹ್ಞೂ ಸರ್. ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಅಲ್ಲಿ ಅಂದ್ರೆ ಇದು ಸೆಟ್ ಆದ್ಮೇಲೆ ಲೋಕತ್ನಾಗ ಹೋಗ್ಬಿಡ್ಬೇಕಾದ್ ನಮ್ಗೆ ಇದಾದ್ಮೇಲೆ
ಸೆಟಲ್ಸೈಡ್ ಆದ್ಮೇಲೆ.
ಹ್ಞೂ ಸರ್.
ಅದಕ್ಕೆ ನೀವು ಪ್ರೋಸೆಸ್ ಕೊಟ್ಬಿಡಿ.
Yes.
ನೋಟಿಸ್ ಹೋಗ್ಲಿ. Yes.
Reading number 22 and number 23, Manavendra Reddy. Here for the petition in this matter, notes. Petitioner number 1. Petitioner is the respond number 2 before the tribunal, MST tribunal, notes. Respond number 1 to 4 had filed a claim petition, my lords. An impleading application was filed by the petitioners, my lords, to implead the owners of the trailers, my lords, in the claim petition, my lords. That has been rejected, my lords. Since, my lords, the tractor and trailer has to be separately insured and separately registered, my lords. The owner of the trailer is not made as a party in the claim
Advantage
petition.
of it, if they're not included the trailer, take
I
advantage.
was taken a specific defense, my lords. I have filed application to be, and because in appeal, they may say that who has precluded the insurance company to not file an application for impleading, my lord. That is why I have made an application, my lords.
You may take out notice, issue emergency notice.
Lords, may I seek interim order, my lords, because the
No,
matter is,
sorry.
the matter, they are proceeding with the matter, my lords. Cross of
Take out
PW.
urgent, in addition, learned counsel for the petitioner is permitted to serve. The learned counsel represents the respondents before the tribunal.
Lords, a date could be fixed, my lords.
Yavat week,
10 days, my lords. I'll serve the copy, my lord.
list on, put it in, 2 weeks, I'll put it. Mr. Bhima Shankar,
Please, oblige.
Bhima Shankar.
My lord, the petitioner's application and order 1 Rule 10 has been rejected.
What is the suit for?
Suit for specific performance of contract. The agreement was executed by my brother. And my lord, I am also the joint owner and I have filed a suit for partition separate portion also. And that suit came to be decreed prior. That suit came to be decreed. I was allotted with a share.
Is it a compromise decree?
No, my lord. It's an judgment.
Tested.
My lord. No, my lord.
Contested.
It's an ex parte judgment. But
Right.
prior to filing up this suit, I have filed suit. And thereafter, to bring out the said facts, my lord, that I have moved an application. And that application was rejected on the ground that I am not the party to the agreement.
No, you can work out your remedy in execution.
That can be done, my lord. But however, my lord, if I am not the necessary party, at least I am the proper party to demarcate the at least share of the, to that extent, my lord, that I am the proper party to the proceedings to bring out the said facts to the court.
Yes.
And my lord, that I am relying one judgment, my lord, that wherein the apex court had held that the joint, the owner can also be arrayed as a party. And on that ground, suit came to be filed by the same, Wendy, that has been dismissed, my lord. May I pass on the judgment for?
No, execution workout ಮಾಡ್ಕೊಳ್ಳಿ. Why should the specific performance to suit be stalled?
My lord, that if I am arrayed as a party, my lord, so my share can also be worked out because the share of my brother, he could purchase, my lord, that to the extent to what he is entitled.
Yes.
Para number 19, my lord, this is also a suit for specific purpose of contract. I mean, the suit filed initially was decreed. Relief of specific performance was granted. Appeal filed and appeal dismissed. And my lord, that the Honorable High Court, my lord, has considered and only the earnest money was the refunded.
Right, but this is an.
Para 19, my lord.
What?
Please. As already discussed here in above, the plaintiff himself has admitted in the plain that suit property joint owned by the defendant, his wife and his 3 sons. A specific objection was also taken by the defendant in his written statement with regard to non-joinder of necessary parties. Since the suit property was jointly owned by the defendant, along with his wife, 3 sons, an effective decree could not have been passed, affecting the rights of the defendant's wife, 3 sons, without impleading them. Even in spite of the defendant taking an objection in that regard, the plaintiff has chosen not to implead the defendant's wife, 3 sons as a party to defendants. Insofar as the reliance placed by Sri Chitnis on the judgment of this court in the case of Kasturi Supra is concerned, the question therein was as to whether person who claims independent title and possession adversely to the title of a vendor could be a necessary party or not. So in this content, this court held that from the above, it is now clear that 2 tests are to be satisfied for determining the question who is necessary party. Tests are that there must be a right of some relief against such party in respect of the controversies involved in the proceedings. No effective decree can be passed in the absence of such party. Now, it can be thus seen that what has been held by the court is that for being necessary party, twin test. And 21 in view of the plaintiff's own admission that suit property was jointly owned by defendant, his wives and 3 sons, no effective decree could have been passed in their absence. No effective decree could have been passed in fact.
No, have you seen section 13 of the specific relief act?
No.
Section 13 ಓದಿದ್ರಾ?
Specific relief act, it pertaining to
specific relief act ಕೊಡ್ರಿ.
even the vendee can also seek for partition section 22 for the specifically fact, if at all it is a joint family property to that extent. Such a relief was not sought by him. If at all in my absence suit is decreed and the relief for specific performance is granted, I could be deprived of the taking up for the
Oh,
property.
where's the question of you being deprived? See, in the execution, in the suit for specific performance, what will be looked into is whether the defendant has executed the agreement or
Agreement,
not,
yes.
and whether the plaintiff is entitled for a sale deed or not. ಇವೆರಡೇ ನೋಡೋದು.
Yes, readiness and willingness. also
ಅದೇ
is
ಅದೇ
asked.
ಅದೆಲ್ಲ ನೋಡ್ತಾರೆ.
But the thing is, my lord, if a suit came to be decreed and relief of specific performance is granted, and in my absence, if the sale deed is executed as per the decree,
Please have a look
Then-
at section 12 of the what is?
the court can direct for farmer the part of to the extent
Part
of
of the agreement.
Yes, my lord. But to
So
bring out
therefore-
fact, my lord, that I need to be added as at least proper party, my lord. that-
Execution ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಿರೋದು.
But
Execution ಅಲ್ಲಿ you file an application section 47,
so my rights could be restricted to the extent of only to submit the true facts before the court.
not necessary. Yeah, how will it help to decide the case?
If the my lord that the defendants or the plaintiff my lord collude each other, and then they should not if they
No.
have not pleaded
Now
anything regarding.
what you can say is,
Yes.
ನನಗೆ ಇಷ್ಟು ಬಂದಿದೆ,
Yes.
ಇದು ಬಿಟ್ಟು ನೀವು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ಬೋದು.
It can be done only in a suit by filing a written statement.
Why? Why not in
The reason to
execution?
bring the said fact before the court only, my lord.
Why not in execution?
My lord, in
Why not
effect, my
in
lord, that only parties to the suit are arrayed as a for the purpose of demarcation of shares.
In
my lord.
execution?
In execution also, my lord. That.
Why? 47 ಇದೆಯಲ್ಲ.
In execution, my lord.
47 ಓದಿ.
Yes, 47 CPC that independent right cannot be. But
So
if then, my lord, if this fact has been brought before the court at the first instance,
No.
the court would be trial court would be in a better position to dispose
Will
of the matter.
unnecessarily delay the suit itself. ಬರ್ಕೊಳ್ಳಿ. Will reserve your right to work out your remedy in the execution.
Please.
ಬರ್ಕೊಳ್ಳಿ. The plaintiff, sorry. An applicant in IA number 3 in OS number 31/2021 on the file of the senior civil judge at Zevargi is before this court challenging an order dated so and so by which his application was rejected. The application to come on record as defendant number 4 in the suit was rejected. Next para. The suit in OS number 31/2021 was filed for specific performance of an agreement of sale purportedly executed by
Brother of the present petitioner, Shivananda.
ಯಾರು?
Brother of the present petitioner, Shivananda, husband of first defendant.
Husband of the first
First
defendant. Husband of the first defendant, who is now deceased. Full stop. The said suit was contested by the defendants. Full stop. In the meanwhile, The petitioner had filed a suit for partition against the husband of the defendant number 1,
Against the present defendants and another brother.
against the against the defendants in OS number 31/2021 and the husband of the defendant number 1 therein.
Uh,
Shivanand ಮೇಲೆ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ, a brother of the brother, another brother of petitioner.
Huh?
There are two brothers.
ಅದು ಶಿವಾನಂದ್ ಮೇಲೆ ಹಾಕಿದ್ರ ಬ್ರದರ್?
Shivana, the wife and another brother Shivshana.
The suit for partition separate possession against the defendant number 1 and his another brother. The said suit resulted in an ex parte decree declaring that the petitioner is entitled to 1/3 share in the suit shall property. Full stop. The petitioner therefore filed an application in OS number 31/2021 to come on record and contest the claim of the plaintiff for specific performance in respect of the entire property. Full stop. The said application was rejected by the trial court in terms of the impugned order on the ground that the petitioner is not a party to the agreement of sale dated 26/9/2017. It also held that there is no need for the petitioner to be brought on record to answer the issues framed in the suit. It held that the question whether the defendants had executed the agreement of sale dated 26/9/2017 and also the question whether plaintiff is entitled for specific performance of the sale agreement are the only questions which arise for consideration in the said suit. And therefore, impleading the petitioner would not help the court in deciding the issues that arise for consideration. Full stop. Being agreed with the said order, the petition is before this court. The learned counsel for the petitioner contends that the petitioner has now a decree of partition of the very same property which is the subject matter of OS number 31/2021, and therefore he is entitled to apply to be impleaded in the suit filed for specific performance.
So as to
And
bring out the true
content-
facts. So as to bring out the true facts.
So as to place on record the decree of his suit for partition and also that he is interested in the suit property. Full stop. Next para. He also relied upon the judgment of the Honorable Apex Court in the case of Ilidan and contended that in similar circumstances, the Honorable Apex Court has permitted a member of the family who is not a signatory to the agreement to be brought on record. Full stop. Next para. I will consider the submissions of the learned counsel for the petitioner and I have also perused the documents enclosed along with the writ petition as well as the judgment of the Apex Court cited by the learned counsel. Next para. In the suit for the petitioner has indeed placed on record a decree of partition of his share in the suit shall properties. A decree of partition in respect of the property which is the subject matter of the specific performance suit in OS number 31/2021. Full stop. The petitioner was not a signatory to the agreement of sale dated 26/9/2017. Full stop. Therefore, as rightly held by the trial court, the petitioner was not entitled to come on record in the suit for specific performance, as the issues that arose for consideration in the said suit was whether the defendants in the suit had executed the agreement and also whether the plaintiff in the suit was entitled for specific performance of the said agreement. Full stop. Even if it is assumed that the petitioner had succeeded in a suit for partition, the defendants partition, comma, the plaintiff would only be entitled to that extent of the share to which the defendants were entitled to and nothing more. Therefore, the petitioner was not really a necessary party for the adjudication of the suit for specific performance. His right, if any, had to be adjudicated in execution proceedings in the event of the suit for specific performance being decreed. Full stop. Therefore, comma, the trial court was right in holding that the defendant, that the petitioner was not a proper and a necessary party to the suit for specific performance. Full stop. The judgment relied upon by the learned counsel for the petitioner is easily distinguishable on facts, as in the said suit, comma, the plaintiff who sought for specific performance specifically pleaded in the plaint that the defendants and other members of the family were owners of the property, and the defendant had also filed a written statement contending that the suit was not maintainable without impleading all the members of the family as parties. In that circumstance, comma, the Honorable Apex Court permitted the applicants to come on record, which was at the instance of the Honorable Apex Court, while considering the contention whether the wife and sons of the defendant in the suit for specific performance were proper or necessary parties, held.
Yes, para 21.
Yes. That the plaintiff did not take steps to implead the defendant's wife and the 3 sons of the defendant as party defendants. Full stop. Therefore, comma, the situation, the fact situation on hand is entirely different. As the suit is yet to be decided, and the question whether plaintiff is entitled for specific performance of the agreement of sale is yet to be considered. In that view of the matter, this petition is disposed of upholding the order passed by the trial court, but reserving liberty of the trial court. However, liberty is reserved to the petitioner herein to contest any execution petition that may be filed by the plaintiff for specific performance of the agreement of sale. If an objection is filed by the petitioner in the execution petition, the same shall be considered in accordance with section 47 of the Code of Civil Procedure.
Grateful one. Kindly, bro. Serial number 20, hand delivery. I was
Yes.
held up in that court.
Correct.
For 25?
Bhima Shankar.
My lord, this matter is connected with another WP, my lord.
ಹೇಳಿ ಯಾವುದು ಭೀಮಾಶಂಕರ್?
WP number 2029914 for 24, my lord.
List this petition along with WP number 2
2029991 of 2024.
25
24.
24 ಯಾವತ್ತು ಬೇಕು?
Any date.
ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್. ಗಣೇಶ್ ನಾಯಕ್.
Number 26, Ganesh Naik.
I'm appearing for the petitioner, my lord. There is no confidence motion, my lord. There is the 15 days clear notice, my lord.
ಯಾವತ್ತು ಹೇಳಿ. What is the date of notice?
My lord, is the date of notice as per the page number 9 annexure A, my lord. The 24/12/2024, my lord.
What should?
The commencing the meeting on, my lord, the 10/1/2025. My lord, the notice was the served on the 26/12/2024, my lord.
ಯಾವತ್ತು? 26
26/12/2024.
26/12/25 ಸರ್ವ್ ಆಗಿದ್ದ?
ಹೌದು.
15 days ಆಗುತ್ತಲ್ಲ ಅಲ್ಲಿಗೆ?
ಆಗಿಲ್ಲ ಸರ್.
15th day.
15th day ಆಗುತ್ತೆ. ಇದಕ್ಕೆ ಒಂದು ಲೆಫ್ಟ್ ಆಗುತ್ತೆ 14th day ಆಗುತ್ತೆ ಸರ್.
ಹೆಂಗಾಗುತ್ತೆ?
My lord, is the
31 days.
31 days, my lord, is the 5 days, my lord, is the hit.
5 days ಅಲ್ಲ ಆಯ್ತು. 10th day, 15th day ಮಾಡಿದಾರಲ್ಲ.
And my lord, the last day, my lord, is the exclude, my lord.
ಕೊಡಿ ರೂಲ್ಸ್ ಕೊಡಿ. ಓದಿ 3 to ಓದಿ.
Please, ma'am. The Assistant Commissioner shall thereafter the convening a meeting for the consideration of the said motion at the office of the Gram Panchayat on the date appointed by him, which shall not be later than the 30 days from the date of on which the notice under section subrule 1 was the delivered to him. He shall give to the member of a notice not less than 15 days, 15 clear days notice of the such meetings in the for number 2.
Yes, sir.
Clear days.
My lord. Notice on served on 24, Tolu. Their contention 26. They have served on 24, Tolu, my lord. I have secured original records, my lord.
ಕೊಡಿ.
On 24, Tolu, it has served. PDO letter has also given, my lord. They are. Another place I have.
ನೀವು ಡೇಟ್ ಹಾಕಿಲ್ವಲ್ರಿ?
ಸ್ವಾಮಿ ನನ್ನ ನೋಟಿಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಹಾಕೊಂಡು ನಮಗೆ
ನೀವು ಹಾಕೋಬಹುದು. 26.
But my lord, as per the fourth respondent, he served on the 26. At least my lord has filed the affidavit. Is the which was date was the mentioned in the notice. We are permitted to withdraw the petition, my lord.
ಇದು ನೋಡಿ ಒಂದ್ಸತಿ.
ಹೌದು. because ಆ ಡೇಟಿಗೆ ಅವ್ರು affidavit ಹಾಕ್ಬಿಟ್ಲ. ಸೊ ನಮಗೆ ಕೊಟ್ಟಿದ್ದು 26 ಗೆ.
ಅಲ್ಲಿ ನೋಡಿ. ಬಸವರಾಜಿಗೇನೋ 24th ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲಿ ಡೇಟ್ ಎಲ್ಲ ಹಾಕಿದಿರಾ?
ನಾವು ಇದ್ರಲ್ಲಿ ಡೇಟ್ ನಮ್ಮ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ ಸರ್.
ನಿಮ್ ಡೇಟ್ ಅಲ್ಲಿ ನೀವು ಹಾಕೋತೀರ.
26 ಅಂತ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ 26 ಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಸರ್ವ್ಡ್ ಬೈ ದಿ PDO, my lord. At least he has filed the affidavit, my lord, which date was the served ಅಂತ.
ನೀವು ಬರ್ಕೊಂಡ್ರದೇನು?
I will give letter of the PDO.
26/2/24 ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ.
ಅದ್ ನೀವು ಬರ್ಕೊಂಡಿರೋದು.
ಇಲ್ಲ, ನಾ ತಗೊಂಡಿರೋ ಡೇಟಿಗೆ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನೀವು ಅಲ್ಲಿ ಡೇಟ್ ಹಾಕ್ಬೇಕಿತ್ತಲ್ಲ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ, ನಮ್ಗೆ ಇದ್ರಲ್ಲೇನೆ ಡೇಟ್ ಬರ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಅವರೇ ಸರ್ವ್ ಮಾಡಿದ್ದು PDOನೇ. PDO ಸರ್ವ್ ಮಾಡಿದ್ದಕ್ಕೆ ಡೇಟ್ ವಿ ಆರ್ ದಿ ಇಶ್ಯೂ, my lord.
ನೀವ್ ಏನಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಾ? ಇದು ನಿಮಗ್
ದಿನಾಂಕ 26/12/2024 ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ ಅಂತ.
ಇದು ನೀವು ಬರ್ಕೊಂಡಿರೋದು. ಇದು ನೀವು ಬರ್ಕೊಂಡಿರೋದು.
ಇಲ್ಲ, ನಮ್ಗೆ ಬರ್ಕೊಂಡು ನಾವು ಸೈಟ್
ಅವ್ರ ಮೇಲೆ ಬರಿಬೇಕಲ್ವಾ?
ಇಲ್ಲ, ಅವ್ರು ಬರ್ಕೊಂಡು ಆದ್ರೆ ಅವರೇ ಬರ್ಕೊಟ್ಟಿರೋ ಸ್ವಾಮಿ. ಅವರು PDOನೇ ಬರ್ದು ಕೊಟ್ಟಿರೋದು.
ಬರ್ಕೊಟ್ಟಿರ್ತಾರೆ.
ನಾವು ತೆಗೆದುಕೊಂಡು ಬರ್ಕೊಂಡಿರ್ತೀವಿ ಅಂತ ಅವರಿಗೆ. ಈಸ್ ನಾಟ್ ಓನ್ಲಿ ದಿ 1 person, my lord. ಇಸ್ ದಿ 4 members ಗೆ 26 ಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
Another letter.
ಹೌದು ಸರ್.
Assistant Commissioner Officer will, somebody from the Assistant Commissioner's office will come to you and give a copy of the notice.
Please, man.
Sign ಮಾಡಪ್ಪ ಅಂತಾರೆ.
ಹೌದು.
ಸೈನ್ ಮಾಡಿದ್ರಿ. ಡೇಟ್ ಹಾಕಿದಿರಾ?
ನಮ್ಮ ಇದ್ರಲ್ಲಿ ಡೇಟ್ ಹಾಕಿ, ಅದರಲ್ಲಿ ಡೇಟ್ ಹಾಕಿಲ್ಲ.
ಗಣೇಶ್ ನಾಯಕ್,
ಪ್ಲೀಸ್,
ನೀವು ಡೇಟ್ ಹಾಕ್ಲಿಲ್ಲ. ನಿಮಗ್ ಕೊಟ್ಟಂತ ನೋಟಿಸ್ ಅಲ್ಲಿ ನೀವ್ ಬರ್ಕೋತೀರಿ 26/12/2020.
ಇದು ನಾವು ಬರ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅವರೇ ಬರೆದು ಎಷ್ಟು ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ ಬರ್ತಿದ್ದಾರೆ.
ಇವಾಗ ಯಾರು ಬರ್ದಿರೋದು ಇದು ಅಂತ
ಇದು ಪಿಡಿಒ, ಅದಕ್ಕೇನೆ ಅವ್ರ ಕಡೆಯಿಂದ ಬೇಕಾದ್ರೆ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡ್ಲಾ ಸ್ವಾಮಿ. ನಾನು 24th ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನಾವು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ ಪೆಟಿಷನ್.
Another letter.
ಅನೇದರ್ ಮೇಲೆ ನೋಡಿದ್ದ 26 ಗೆ ಮಲಡಿದ ದೃಢೀಕರಣ ಪತ್ರ ಅವರು 26 ಸೇಮ್ ಡೇನೆ ಹೋಗಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹತ್ರ.
My lord, PDO has given letter to the assistant commissioner.
The 26.
He has served on 24th ಅಂತ letter ಕೊಟ್ಟಿದ್ದಾನೆ.
ಇಲ್ಲಿ ಓದಿ ಏನ್ ಹೇಳ್ತದೆ? ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು ಉಪಾಧ್ಯಕ್ಷರು ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ನೋಟಿಸ್ ಪತ್ರಗಳನ್ನು ದಿನಾಂಕ 26/12/24 ತಮ್ಮ ಕಚೇರಿ ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಆದರೆ ಅದರಲ್ಲಿ ನಾವು ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ಸದಸ್ಯರುಗಳಿಗೆ ನೋಟಿಸ್ ಪತ್ರ ಕೊಟ್ಟ ದಿನಾಂಕ ಬರ್ತಿರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಈ ದಿನಾಂಕ 15/1/25 ಈ ಸ್ಪಷ್ಟೀಕರಣ ಕೊಟ್ಟಿರುತ್ತೇವೆ. 13 ಜನ ಸದಸ್ಯರಲ್ಲಿ 12 ಜನ ಸದಸ್ಯರು ದಿನಾಂಕ 24/12/24 ನೋಟಿಸ್ ಸ್ವೀಕರಿಸಿರುತ್ತಾರೆ. ಒಬ್ಬರು ಅಂದರೆ ಮಂಜುಶ್ರೀ ಗಂಡ ಭೀಮರಾಜ್ ಅವರು ದಿನಾಂಕ 25/12/24 ನೋಟಿಸ್ ಸ್ವೀಕರಿಸುತ್ತಾರೆ ಎಂದು ಮಾನ್ಯರ ಗಮನಕ್ಕೆ ತರಬಯಸುತ್ತೇನೆ.
It is given by PDO to the assistant commissioner.
PDO ಮಲಡಿದ ರಿಕ್ವೆಸ್ಟ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡಿ.
26 ತಾರೀಕಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಕೊಡಿ. ಗುರುಮಟ್ಕಲ್ ತಾಲೂಕಿನ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ಸೂಚನೆಗೆ ನಮೂನೆ ನೋಟಿಸ್ ಅನ್ನು ಸ್ವೀಕರಿಸಿದ ಪತ್ರ ಸಲ್ಲಿಸಿರುವ ಕುರಿತು ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ಸೂಚನೆಯ ನಮೂನೆ 2 ನೋಟಿಸ್ ಸ್ವೀಕರಿಸಿದ ಪತ್ರವನ್ನು ದೃಢೀಕರಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ ಎಂದು ಸ್ವೀಕೃತವಾದ ಮಾನ್ಯರಲ್ಲಿ ಕೋರಿರುತ್ತೇನೆ. ಇದು ಮಲದ 26/12/2024.
ಅಲ್ಲಲ್ಲ, ಇದು ಇವರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ಗೆ ಕಳಿಸಿರೋದು 26ನೇ ತಾರೀಕು.
26ನೇ ತಾರೀಕು ಕೊಟ್ಟಿದ್ದಾರೆ.
26ನೇ ತಾರೀಕು ಇವ್ರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ಸೂಚನೆ ನಮೂನೆ 2 ನೋಟಿಸ್ ಸ್ವೀಕೃತಿ ಪತ್ರಗಳನ್ನು ದೃಢೀಕರಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಸೊ ಅಲ್ಲಿಗೆ 26ನೇ ತಾರೀಕು
ಸಲ್ಲಿಸಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ಬರೀತಾರೆ ಸ್ವಾಮಿ 24ಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಬರೀತಾರೆ ಅವರು.
ಸೊ ಅಲ್ಲಿಗೆ 26ಕ್ಕೆ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲ, ನನಗೆ ಕೊಟ್ಟರು 26ಕ್ಕೆ ಸರ್ವ್ ಮಾಡಿ ನಾ ಸೇಮ್ ಡೇನೆ ಅವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಅವ್ರು PDO ಬೇಕಿದ್ರೆ ಅಫಿಡವಿಟ್ ಹಾಕಿಬಿಡ್ಲ ಸ್ವಾಮಿ. 24th ಬೇಕಾದ್ರೆ ನಾವು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ.
ಪಂಚಾಯತಿಗೆ ಯಾರು ಅಡ್ವೊಕೇಟ್?
ಮೇಲಡಿದ ಅರುಣ್ ಕುಮಾರ್ ಅಮರ್ಗೊಂಡಪ್ಪ ಸಿದ್ದಿಕ್ಕೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅವರಿಗೆ ಬರುತ್ತೆ.
My lord, letter itself has given PDO to the
Let him file an affidavit that it was served on 24th. ಗಣೇಶ್ ನಾಯಕ್ ಅವ್ರು ಹೇಳ್ತಿದ್ರಲ್ಲ, ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ.
ವಿಡ್ರಾ ಮಾಡ್ಕೊತೀವಿ. ನಾ 26ಗೆ ಕೊಟ್ಟಿರೋದು. We are the 4 members melody served on the 26th.
The Learned Counsel for the petitioner submits that the notice of no confidence motion was served on 26th of December 2000. The notice of no confidence dated 24/12/2024 was served on the petitioner
26/12 melody.
Petitioners on 26/12/2024, and therefore the meeting scheduled on 10/1/2025 was within the 15-day period prescribed under Rule 3(2) of the rules. However, the learned AGA submitted that the notice of no confidence was served on the petitioner on 24/12/2024 itself, and the same is evident from the report of the Panchayat Development Officer dated 26/12/2024. At this stage, the Learned Counsel for the petitioner submitted that if the Panchayat Development Officer files an affidavit admitting that he had served the notice on 24/12/2024, the petitioners would not press this petition.
Please.
Full stop. In that way of the matter, Mr. Arun Kumar Amargundappa, who represents the Taluka Panchayat and Jilla Panchayat of Yadgiri, he is directed to accept notice for respondent number 4 and secure instructions from the respondent number 4 about the date of service of notice of the no confidence motion on the petitioners.
Please.
List on. Copy ಕೊಡಿ ಅವ್ರಿಗೊಂದು. Counsel for the petitioner is directed to serve a complete copy of the writ petition along with all enclosures to Shri Arun Kumar Amargundappa, list on Thursday.
Please.
Thursday. Yeah, cross this.
Number 27, P. Deshmukh.
Yes, sir.
My lord, after filing this one, they have locked my shop.
After filing
This petition, my lord, they have
Ah.
filed this shop and they have not given any reply to my consideration of the application before this petition. My lord, I filed another WP and in that WP they have
No, I don't
directed to
understand.
consider my application, my lord.
Like, yeah,
But without allotment.
Facts of the case.
My lord, this is APMCR, my
You
lord.
might know it in your, you might know the facts of your case very well, but I do not know it. You don't start from the middle, start
No,
from the
no, sir.
beginning.
Previously it was told, that's why.
I don't remember, sir. I'm not expected to remember.
Well, respondent 3 has given shop, 7 number shop to the shopkeeper petitioner, my lord. And they have continuously they are paying the this shall in this one. Rent also continuously they have paid rent and they are since 10 years they are in that shop, my lord. APMC yard, my lord. They are doing a petty business, my lord. And that's why they have given another notice, my lord. I have challenged that notice in the petition before, previously, my lord. Then that petition, they have directed to consider my application for allotting the shop. That's why I given that application, my lord. But they have not considered the application. They have not replied anything, my lord. Again, they given the vacating notice, my lord. And now they have locked my shop.
Yes.
In this also, I am seeking the mandamus for directing the consider my application.
Yes.
Your Lordship, APMC, for APMC that Mallikarjun C. Bus Reddy, sir.
ನೀವು ಅಪೇರ್ ಆಗ್ತಿದಾರಲ್ಲ
ನೀವಿದ್ದೀರಾ?
ಇದಾರಲ್ಲ
I am for.
ಆಯ್ತಾಯ್ತು ಸರ್.
ಮಿಸ್ಟರ್ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
Yes, sir.
ತಗೊಂಡಿದ್ದೀರಿ?
Told it, madam.
AG is directed to accept notice for respondent number 1. Mr.
Sir, the position has been taken, committee has been taken the position, my lord.
Position is taken.
Yes.
ನಿಮ್ಮ ಹೆಸರು ಹೇಳ್ರಿ.
Yes, sir.
What is your name?
M. Sudhakar.
Mr. M. Sudhakar Rao.
Yes.
Sudhakar Rao.
Yes.
Is directed to accept notice for the respondents 2 and 3. Full stop. The learned counsel for the petitioner submits that the petitioner has been in occupation of a in godown ಏನಿದು?
Shop, my lord.
Is in occupation of a shop at the APMC yard, Chittapur.
Yes, Chittapur.
And that the respondents
3, my lord. Respond 3.
and that the respondent number 3 and that the petitioner requested the respondent number 3 to allot the said shop to the petitioner. But the same was not considered, which prompted the petitioner to file WP number 201386 of 2022, which was disposed of in terms of the order dated 12/1/23. The petitioner contends that the respondents number 3, instead of complying with the aforesaid order, has now issued a final notice under the provisions of the Karnataka Public Premises (Eviction of Unauthorized Occupants Act 1974), and has therefore challenged the said notice in this writ petition. He has also sought for a mandamus, writ in the nature of mandamus, to consider the application filed by the petition by him on 8/8/2023 and 6/1/25.
Yes, ma'am.
for conversion of the petitioner's lease and license to lease cum sale agreement.
And similar matters they have
Lease
given
cum
given the
sale.
shop. In similar matters, they have converted, my lord. In this,
He submits that
No, madam.
in many cases, comma, the respondent number 3 has converted the lease cum license to a lease cum sale. And therefore, the respondents cannot take out proceedings against the petitioner under the provisions of the Act 1974. Per contra, the learned counsel for the response 2 and 3 submits that pursuant to the notice impugned in this writ petition, the respondents 2 and 3 have already recovered possession.
Yes, sir. After issue notice, sir.
yes, that notice is
Two
there.
twelve 2024.
Ah,
Accomplish of 55 minutes. They are issue
but
notice.
have you passed a final order?
Yes,
Final
sir.
order ಮಾಡಿದಿರಿ?
No, madam.
Yes, two notice has been given, my lord.
Sir, notice of eviction of unauthorized occupants act ಅಲ್ಲಿ there is a procedure.
Yes.
First to a notice in form A, then form B, then an
Yes,
order.
yes, pass.
It
Yes,
is a-
pass. After
stop.
passing that order, they take a position, my lord.
Of the shop in question. Full stop. In view of the aforesaid statement, comma, the learned counsel for the respondent number 2 and 3 is directed to place on record the entire proceedings initiated against the petitioner under the provisions of the 1974 Act, leading to the recovery of possession of the shop premises from the petitioner. ಯಾವತ್ ಮಾಡ್ತೀರಿ? Documents ಯಾವತ್ ತಂದು ಕೊಡ್ತೀರಿ?
8/1/2024.
Huh?
8/1/2025.
ನೀವು ಖಾಲಿ ಮಾಡಿಸಿರೋ ಪ್ರಕ್ರಿಯೆ
Yes,
ಅದರ ಸಂಬಂಧಪಟ್ಟಂತೆ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನ
yes, I call.
ಯಾವತ್ತು ತಂದು ಕೊಡ್ತೀರಿ?
One second.
ಆಯ್ತು, ಯಾವತ್ತು ಕೊಡ್ತೀರಿ? ಯಾವತ್ತು ಡೇಟ್ ಕೊಡ್ರಿ?
One date ತಗೋರಿ.
ಯಾವ್ದೊಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವತ್ತು ಇರುತ್ತೆ? APMC ಮ್ಯಾಟರ್ಸ್. ಹ್ಮ್ 30ನೇ ತಾರೀಕು ತಂದು ಕೊಡ್ತೀರಿ?
30.
ಲಿಸ್ಟ್ ಆನ್ 30th.
Please,
ಜ್ಯೋತಿ SK.
My lord, for the petitioner, my lord, in this petitioner is challenging the order on application under order 16 rule 6 issuance of the summons to the commissioner CMC for production of document of the khata of the house which is not part of the suit scheduled property, my lord. It's an irrelevant document.
Madam, let me understand you. What
Please.
is a suit form?
Suit for partition, my lord.
Suit is for
Suit is for partition. I'm the defendant number 1. The respondent number 1 has filed for the suit for the partition, my lord, in this.
Yes.
And the suit property is at page 25, my lord. Plaint. Clearly suit property ಒಂದು land ಹೇಳ್ತಾರೆ. But however, after 4 years, they filed the application seeking for direction, issuance of summons to the CMC for production of khata of the houses, which is not part of the suit scheduled property, which is an irrelevant document. Kindly see the page 25, my lord.
25 is the plaint.
Plaint. ಅದರೊಳಗಡೆ suit property page para 2 ದಲ್ಲಿ ಹೇಳ್ತಾರೆ. The subject matter of the suit is non-agriculture land bearing survey number so and so and measuring 6 acre, and this is referred as a suit property.
ಅಲ್ಲ, ಮುಂದಕ್ಕೆ ಓದಿ, ಕ್ಲೀನ್ ಆಗಿ ಓದಿ.
Please. Survey number 139/6 measuring 6 acre 22 gunta situated at Yadgiri Taluk district and Yadgiri, and same is converted into non-agriculture purpose, and number of residential plots have been formed with due approval of the competent authority.
Yes.
This
Where
is
is the application now filed? Where is the application?
Application is at page
Please read. What do they say?
page 37 to 38, my lord. The application.
Yes.
The affidavit, I'll read out the application, my lord. That I have filed the suit against the defendants for the relief of partition and separate possession of our family properties. Since the date of filing of the suit, I am making all efforts to obtain the khata of the above houses, but the municipal authority have neither responded nor given the copies of the house. I have filed an application on 3/3/2020 under the provisions of RTA Act along with the then required charges through postal orders. Thereafter, I have made another application on 13/3/2023. Thereafter, I have filed another application on 2/9/2024. And I am regularly visiting the municipality office with the request to furnish the copies. In turn, the municipal authority neither have an endorsement nor finished the copies and the
Yes.
copies of the family properties.
Now, have you said that the property which is mentioned in the application
Yes, my lord.
are not the properties, are not the houses which are constructed on the suit property?
My counter at page 39, my lord. Objection.
Both.
The documents which are summoning under petition are irrelevant to decide the real dispute between the parties to the suit fully and completely, and the said documents are not necessary to summon in this case. So the application deserves to be dismissed as not maintainable. No material placed before the Honorable Court that the plaintiff has made of efforts to obtain such documents from CMC Yadgiri. Hence, the allegation made in this petition are not sustainable.
Where have you said that the properties which are mentioned in the application are not situate on the suit property? Because in the suit they say
Please.
that this land is converted and sites are formed.
Please.
So therefore, where have you said in your counter that the property numbers or the houses which are mentioned in the application are not situate on the suit property? ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
Oh, there is no specific contention as such taken, but this
Then
paragraph too
at least-
clearly.
No, at least will you make a statement that these properties are not situated on the suit property? If you make,
Yes.
I'll record it.
That's the instruction I have that these houses are not part of that.
Then I'll record it and I'll issue notice to you. But if it is found that these are all situated on the property, then you will be in for trouble. Your client will have to pay through the nose. Please get instructions before you make a statement.
I would rather get clarity on this, my lord.
To learn counsel for the petitioner seeks time to secure instructions whether the properties mentioned by the respondent number 1 in the application filed under order 16 rule 1 are situate on the suit property or not. This list on 31.
Please. Grateful, my lord.
Number 29.
Raise time.
ಯಾಕ್ರಿ ಹೇಳ್ರಿ ಮಾತ್ ಹೇಳ್ರಿ ಏನು? ಫೈಲ್ ತೆಗೀರಿ, ಏನು ಅಂತ ಹೇಳಿ ಫಸ್ಟು. Suit is ಏನಕ್ಕೆ? What is a suit for? Perpetual injunction. Suit property is one house property measuring 30 by 40 feet. What is this application now filed? Injunction application to restrain the defendant from obstructing the suit. Injunction application is granted. Appeal is dismissed. Appeal is dismissed. ಏನು ಹೇಳ್ರಿ ಏನು? What does the plaintiff claim? How did the plaintiff get this property?
Registered sale deed.
Registered sale deed. How did you get it? Do you have any title to this property? Defendant ಗೆ ಈ ಆಸ್ತಿಲಿ ಏನೋ ಹಕ್ಕಿದೆಯಾ?
No, man.
ಮತ್ತೆ what is your right to obstruct then?
Pass on.
Yeah?
Kindly pass on.
Password.
Engineering group, number 30, R.S. Siddhapurkar.
Back to. Rajesh Dodaman.
Food for declaration injunction in respect of landed property. Trial court granted me injunction order. Appellate court has reversed it on the ground that I am not residing in that village.
Suit is property is what?
Land,
Vacant land.
illa, agriculture land.
Other Kali.
31 acres, 15 guntas.
Ah.
Agriculture land.
Hmm.
Survey number 105.
What is your claim? How do you claim this?
My lord, it was earlier belonging to my husband. After his death, I succeeded to the said property.
Ah.
The defendants claim that this land was allotted to them by the Karnataka SC/ST Corporation.
Ah.
No document is produced.
Their statement. Huh? Defendant 7 to 14.
Please.
ಏನು ಹೇಳ್ತಾರೆ?
At page number 27 is the written statement.
Yes.
Para 8. In reply to para 11, it is true that defendants have filed objection for mutation, contending that they are the beneficiaries under SC/ST Corporation of Government of Karnataka, which have given the land to these landless backward class beneficiaries. Said corporation had purchased the suit land in the names of these defendants from one Asha, wife of Pranesh, and not from Anjali alias Asha. This plaintiff came to the court with unclean hands and hiding factual acts.
Yeah, what is this? Refer to some writ petition, some sale date. Page number 28. There's some writ petition.
Howdo?
Illi copy ಇದೆ ಇದು?
ಇಲ್ಲ, copy ಇದ್ದಿರಲಿಲ್ಲ.
202573.
Now verify ಮಾಡಿ. Copy ಇದ್ದಂಗಿಲ್ಲ. ಇದೆ.
ಕೊಡಿ.
They can avail the remedy in accordance with law.
I don't know what is the writ petition. Who has executed sale deeds?
Lord, they say that my husband had another wife. She has executed sale deeds. But the documents are not produced to show that sale deeds are executed. Even assuming that the other wife has executed sale deeds, at least sale deed copies should have been filed. And especially when I am claiming the relief of declaration of title, it is all the more necessary that they should produce some document.
Yeah, 162 of 99 ಬೇರೆ ಇನ್ನೊಂದು suit ಇದೆ.
ಹೌದು. ಅದು it is between the plaintiff and other persons, nothing to do with the suit property. That is in respect of a house property. And that matter is now pending before this honorable court in RSA.
So what they are saying is that the plaintiff in 162 of 1999, she has sold it to the SC/ST Corporation.
Correct. That is now pending before this honorable court in RSA.
Then?
Therefore, what I am suggesting is.
ಏನಾಯ್ತು? OS ಏನಾಯ್ತು ಅದು? 162?
162, it was filed by me, it was decreed, appellate court reversed, and now it is before this honorable. What I would suggest is maintain status quo and direct the trial court to dispose of the suit itself within 2-3 months.
But RFC ಅವೆಲ್ಲ ಕೊಡ್ಬೇಕಲ್ವಾ? ಏನಾಗಿದೆ ಅಂತ without seeing.
ಇದಕ್ಕೇನು ಸಂಬಂಧ ಇಲ್ಲ ಅದು. That is with regard to the house property, not with the landed property.
Correct, ಅದು ನೋಡ್ದೆ ಹೆಂಗ್ ಮಾಡೋದು?
ಆಯ್ತು, ಅದನ್ನು
Purple, the learned counsel for the petitioner is directed to place on record the decree passed in OS number 162 of 1999, RA 12 and 15 of 2007.
ಎರಡು RSA ಇದೆ 200
Suppose ಆಗಿದೆಯಾ?
RSA ಪೆಂಡಿಂಗ್ ಇದೆ. ಅಡ್ಮಿಟ್ ಆಗಿ ಪೆಂಡಿಂಗ್.
List on ಯಾವತ್ತು ಬೇಕು?
Next week, except 29 and 30. Next week, 31st ಬೇಡ. Next week.
Next. 7.
Public.
Number 31, heir brother.
I am appealing for the
Infectious
petition.
order. 19/6/24 it is, suit is disposed of.
It is this.
Disposed
Purpose
for
the
non-prosecution.
for the respondent number 2 to 10 submits that the suit from which the present writ petition arises was disposed of on
19/6/2024.
19/6/2024. This however this is not disputed by the learned counsel for the petitioner. In that view of the matter, this petition is disposed of as having become infructuous. However, the grounds urged in this writ petition is kept open to be urged in any appeal that may be filed by the petitioner against any judgment that is passed in the said suit before the appropriate appellate court.
This is number 32, DP Ambekar.
Lord, I am here for the respond number 5 in this matter, my lord. On the last date of hearing, my lord, I submitted. I will, my lord, what file from the, my lord, office. I, my lord, what file from the office. My lord, it is, so far as, my lord, plot number 6 is concerned, my lord, no documents are there to show that, my lord, they have sent to, my lord, deputy commissioner for approval of the, my lord, plot. And it is informed, my lord, some properties were, my lord, again auctioned. Whether this property is, my lord, auctioned or not, to ascertain that, my lord, I need 1 week time, my lord. I have bought earlier file, but so far it is informed, my lord, so many properties were, my lord, there. And subsequently those properties are auctioned.
So according to you, even this property is also auctioned.
ಅಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದಕ್ಕೆ
There is an interim order, my lords, in this case.
ಅಲ್ಲ 21 my lord, what has happened, my lord, property was auctioned in the year 2016. He started giving representation after 2012. Till 2021 he was kept quiet. In the year
Counsel for
2021
the
he was quiet.
respondent number 5 again seeks time to secure instructions whether about the status of the property which is the subject matter of this petition. List on 31st is Deepak Bharat.
35, and the interim order may kindly be extended.
Interim order granted early extend till the next.
33, Deepak Bharat.
ಅಲ್ಲ next.
Date, specific date ಕೊಟ್ರೆ next week.
Gaurish Kasham.
Now.
ಮತ್ತೆ ಹೇಳಿ.
ಮೊನ್ನೆ ಬಂದಿದ್ದ ಸಮಯ affidavit ready ಇದೆ swearing ಅಂತ ಹೇಳಿ ಇವತ್ತು ಇಸ್ಕೊಂಡಿದ್ದೆ. ಆಫೀಸರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇದಾರಂತೆ. ಅದೊಂದು
ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು?
And if my lord permits, I'll make submission, ma'am.
Well, but without a document, can you make a submission?
Please.
Copy no ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ ನೀವು.
ಇಲ್ಲ, without swearing.
Learned counsel for the respond number 6 again seeks time. List on
Tuesday, ma'am.
Thursday.
Yes.
Tuesday, Wednesday, I mean.
ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ ನೋಡಿ ಬೋರ್ಡ್ ಹಾಕಿದೀವಿ.
6. 6-2. Number 34. Biradar.
Next week I'll be taking, I am not, throat problem.
ಯಾರಿಗೆ?
ನನಗೆ. Next week at any day.
Learned counsel for ಎಷ್ಟನೇ ಸೂಟು?
Suit for pertaining the 2011. 15.
ಚೆನ್ನಾಗಿದೆ ಅದು ಥ್ರೋಟು.
Because of some problem is.
ಐಸ್ ಕ್ರೀಮ್ ತಿಂದ್ರಾ? ಐಸ್ ಕ್ರೀಮ್ ಅಲ್ಲ ಸರ್, ಐಸ್ ಕ್ರೀಮ್ ತಿಂದ್ರಾ ಅಂದೆ.
ತಗೋಬೇಕು.
ತಗೋಬೇಡ್ರಿ.
ತಿಂದಿಲ್ ಸರ್ ಅದು. Because of the weather, due to weather, that infection.
Learned counsel for the petitioner speaks time. List on
31.
31, first week at, please.
35. Anand Patil.
Chandrakala and
Here for
Preeti
the
Patil,
petition.
Shivaya.
Matter has become infectious, my lords.
Hello, Shivanand Patil.
Yes.
The learned counsel for the petitioner submits that the writ petition has become infructuous. The submission is placed on record and the petition is dismissed as having become infructuous. Ganesh Kalaburagi.
Number 36, Ganesh Kalaburagi. One submission, my lord. My lord, they have taken no objection that it is informed, my lord, Nagraj has, they have given file to my lord Nagraj, Nagraj.
A.M. Nagrale. A.M. Nagrale.
AM.
Office, the learned counsel for the respondent number 3 submits that the respondent number 3 has now engaged the services of Sri A.M. Nagrale.
Nagraj.
A.M.
AM Nagraj.
A.M. Nagrale. And his office is directed to show the name of Mr. A.M. Nagrale as the counsel for respondent number 3. The deletion of the name of Mr. C.M. Chaitanya Kumar shall be considered later. List on R.S. Siddhapurkar.
There is an interim order operating.
Interim order of stay granted. Isne suit?
Suit alla samay idu whip jari agide ittu.
Yavado whip.
Whip. Your lordships have heard this matter in part.
List on date.
After 3, your lordships. After 3. 7th.
Appearing for the petitioners in this matter. Yesterday's matter, the LR application, the setting aside abatement and the condonation of delay applications were dismissed.
They are DP Ambedkar.
Yeah, I am formal party, my lords. I have not even filed returns. Corporation.
Good.
I have also filed an application for impleading the LRs as defendants 3 to 8.
Good.
37.
Suit is for declaration and
Suit for
possession.
declaration and possession, my lords.
Who died?
The defendant number 2 died. And the defendant number 2 died on 14/11/2016. Subsequently, on 20th of February 2017, I came to know regarding the death of defendant number 2. And on 23/3/2017, I filed 3 applications for bringing LR, for setting aside abatement, and for condonation of delay in filing the LR.
The plaintiff in OS number 499 of 2014 on the file of so-and-so before this court challenging an order dated so-and-so by which an application filed under order 22 rule 4 applications filed under section 5 of the Limitation Act to set aside the delay, to condone the delay in filing the application to bring the legal heirs of deceased respondent, defendant number 2, and an application for setting aside the abatement of the suit against the LRs of the defendant number 2, and an application to bring the LRs of defendant number 2 were rejected. Next part. The suit in OS number 499 of 2014 was filed for declaration of title, recovery of possession and mandatory injunction. Full stop. The LR's party madila idalli.
No, Lords, LRs are not made part.
What had
Since
happened was,
the-
they first filed application under order 22. That was rejected. All 3 applications were rejected. Thereafter, they filed under 1 Rule 10 to implead the same persons. That was also rejected. Both orders have been challenged.
Cool. The petitioner is also challenged an order dated so-and-so, by which
15/3/20.
an application filed by him under order 1 Rule 10(2) of CPC was rejected. Next part. The suit in OS number so-and-so was filed for declaration of title and recovery of possession and for mandatory injunction. Full stop. The suit was contested by the defendant number 2.
Yes, defendant number 1 and 2.
The suit was contested by the defendant number 1 and 2. Full stop. The death of the defendant number 2 came to the knowledge of the plaintiff on 27/2017, following which an application was filed to bring the legal heirs of the defendant number 2 on 23/3/2017. Full stop. The petitioner therefore filed applications for condonation of delay to filing the application to bring the legal heirs of the defendant number 2 on record, an application for setting aside the abatement of the suit as against the LRs of the defendant number 2, and an application to bring the legal heirs of the defendant number 2. Full stop. The said application was rejected. The said applications were rejected by the trial court in terms of an order dated
Order dated.
so and so, on the
23/3/2000 on the ground that the plaintiff and defendant number 2 are neighbors.
on the ground that the plaintiff and defendant number 2 were neighbors,
And-
and the plaintiff could not have ignored plaintiff on the ground that the plaintiff had notice of the death of the defendant number 2 on 14/11/2016 itself, and that the delay in filing the application was not genuine and bona fide. Full stop. Following the aforesaid order, the plaintiff filed an application under Order 1, Rule 10(2) of CPC to implead the legal heirs of the deceased defendant number 2, which also was dismissed in terms of the order dated so and so. The petitioner is therefore before this court challenging the aforesaid orders. Next paragraph. The learned counsel for the plaintiff petitioner submitted that the death of the defendant number 2 was not informed to the court. Death of the defendant number 2 on 14/11/2016 was not informed to the court. And therefore, the petitioner was not aware of the death of the defendant number 2. He contends that even otherwise, the application was filed in on 23/3/2017. It was delayed by a month and a half. And trial court committed an error in holding that the reason mentioned for condonation of delay was not bona fide and satisfactory. He contends that the cause of action had survived against the legal heirs of the defendant number 2, cause of action for the suit survived against the legal representatives of the defendant number 2. And therefore, it was incumbent upon the court to have allowed the application for condonation of delay in filing the application to bring the legal heirs of defendant number 2 and to set aside the abatement and to implead them. She contends that the petitioner was also entitled to file an application to bring the legal heirs of defendant number 2 against whom the cause of action survived. And therefore, the trial court must have at least allowed the application filed under Order 1, Rule 10(2) of CPC. So next, learned counsel for the defendant number 3. Learned counsel for the defendant number 1 is absent, and therefore this court did not have the benefit of his submissions. Full stop. You actually legal heirs party ಮಾಡಬೇಕಾಗಿತ್ತು ಇದರಲ್ಲಿ. You should have arrayed them also as parties.
I had arrayed the person dead in the cause title and then due to
Yes,
office.
madam, but
I will make them a party.
I'm allowing the petition. Barcode. The learned counsel for the defendant, learned counsel for the respondent number 3 submits that learned counsel for the respondent number 3 submits that he is a formal party in the suit and no relief is sought for against. Ideya?
ಇಲ್ಲ ಏನಿಲ್ಲ because the
Is a formal
marginal
party
land
in
ನಲ್ಲಿ
the
ಇದೆ.
suit. And the dispute is essentially between the plaintiff and the defendants 1 and 2. Next paragraph. The suit is filed for declaration of title, recovery of possession and for mandatory injunction of an immovable property. Full stop. Therefore, the cause of action survived the death of the defendant. Cause of action for the suit survived against the legal heirs of the defendant number 2. And hence, in ordinary circumstances, they were bound to be brought on record. Full stop. The defendant number 2 died on 14/11/2016. And apparently there is no indication whether the death was reported to the court so as to prompt the plaintiff to take steps to bring the legal heirs on record. The plaintiff, on coming to know of the death of the defendant number 2, had filed the application on 23/3/2017. Therefore, the cost shown for not filing the application to bring the legal heirs of the defendant number 2 must have been accepted by the trial court. Full stop. The reasoning of the trial court that the plaintiff and the defendant number 2 were neighbors, and therefore the plaintiff was bound to know the death of the defendant number 2, is an assumption on the part of the trial court. Full stop. If the plaintiff, who is an advocate, knew the death of the defendant number 2, he would have definitely taken steps to bring the legal heirs of defendant number 2 within the time stipulated, as he would be aware that not doing so, but as he would be aware that by not doing so, he would run the risk of getting the entire suit abated. Full stop. In that way of the matter, the impugned order passed by the trial court rejecting the application filed by the plaintiff and order under Section 5 of Limitation Act, Order 22 Rule 9 of CPC and under Order 22 Rule 4 of CPC is set aside, and the said applications are allowed. And the LRs of defendant number 2 are ordered to be brought on record. Full stop. In view of the aforesaid, the order passed by the trial court on IA number so-and-so and Order 1 Rule 10(2) does not warrant any interference.
Obliged.
For 38, Manvendra Reddy.
P. Ambekar.
Yes.
2005 suit.
2005 suit. Defendant's writ petition. Defendant has preferred the writ petition.
Yes, what is the suit for?
Suit for declaration, possession, and mandatory injunction to remove the illegal construction.
How so clearly?
Please.
Let him also have the pleasure of arguing.
Please.
Yes, suit is filed, my lord, with a description of, it is mentioned in para 15, my lord. Page 15, my lord. And it is also a connection to the map, my lord. Originally, my lord.
Either.
The defendant has encroached upon the above said CTS number and had put up a devani for feeding the cattle, which is measuring 8 feet north-south and 4 feet east-west, and also a water tank measuring 4 feet east-west and 4 feet northwest. Side above said CTS number. Thereafter, this area was devani measuring 8 feet and north-south 4 feet. East-west and also a water tank measuring 4 feet east-feet and 4 feet north-south, situated in eastern side of CTS number 87-1A1A2 of ward number 2 of Bijapur is called as suit properties. On the basis, I have filed the written statement immediately in the 2006 itself, denying the measurement, denying the suit property. The trial was commenced. Both the sides have closed their evidence.
Have you said in the statement that you had constructed a house and all the stuff? In statement alli, na mane kattukondiddini. I mean a larger occupation of a larger area anta helidira.
Yes,
Elli helidira?
23.
ಓದಿ.
This defendant is his owner and actual possession of CTS number 87. The defendant has paid tax for CMC Bijapur, and this defendant is in possession of the area measuring 40 into 20 feet and is in enjoyment of a suit property with knowledge of the plaintiff and such possession and enjoyment of property by defendant is peacefully and without the obstruction of anybody, including the plaintiff who claims to be the owner. The plaintiff at no point of time obstructed the defendant Devani and water tank constructed about 10 years back. The plaintiff did not raise any objection to enjoy the property by this defendant which is in his possession. Now, at the time of argument, a court commissioner was appointed.
Now, please tell us,
Come on.
ಇವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, 2113 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. 2113 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳೋದು. ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದೀರಾ ಟು ದಿ IA?
Objection is at 37. The plaintiff filed a suit seeking the relief of declaration that the plaintiff is owner of area shown in MNOP ORST out of CTS number 87 1A 1A2 of Ward 2 of Vijayapura and seeking a vacant possession of the suit property. The defendant has disputed the title of the plaintiff and also the right of the plaintiff to seek possession. The defendant has claimed that this possession is more than MNOP and ORST in his return statement. The same has not been denied by the plaintiff by necessary implication. Thus, the plaintiff, in spite of having knowledge that the construction made by this defendant in his CTS number 87 1A 1A2 of the Ward number 2 of Bijapur, but did not take any steps either to get the property measured or to file a necessary application. The plaintiff, after evidence of the court commissioner, has come with application and after closure of both the sides' evidence, the defendant in his absence of the plaintiff, the defendant constructed the house by encroaching upon extent of feet and changed the nature of the water tank and order up are all false and represented in same is afterthought story. Thus, the further contention taken with application that after disclosure of the evidence before applying the measurement through court commissioner, this defendant constructed a new house shown in the EFGH and changed the existing water tank are all false.
ಮುಂದೆ ಓದಿ ಹೆಂಗೆ?
The further contended that the contention taken in the application after construction of the illegal structure, this defendant applied for appointment of commissioner to collect a favorable evidence in also denied. This defendant from the date of appearance has been asserting that the defendant has been possession of the area. Then what is shown in the plain sketch. Therefore, the commissioner appointed support to the contention of the defendant. The plaintiff, right from the date of presentation of the claim, was very much aware of the plaintiff is not in possession of a 3-inch out of suit property. The property bearing CTS number 87 1A 1A2. The commissioner report reveals the same. Therefore, the plaintiff concocted the story in the narrated in the application to suit the civil design.
Now read this. This is very important. What the next?
Narrated in the application to suit the evil design of the applicant plaintiff. The commissioner report reveals that the defendant was constructed a house property in area measuring 12123 square feet. Such a big house cannot be constructed in a overnight. That too without notice to the plaintiff.
So, Alige, do you admit that the house measuring 2113 square feet exists or not? 2113 ಅಡಿ ಒಂದೇ
ಅವ್ರು ಹೇಳ್ತಾರೆ.
ನೀವೇನ್ ಹೇಳ್ತಿದ್ರಿ? 2113 ಅಡಿ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನೀವ್ ಹೇಳ್ತಿದ್ದೀರಿ. ಯೂಸೆ ಇಷ್ಟು ದೊಡ್ಡ ಮನೆನ ರಾತ್ರೋರಾತ್ರಿ ಕಟ್ಟಕ್ಕಾಗಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳಿದ್ರಿ. 2113 ಅಡಿ ಕಟ್ಟಿದಿರೋ ಕಟ್ಟಿಲ್ವೋ ಅಂತ ಹೇಳಿಲ್ಲ ನೀವು. ವೇರ್ ಹ್ಯಾವ್ ಯು ಸೆಡ್ ಕಟ್ಟಿಲ್ಲ ನಾನು? ನಾನು ಇರೋದೇ
ಅದು-
20/40 ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Plaintiff concocted the story is narrated in the application to suit, he will decide the applicant plaintiff.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು? 2113 ಅಡಿ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಬಿಲ್ಡಿಂಗೇ ಇಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
If that was there, my lord, there is a new cause of action for them.
That is why they have filed an application for amendment of the plaint.
ಈಗೆಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿದೆ, where is their pleading?
Now the
Or they are pleading?
no. Commissioner now says that there is a building which measures 2113 square feet in this property, which you don't dispute. You say ಹೆಂಗ್ ಕಟ್ಟಕ್ಕಾಗತ್ತೆ ಅಂತ. ಕಟ್ಟಿದಿರೋ ಹೇಳ್ತಾ ಇಲ್ಲ ನೀವು. ಕಟ್ಟಿದಿರೋ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಆದ್ರೂ my lord, at what stage they can come up with amendment?
Why not? Sir, this is a suit for declaration of title.
Identity of property ನೇ ಇಲ್ಲಲ್ಲ ಮತ್ತೆ. What is their pleading?
Today,
What is the map, my lord?
ನಿಮ್ದೇನ್ ಟೈಟ್ಲ್ ಇಲ್ಲ.
Huh?
You don't have title to the property.
But I am in
You
possession.
are saying I am in hostile possession.
Adverse possession.
You are saying that you are in hostile possession.
Yes, my lord.
So you don't have title. You don't have title.
But when they,
Why shouldn't he assert his title and claim back possession?
so again, everything will go back.
It will go back.
It is nothing but a fresh suit.
Why not?
What about the admission given in the evidence of the parties?
Take advantage of, see, if there is admission in the,
Yes.
ಏನು evidence ಇದೆ ಹೇಳಿ.
ಮತ್ತೆ on the basis of the pleading, they laid evidence.
ಏನಂತ?
Deposition.
ಏನಂತ admission ಏನಂತ ಇದೆ ಅಂತ ತೋರಿಸಿ. What is the admission?
They have described the property.
ಹೌದು 8 ಅಡಿ 4 ಅಡಿ ಅಂತಿದೆ.
ಅದು ಹೇಳಿದ್ದಾರೆ. ಈಗ ನಾವು if the amendment ಈ ಹೊಸ ಕೇಸೇ ಆಗುತ್ತೆ.
ಹೌದು ಸರ್, ನೀವ್ ಹೇಳ್ಬೇಕಲ್ವಾ 2113.
ಪ್ಲೆಂಟಿಫ್ ಬಂದ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ ಸರ್.
Commissioner has inspected the property.
At his behest.
Commissioner has inspected the at his
At his behest.
ನಿಮ್ಮ on your application he has inspected. ಈ ಪ್ರಾಪರ್ಟಿ 2113 ಅಡಿ ಇದೆ ಅಂತ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Suit when it was filed was only in respect of 8 feet by 4 feet. So ನೀವು ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ ಅಂತ ನೀವ್ ಹೇಳ್ಬೇಕು. ನೀವೆಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಎಲ್ಲಾದ್ರೂ ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಾ?
ನಾನು ಎವಿಡೆನ್ಸ್ ಕಾಪಿ ಇಲ್ಲ, ಇಲ್ಲಿ ಕಮ್ ಟು ಎವಿಡೆನ್ಸ್. ವಾಟ್ ಇಸ್ ಅಡ್ಮಿಷನ್ ಗಿವನ್?
2113 ಅಡಿ ಯಾವಾಗ ಕಟ್ಟಿದೆ ಅಂತ ನೀವು ಹೇಳಿದಿರ ಎಲ್ಲಾದ್ರೂ?
I will see the depositions, my lord, where they admit. If the admission is there, my lord, that
Have
admission.
copies of the deposition.
No, my lord. In fact, my submission, my lord, is suit is of the year 2005. This land, this suit property, it was granted to me by the deputy commissioner. Plaintiff is a Samaj society. It was granted by the deputy commissioner. Defendant has put up some construction. At that time, in the year 2005, when suit was filed, he had only put up those two construction. In fact, in the written statement, he admits that he has put up those two constructions. He does not say there is any other construction other than those. May I just read, my lord? Ade there. Page 23 ಅಲ್ಲಿ para 3 ದಲ್ಲಿ 5th line from the bottom.
ನೋಡಿದೆ.
The plaintiff at no point of an obstacle to the defendant, the Downy and water tank were constructed about 10 years back. Plaintiff did not raise any objection to enjoyment. So only says that at that time only these two structures were existing. He did not disclose anything.
And he also says it was only 40 feet by 20 feet.
Yes, ma'am.
So 800 ಅಡಿ ಪೊಸಿಷನ್ ಇದ್ದೆ ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಿ.
Admit ಮಾಡ್ತಾರೆ. And issue number 3.
2000 ಅಡಿ ಹೆಂಗಾಯ್ತು? 800 ಅಡಿ ಪೊಸಿಷನ್ 2113 ಅಡಿ ಹೆಂಗಾಯ್ತು ಅಂತ ಕೇಳಿದ್ದು.
ಬಟ್ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ ಸರ್.
ನೀವ್ ಹೇಳ್ಬೇಕು. ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್.
Issue number 3 is on him to prove adverse possession.
ಈಗ ನೇಚರ್ ಆಫ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿನೇ ಚೇಂಜ್ ಆಗುತ್ತದಲ್ಲ ಮನೆ.
Sir, it has to change. Even if it changes, the suit for possession is not changed. The suit for possession is not changed. It continues to be a suit for possession. The area which was initially claimed was 8 feet by 4 feet. Now he wants to include it to 2133 square feet. Ashte change agirodu because you have constructed during the pendency of the suit.
What steps you have taken, my lord, if I pendency of the suit?
ಅದನ್ನ ನೀವೆಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೇಳ್ಕೊಳ್ರಿ.
ಅದೇ ಎವಿಡೆನ್ಸ್ ನಾನು ನೋಡಿ ಯಾಕಂದ್ರೆ
Cross
if
exam-
they say during the, can I construct my lord in during the pendency of the suit?
Why not?
And the defendant plaintiff can keep silent for construction.
Why not, sir? Why not? Why not?
It's a.
Sir, we are in a court of law.
My lord,
We are in a court of law. Why it can't happen? ಯಾರ್ದೋ
he could have been,
ಸ್ವಲ್ಪ ತಡ್ರಿ, ಯಾರ್ದೋ ಪ್ರಾಪರ್ಟಿ. ಇವಾಗ ನೀವು ಚಿಂಚೋಳಿಲಿ ಏನೋ ಜಮೀನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಆ ಚಿಂಚೋಳಿಗೆ ನೀವು ವರ್ಷಕ್ಕೊಂದ್ಸತಿ ಹೋಗ್ತೀರಾ. ವರ್ಷಕ್ಕೊಂದ್ಸತಿ ಒಂದ್ ವರ್ಷದಲ್ಲಿ ಮನೆ ಕಟ್ಬಿಟ್ರ. ವೈ ನಾಟ್ ಅಂದ್ರೆ
ಆಗಿಲ್ಲಲ್ಲ, there is not their case.
ಹೇಳ್ತಿರೋದು.
ಆಗಿರ್ಬೇಕು evidence ಅಂತ.
ಹಾಗಿರ್ಬೇಕು ಅಂತಲ್ಲ. There are possibilities. It can happen.
But in the present case.
ಈಗ ನೋಡಿ, ಅಲ್ಲೊಂದು ಬೇವಿನ ಮರ ಇದೆ ಇಲ್ಲಿ. ನೀವು ಹೈಕೋರ್ಟಿನ ಆ ಕಡೆ ಹೋದ್ರೆ, when I first came, it was only one neem tree. Now, the people have put cloth around the tree. ಕೆಳಗಡೆ ಒಂದು ದೇವಸ್ಥಾನ ಆಗಿದೆ. ಬೇವಿನ ಮರದ ಕೆಳಗಡೆ ಒಂದು ದೇವಸ್ಥಾನ ಆಗಿದೆ. How did it happen ಅಂದ್ರೆ ಹೈಕೋರ್ಟ್ ಹೆಂಗಾಯ್ತು ಅಂದ್ರೆ ಆಯ್ಕುತ್ತೆ. We also do not take any steps because it's not affecting us. ಸುಮ್ಮನೆ
ಇಲ್ಲಿ private litigations are before the parties, my lord. ಹಾಗಿದ್ದಾಗ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನೀವು ಹೇಳೋ ಪ್ರಕಾರ why ಅಂತಂದ್ರೆ it's possible.
Under these circumstances,
Why not, sir?
when the parties are head on, they are agitating the matter.
ನೋಡಿ, ನೀವು ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ನುಗ್ಗಿದ್ರಿ ಫಸ್ಟ್. ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್, ಮೈಂಡ್ ಯು. ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಅಂದ್ರೆ ನಿಮ್ದು ಅಲ್ದಿರೋ ಪ್ರಾಪರ್ಟಿ ನೀವು ನುಗ್ಗಿದಿರಿ. ಹೌ ಡಿಡ್ ಯು ಡೂ ಇಟ್? ನಿಮ್ದು ಅಲ್ವಲ್ಲ ಪ್ರಾಪರ್ಟಿ, ಹೆಂಗೋ ಕೂತ್ರಿ ಅಲ್ಲಿ? ಹೆಂಗೋ ಕೂತ್ರಿ ಅಲ್ಲಿ? ಇಟ್ ಈಸ್ ಪಾಸಿಬಲ್ ಬಿಕಾಸ್ ಹಿ ಡಿಡ್ ನಾಟ್ ಆಸ್ಕ್ ಯು. ನೀವು ಒಕ್ಕೂತ್ರಿ, ಅವ್ರು ಕೇಳಿಲ್ಲ, ನೀವು ಒಕ್ಕೂತ್ರಿ. ಫಸ್ಟ್ ಏನ್ ಮಾಡಿದ್ರಿ? ದನ ಕಟ್ಟಿದ್ರಿ, ಒಂದು ಕೊಟ್ಟಿಗೆ ಕಟ್ಟಿದ್ರಿ, ಒಂದು ಟ್ಯಾಂಕ್ ಕಟ್ಟಿದ್ರಿ, ಯಾರು ಬರ್ಲಿಲ್ಲ, ಒಂದ್ ಮನೆ ಕಟ್ಟಿದ್ರಿ. ವೈ ನಾಟ್ ಅಂದ್ರೆ ಇಟ್ ಕ್ಯಾನ್. ಇಫ್ ನೋಬಡಿ ಆಸ್ಕ್ಸ್, ವೈ ನಾಟ್?
ಇಲ್ಲ, ನಂದೇನು the stage of in a so advanced stage.
If you want to look into any evidence, you do it. ಯಾವತ್ ಬೇಕು ಹೇಳಿ, ಗುರುವಾರ ಇಡ್ತೀನಿ, I'll close it on ಗುರುವಾರ. 2005 ಸೂಟ್
Idea.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
First working day.
Next Friday.
ಫಸ್ಟ್ ವರ್ಕಿಂಗ್
Working
ಡೇ.
day.
ಫಸ್ಟ್
Friday CPC day, Mallards.
ಫ್ರೈಡೇದಾ?
Friday CPC.
ಫ್ರೈಡೇ ಹಾಕ್ಬೋದಾ? ಫ್ರೈಡೇ.
39 Armagowda K. Patil.
Brahmagowda Patil.
Interim order.
Interim order granted arrears extend till the next date of hearing.
The petitioner had challenged the
Srinath Shravan Kumar.
Respondent. Challenge the annexure E, my lordship, which is in a civil imprisonment on the count of alleged disobedience of court order, my lordship.
Sure, E na?
Yes, my lord. Annexure E is the order, which is under challenge, my lordship.
Yes.
The respondent herein has filed OS suit 249 of 2017 for the suit of perpetual injunction. And same has been decreed, my lordship. Thereafter, a regular appeal has been preferred and also it has been dismissed and confirmed the trial court order, my lordship. Thereafter, the respondent herein filed the execution petition under section 21 rule 11, my lordship. Under it is at annexure C, my lordship. It is at ink page number 47. The suit is for the perpetual injunction, my lordship. Kindly peruse the ink page number 47, my lordship.
47.
Yes, my lord. This is the petition filed before the execution court. In para, against the JDR approached the concerned police, that is Brahmpur PS, along with complaint. The concerned IO refused to DHR request that matter is for civil nature, therefore no authority to support the DH. The DHR requested before the Honorable Court to give the direction and assistance of the Brahmpur PS to help vacate the suit scheduled properties to the JDRs
and also for necessary to please to appoint court commissioner.
What is the suit property?
Suit property is the house, my lordship.
Ah.
That, and it is in the entire petition, they were nowhere state that when they came and entered in their home or anything, my lordship. That it is from since beginning, the petitioner was in the position, my lordship. And kindly appreciate the objection which I have filed, my lordship, and thereafter another application. It is in a petition, the complaint filed before the police commissioner, where is also he seeks the direction to hand over the vacant position, my lordship.
Already Nim Tandane,
Yes, my lordship. There are brothers.
your father, defend number 2 and grandfather defends 1 and 3.
Yes, ma'am.
They sold it to plaintiff.
Yes, ma'am.
Correct.
Yes, ma'am.
Plaintiff yarinda purchase ಮಾಡಿದ property.
From third person, it has been pleaded, it has been from one.
Plaintiff has purchased the property from whom?
In the year 1992 from one Chandrasekhar, son of Virana Desai, my lord.
Yes, it's nowhere, it's not the family person.
They claim that it has purchased
It's
in the name, in my name, it's a family property.
From
and
the
now-
family property.
But
the
suit
brothers,
is decreed,
it's
RA
between-
is confirmed, my lords.
It is between the brothers, my lordship.
He violated the terms and he was sent to the civil prison, my lords, committed.
Or whether you have filed any suit for claiming your share, whether, have you filed any suit?
No, now they are preparing to file it, my lordship. Initially, it was in some other hand.
You
That
hand over
very, my contention is that when the suit is for the interference, restraining the interference by the petitioner. Here, it's nowhere case that they have and so and so date, I went there, I dispossessed from them. It's nothing has been pleaded. Only they came forward and said that request to hand over the.
Right or wrong, there is a judgment of perpetual injunction.
Yes, my lord. Yes,
Correct.
definitely.
How you went there? Have you pleaded anywhere in the suit?
Yes, my lord.
Suit ಅಲ್ಲಿ,
Yes, my lord.
suit ಅಲ್ಲಿ ನಾನ್ ಪೊಸಿಷನ್ ಇದೀನಿ ಅಂತ ಕೇಳಿದಿರಾ?
That is, there is a
Suit ಅಲ್ಲಿ
specific-
ಹೇಳಿದಿರಾ?
Yes, my lord. ಹೇಳಿದ್ದೇವೆ, but the court holds that it is a registered document in the name of the respondent, hence it is presumed that they are in the possession.
So
But
therefore,
my specific case is that I am in the position is
so
also.
therefore the court has disbelieved your case.
Yes, my lord. Only count that register sale deed is in their favor only because of that.
If it's a house property.
Yes, my lord.
See, if it was a vacant site, there was a presumption that, you also had some right in the property.
Yes, ma'am.
But this is a house.
Yes, my house property.
This is a house, he has sold the house to him.
Yes, my lord.
So ಮನೆ ಸೇಲ್ ಮಾಡುವಾಗ ಪೊಸಿಷನ್ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? ಸಿಂಬಾಲಿಕ್ ಪೊಸಿಷನ್ ಕೊಡ್ತಾರಾ?
True, my lord, but my contention is that it is an out of income of the income, but he is
Yeah,
the
yeah,
younger
yeah.
brother of the petitioners, and hence it has been purchased,
you
and we
claim
are in
your
common
property.
position of that.
You claim your property, you file a suit for partition, do whatever you want, but don't disturb his possession.
No, I'm not disturbing. my
ಯಾವ
lordship.
ಖಾಲಿ ಮಾಡ್ತೀರಿ ಹೇಳಿ, otherwise I am going to confirm this order.
1 week time, maybe I will keep present all the parties present, my lordship. If
ಯಾವಾಗ ಖಾಲಿ ಮಾಡ್ತೀರಿ ಹೇಳಿ, are you in
week.
possession or not?
Yes, my lord.
You are in possession.
But they are interfering and after that.
There is nothing has been pleaded. How interfere? When
ಯಾವಾಗ-
I have
I mean, there is
came
an
there,
order that.
nothing has been pleaded, my
Either
lordship.
you give a statement that you will work out your remedy by filing a suit for partition, I will not disturb his possession, ಮಾಡ್ಕೊಳ್ಳಿ. ಒಂದ್ಸತಿ ಇಂಜಂಕ್ಷನ್ ಡಿಕ್ರಿ ಇದ್ಮೇಲೆ you can't come in the way. You can't say that ಇಂಜಂಕ್ಷನ್ ಕೊಡ್ರಿ ನಾನು ಹೋಗಿ ನುಗ್ತೀನಿ ಅಂತ ನೀವು ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ sir.
Second appeal
ಹೇಳಕ್ಕೆ ಒಳಗೆ
To
ಹಾಕ್ಸ್ತೀವಿ.
the extent of civil imprisonment, there must be disobedience. The court has ordered 30 days civil imprisonment here.
The fact that you are still claiming, to be in possession of the property despite an injunction decree shows you are interfering with his possession.
In one angle, it is true, my lord. In actually, if it has been considered, there must be pleadings when on
Forget
which date,
pleadings.
which date I have come there, there must be in imprisonment, when the passing of imprisonment is there.
Talking of pleadings in the High Court, You're talking of pleadings in the High Court.
But
Court is here to do
base-
substantial
first
justice.
The imprisonment has been, order has been ordered, my lordship, and opportunity is also not given to
I'll give you
plead
1
my
week's
evidence.
time. I'll give you 1 week's time. You decide what you want to do. If you want to face the consequences, please face it.
Even
Then
though I
you
have
say-
not given an opportunity to lead evidence on substantiate evidence, I have the documents, I have the electrical bills since from beginning.
Court decree set aside agilla.
Yes, yes.
Injunction decree set aside agilla. You should get the fruits of the decree, full stop. Decree ತಕೊಂಡುನು ಕೋರ್ಟಿಗೆ ಬಂದು ಲಾಯರ್ ನಿಟ್ಟು ಫೀಸ್ ಕೊಟ್ಟು ಡಿಗ್ರಿ ತಗೊಂಡು ಏನು ಉಪಯೋಗ ಆಗಿಲ್ಲ ಅಂದ್ರೆ
That only position with the petitioner itself from beginning
This
itself.
is why they say in Kannada, ಗೆದ್ದವನು ಸೋತ ಸೋತವನು ಸತ್ತ ಅಂತ. ಗೆದ್ದವನು ಸೋತ ಸೋತವನು ಸತ್ತ. He has won a case against you. So you should get the benefit of the decree.
I will discuss 1 week. I will keep them present and it is them, it's a
Next Friday, my
dispute between the brothers, my lordship. If it's, there is an amicable settlement.
ಯಾರು ಇವರು ಬ್ರದರ್ ಏನಾ?
Yes, my lord. Brother is
ಸೆಟಲ್ಮೆಂಟ್
a
ಇದು ಆಗಿದೆ
brother.
ಸ್ವಾಮಿ. ಮೀಡಿಯೇಷನ್ ಫೇಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ
ಐ ಆಮ್ ಆಲ್ಸೋ ಬ್ರದರ್.
Brother,
ಮೈ ಬ್ರದರ್ಸ್
own brothers. Dispute is between own brothers.
ಮೀಡಿಯೇಷನ್
ಯಾವತ್ತು
Their brother.
ಯಾವತ್ತು ಹೇಳಿ?
Any week, in this week, any day.
ಹಾ.
If they both
ಶ್ರವಣ್
present
ಕುಮಾರ್ ಏನೋ
and-
ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ನೋಡಿ.
ನಾನು ಪಾರ್ಟಿ ಒಂದ್ಸತಿ ಮಿಡಿಯೇಷನ್ ಹೋಗಿತ್ತು ಸ್ವಾಮಿ. ಐ ವಿಲ್ ಕೀಪ್ ಮೈ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್. ತಾವೇ ಹೇಳಿ.
Keep
ಐ ವಿಲ್ ಕೀಪ್
Both
ದೆಮ್
parties,
ಪ್ರೆಸೆಂಟ್.
keep them present, Barkul. Learned counsel for the petitioner seeks time. Having regard to the fact that the dispute is between the brothers and between the nephew of the respondent, comma, the parties are directed to be present to work out a settlement.
Yes.
Based on
31st.
all of the matters at 2:30.
Interim order may be. Interim order,
49 and 52 kindly next week.
my lord. Interim order is there. Can
There
you-
is an
Interim order extended till the next year.
46 on the next
39 ಅಲ್ಲಿ.
45 next week.
40 ಮಧ್ಯಾಹ್ನ
45.
ಕೆಲಸ ಮಾಡಂಗಿಲ್ಲ?
My lord,
ಮಧ್ಯಾಹ್ನ ಮಾಡಲ್ಲ ಕೆಲಸ?
my brothers some.
ಹಾ?
Next week any date, Papa.
ಯಾವ್ದು ಬೇಕೋ ತಗೊಳ್ಳಿ. Which all, please mention to the court of.
Please.
Interim orders are there. All interim orders will be extended.
Sir.
ಮೇಡಮ್ 44 ಅಂತ ನೋಡ್ರಿ. 1ನೇ ತಾರೀಕು ಕೊಡ್ರಿ. 1, 2. Entry ಮಾಡ್ರಿ.
57.
Entry ಮಾಡಿಲ್ಲ. Entry ಮಾಡಿಲ್ಲ. ಇದೆ ರೀ.
Hello, court officer.
49, sir, 49. Next week.
Entry ಮಾಡಿದ್ರೆ ಕೊಡ್ತಾರೆ.
49, interim order ಇದೆ, extension.
ಹೋಗ್ರಿ
Next week.
42.
Yes, second.
ನಿಮ್ದು ಆಯ್ತು 57 ರೀ.
ಸಚಿನ್ ಸರ್ ಯಾವತ್ತು ಇಟ್ಸ್ಕೊಲಿಕತ್ತೀರ?
57.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ ಸರ್?
ನೀವು ಯಾವಾಗ?
Madam, serial number 55, madam.
55, sir.
Madam, I have taken instruction.
Sir.
I have taken instruction, my lord. Madam, in 55, if it is posted on Wednesday,
Sir.
Wednesday, it is a KSRTC day, madam.
ಹೌದು.
I have clearly stated, instructed them, the order has to go. But today I am having some inconvenience.
ಆಯ್ತು ಸರ್, ಆಯ್ತು. ಸರ್ ನಿಮ್ಮ ಹೆಸರು ತೋರ್ಸಕ್ಕೆ ಹೇಳ್ಬಿಡಿ ಸರ್.
I will ಹೇಳ್ತೀನಿ.
ಸರ್.
55 ಕೋರ್ಟ್ ಆಫೀಸ್ 55 ನನ್ನ ಹೆಸರು ತೋರಿಸಿಲ್ಲ, ಅದ್ರೊಳಗೆ ನನ್ನ ಹೆಸರು ತೋರಿಸ್ಬೇಕು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಬುಧವಾರ ಇಡ್ಸ್ಕೊಳ್ರಿ. ಹಾ, ಬುಧವಾರ ನನ್ನ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ಅದ್ರೊಳಗ. ಮೇಡಮ್, ಜಸ್ಟ್ ಟೆಲ್ ಚಂದ್ರಕಾಂತ್ ಮೇಡಮ್ ಟು ಇನ್ಫಾರ್ಮ್ ಮಿ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ.
ಆಯ್ತು ಸರ್, ಹೇಳ್ತೇನೆ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಹಾಕಿದ್ರಲ್ಲ
ಬುಧವಾರ ಹಾಕಿದ್ರೆ
ಬುಧವಾರ ಇದೆ.
ಹಾ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
21st.
ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಹೇಳ್ತಾರ ಅವ್ರು.
31st ಇರ್ಬೇಕು.
ನೆಕ್ಸ್ಟ್ ಫೆಬ್ರವರಿ 21st.
ಫೆಬ್ರವರಿ 21st sir.
ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಇರಬೇಕು. ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಅದೇನು?
Sir, serial number
ವರ್ಕಿಂಗ್
52.
ಡೇ ಇದ್ದಂಗೆ ಇರೋದು.
Serial
Court
number
officer?
50, February 2nd week the court.
52 ನಾ?
ಹಾ.
52 7/2.
ಹಾ.
Interim
NCPC
ಹಾ, ಇದ್ರಿ extend ಮಾಡ್ರಿ. ನಾವ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೇನ್ರಿ ಸರ್.
ಯಾವತ್ತ?
Serial number 51. Serial number 50.
ಸ್ಯಾಟರ್ಡೆ, ನೆಕ್ಸ್ಟ್ ಸ್ಯಾಟರ್ಡೆ ವರ್ಕಿಂಗ್ ಡೇ ಅದ, ಅದಕ್ಕೆ ಇಡ್ತಾರೆ.
ಯಾವ್ದು?
42 ಇಲ್ಲ ಸರ್ ನಮ್ ಫಸ್ಟ್.
ಎಲ್ಲ ತಗೊಂಡ್ರು ಮತ್ತೆ 1000
ಸರ್ 44 ಒಂದು 7th ಇಡ್ರಿ ಸರ್. ಸರ್
ಆರಾಮಿಲ್ಲ
45 ಎಷ್ಟು? 30 ಸರ್ 45 ನಿಮ್ಗೆ
7th 7ನೇ ತಾರೀಕು.
7/2.
Sir,
ಸರ್
serial
ನಮ್ದು
number
44
50.
7ನೇ 44 7th ಗೆ ಲೈಕ್ಲಿಹುಡ್ ಆಫ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಅವೈಲೇಬಲ್ 7 ನಾ ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೆ.
Number 50 infectious ಆಗಿದೆ.
ಇಂಟ್ರೆಕ್ಟಿವ್ ಸರ್.
ಹ್ಮ್.
ಆಮೇಲೆ ಹೇಳ್ರಿ 2ವರೆಗೆ.
ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬೇಡ್ರಿ.
ಹೇಳ್ರಿ ಸುಮ್ಮನೆ ಯಾಕೆ ಇಟ್ಕೋತೀರಿ?
ಮತ್ತೆ ಬರಲ್ರಿ.
ನಮ್ದು 7th ಗೆ 42.
ಡೇಟ್ ಕೊಟ್ಬೇಡ್ರಿ ಸರ್.
ಅವ್ರು ಅಪ್ರೋಚ್ ಮಾಡತ್ತಾರ ಬೇಡ.
ಒಂದ್ ಡೇಟ್.
Court officer?
ಹಾ ಹೇಳ್ರಿ
Court
madam.
officer?
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್, ಇದು 55ನೇ ಮ್ಯಾಟ್ರ್ ಬುಧವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ರ?
44 7 42 ಹಾಕೈತಿ ಸರ್. ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ.
ಹಲೋ
ಹಾ ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ.
ಸರ್, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. 55ನೇ ಮ್ಯಾಟರ್ ಏನಾಯ್ತು ಸರ್?
55 ಏನೂ ಆಗಿಲ್ಲ ಮೇಡಮ್.
ಹಲೋ
55 29ಕ್ಕೆ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್
ಹಾ.
29.
ಅದೇ ಅವ್ರ ಹೆಸರು ತೋರ್ಸ್ಬೇಕಾಯ್ತು ಸರ್, ದೀಪಕ್ ಅವ್ರ ಹೆಸರು.
ಆಯ್ತು.
ಆಯ್ತು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
51 ಯಾಕ್ರಿ ಮಧ್ಯಾಹ್ನ ಏನ್ ಮಾಡೋದು?
ಸರ್ ಮಧ್ಯಾಹ್ನ ಬರಲ್ರಿ.
ಬರ್ಬೇಕು.
ಸರ್ 50 ಒಂದ್ ಡೇಟ್ ಕೊಟ್ಬೇಡ್ರಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
50
ಹಾ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದ್ ಡೇಟ್ ಕೊಟ್ಬೇಡ್ರಿ. ಇನ್ಫ್ರಾಕ್ಟ್
ಆಲ್ರೆಡಿ ತಗೊಂಡಾರ ಮುಂಜಾನೆ 30.
ಮುಂಜಾನೆ ತಗೊಂಡ್ರಿ.
ಲಾಗಿನ್ ಆಗ್ಬೇಕಲ್ಲ ಇವನ್ ಒಂದ್ಸತಿ ಕೈ ಕೊಟ್ಟು ಸಾಯ್ತಾವಲ್ಲ ಮೆಕ್ಕಮ ಮೆಂಟಲ್ ನಾನು ಅಲ್ಲ ಕೂತ್ಕೊಂಡ್ರೆ
సైన్ పడదు సీల్ ఉన్నారు కదా
ನಾರಾಯಣ ಸಾರ್ ಅಲ್ವಾ ಅಲ್ಲ ಹಿಮಾಚಲ್ ಪ್ರದೇಶ್
ಬಂದ್ರು
ಯಾರು? Anita B. List after service of, list after receipt
For
of
the petitioner, my lord.
the report of the police regarding service of notice to R3. Is there any interim order?
Yes, my lord.
Interim order granted release extend to the next date of hearing. Prabhakar L. Shetty.
ಇದು ನಾವು
Prabhakar L. Shetty.
ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ಲ.
There is no representation for the petitioner. List on date put. Oh, even dictating order system is there. Good.
ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ಲ.
I appear for the petitioner, my lord, in this case.
Abhinay Vaiti. Abhinay Vaiti.
My lord, I appear for the respondent in this case, my lord.
Yes.
The matter was listed for dictation of orders. Abhinay Vaiti was the petitioner.
Is there
I
any
could not hear
settlement?
the case number, so if it is the same, I'm not sure, my lords.
Pardon?
It is WP number 21162 of 2022, my lords.
Correct. This is regarding that arbitration, right?
Arbitration matter, yes, my lords.
Yes. Workout, but code is file code. The petitioner, ಇದು serial 3 ನಲ್ಲಿ, the petitioner sought a review of the order dated so and so passed by this court for 21632 of 2022. Writ petition was disposed of. Sorry, the writ petition was dismissed. Sorry, ಅದಕ್ಕೆ ಮುಂಚೆ the petitioner herein had challenged a charge sheet issued by the respondent number 2. And this court, in terms of the order dated 18/9/2024, dismissed the writ petition. Reserving liberty to the petitioner to urge the grounds in a petition that may be filed challenging the order that may be passed with the disciplinary authority. Full stop. The petitioner has contended that this court has not considered the ground urged by the petitioner in the writ petition that the presenting officer had no role to play in the framing of the articles of charge, and that he was also the disciplinary authority. Full stop. In support of full stop, he contends that the person who issued the articles of charge was also the person who presented the case before the inquiry officer. Huh?
And also a witness.
And also a witness at the inquiry. He has also submitted documents to contend that the person who issued the charge sheet is also one of the members of the board of the respondent, before whom the inquiry report is placed for consideration. Therefore, he contends that the impugned order, the order dated so and so passed by this court, dismissing the writ petition by holding that there is no material to establish that the presenting officer had any role to establish that the presenting officer had any role in framing the articles of charge, and that he was the disciplinary authority. Full stop. Per contra, the learned counsel for the respondent submits that the respondent is headed by the managing director, who is managing director, and he is the only person who has to institute the inquiry and also conduct the inquiry and adduce evidence. He therefore submits that due to this necessity, the respondent was forced to issue the articles of charge and also adduce evidence at the inquiry. Full stop. Insofar as the contention of the learned counsel for the petitioner that the report of the inquiry is tabled before the board of the respondent, where the person where the managing director of the respondent is a member, he submits that it is a board which takes a decision and not the managing director. Therefore, he contends that there is no error in the procedure adopted for framing the articles of charge and also in conduct of the inquiry. This court had dismissed the writ petition on the ground that the petitioner had not produced any documents to show that the presenting officer had any role in framing the articles of charge, and that he was also the disciplinary authority. Full stop. However, this court had reserved right to the petitioner to urge the grounds urged in the writ petition in any petition that may be filed challenging the order that may be passed with the disciplinary authority. Therefore, the petitioner was not justified in seeking for a review of the order passed by this court, as the contention sought to be urged in this writ petition is kept open to be considered in an appropriate petition.
Not a list code, are they?
Full stop. In that way of the matter, no interference in that way of the matter, the order dated so and so do not merit to be reviewed. Consequently, this petition is dismissed. Abhinay Vaiti. The last title, the Abhinay White had made some submission. What was that? Order sheet.
My lords, I could not hear, my lords.
Huh?
Abhinay Whitey is not logged in. This is with regard to dismissal of the suit.
No, that is right.
Ref.
But, on the last date, he made some submission.
Yeah,
I think Mr. Rajesh Male, who was appearing for Abhinay Whitey, they said that they'll initiate proceedings for arbitration. Heladralla?
no, my lords, what they were proposing is that if we come to an consent, if we give a consent for an appointment of an arbitrator in this proceedings, your lordship had actually exercised that in case if we agree for it, the arbitrator would be appointed under this proceeding. But the respondent was not willing to give such a consent. Then why that consent could not be given is that, my lords, there are many defenses that has to be taken, and including the repayment. It is totally a money transaction which has happened. And as a security, the memorandum of understanding was signed. So he wanted to take defense from the inception, that is issuance of notice. So therefore, the respondent was not willing to give a consent for appointment under this proceedings, my lords.
Priya ಆಗಿದ್ದಾರಾ? Priya ಆಗಿದ್ದಾರಾ? ಹೆಂಗೆ? ಪ್ರಿಯಾಂಕರ್ ಬಿಟ್ಟು ಹೋಗಿ. ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಇನ್ನೊಂದು ಕೊಟ್ಟನಲ್ಲ, ಅದು ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಅಷ್ಟು ಪ್ರಿಯ ಬರಲಿ.
My lords, both of us have filed synopsis, my lords, in this
I'm not
matter.
able to find that synopsis, that is why.
My lords, 12/12/2024, my lords.
Yes. ಇದೆ ಬಿಡಿ. I'll do one thing, I'll list it on some other day. Let me just brush up the facts.
Yes, my lord.
Based on the date. It's been almost more than a month since I heard this matter.
Yes, my lords, it was prior to the winter vacation.
I'll take it up on 1st.
Yes, my lords.
It will be a Saturday.
Yes, my lord.
Srinivas B. Naik. ಅದೇನು ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ವಿ. ಇದು ಬರೋದೇನು ಬೇಡ ಅಂತ. ಶ್ರೀನಿವಾಸ್ ಪಿ ನಾಯಕ್. Venkat Subbarao.
In this case, I am representing respondent, my lord. I am representing respondent.
ಯಾರು ಆಂಜನೇಯ AB.
Yes, my lord.
ವೆಂಕಟ್ ಸುಬ್ಬರಾವ್ ಇಲ್ಲಿ.
ಅವ್ರು ಲಾಗಿನ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಬಟ್ ಮತ್ತೆ ಲಾಗೌಟ್ ಆಗಿದ್ದಾರೆ.
ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಏನು ಆಗುತ್ತೆ ಅಂದ್ರಲ್ಲ, ಇದು ಏನಿದು?
ಇದು ಅವರೇ ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಈಗ 7.5 ಕೋಟಿ ಪೆಂಡಿಂಗ್ ಇದೆ. 7.5 ಕೋಟಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಈಗ ಆಸ್ ಆಫ್ ನೌ.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಲ್ವಾ? ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಅಂದ್ರಲ್ಲ.
ಅದು ನಮ್ಮವರೆಗೂ ಇನ್ನು ಏನು ಬಂದಿಲ್ಲ ಸರ್.
ಶನಿವಾರಕ್ಕೆ ಯಾಕೆ ಇದು? ಲಿಸ್ಟ್ ಆನ್ ಸಾಟರ್ಡೆ. ವೆಂಕಟ್ ಸುಬ್ಬರಾವ್
ಲಾಗಿನ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಲಾಗೌಟ್ ಆದ್ರು.
ವೆಂಕಟ್ ಸುಬ್ಬರಾವ್ ಮೇಲೆ ಇರೋದು ಯಾರು? ಸರಿ.
Suit is pending.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? R5
only for R5 notice.
Issue notice to R5. Yes.
PF is paid off. PF has been paid off. Interim order may be.
Issue notice to R5. In addition, learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent before the trial court. Interim order granted early is extended till the next. Yes. Vinayak Apte. Acceptance of acknowledgement for copy bandidya?
Already.
Yes. Yes, Mr. Vinayak.
Lordship, suit was filed by Lordship before the trial court seeking relief of perpetual injunction in respect of social property.
Perpetual injunction.
Perpetual injunction. And facts in nutshell are that, my lord. Initially, the father of the petitioners filed suit in OS number 27/1977. Your lordship will have the copy of the decree at page number 62, sir.
Yes.
And my lord, that suit came to be decreed, thereby allotting 736 share to the petitioner. And the father of the petitioner, sir. Your lordship can have a glance to page number 62, sir. Judgment and decree, both copies I have produced.
Yes.
And the suit property, your lordship will find at running page number 66, sir. There are 4,500 properties. And this suit came to be declared on partition. Against that, appeal was filed by the defendants.
Yes.
In RA number 33/79. That was also came to dismiss, and RS also came to dismiss. Then, my lord, I admit that instead of initiating FDP proceedings, my lord, the father of the petitioner filed execution petition number before the executing court in EP number 292/86, sir. My lord, in that case, after issuing notices, the decree was referred under section 54, my lord, earlier to the deputy commissioner for effecting 4D map pertaining to his charge account in preliminary decree. And that report was submitted. After submission of report, as per the preliminary decree, my lord, application was filed to issue delivery warrant of possession. And accordingly, my lord, the executing court has written a letter to the deputy commissioner to hand over possession to the respective parties. And they were kept in possession, put in possession of the property respective shares. And their names are also entered in the RTC extracts by way of mutation order, my lord, certification of mutation order. Those mutation orders copies, my lord, I have produced at the annexure B1, B2, and B3 from page number 80 to 85, sir. And after this, my lord, after effecting my name, the respondents were trying to cause an interference, and they assessed that order of mutation before the assistant commissioner, who set aside that order, my lord. On the ground, instead of final decree proceedings, execution petition was filed. Procedure is not adopted. This is what observed by the assistant commissioner, and on that ground, the mutation order was set aside. I filed injunction suit. Sir, my submission is, rightly or wrongly, we have filed, my predecessor filed execution petition. And I have been put in possession of the property in pursuance with the order passed by the executing court. So I am in lawful possession of my share property, which is already to my share. My lord, trial court granted injunction. First appellate court only on this ground, my lord, final degree proceedings not initiated. There is technical error. On this ground, my lord, recall the order.
Technical proceedings initiate agde ortho.
That's I agree. I agree, my lord, don't dispute. But my share is for only bare injunction. Because I have been put in possession of my share in pursuance with the order of delivery warrant of possession issued by the honorable court, by the deputy commissioner. So my possession is to be protected.
Is held up in quarter number 4.
Please look at this one judgment which says even executing.
I do agree, my lord, about that.
I'm saying one judgment is in your favor.
Please, sir.
Which says even executing court can take steps to draw a final decree and hand over possession. Nodi, adide nodi. Even the executing court, if it has passed the preliminary decree, the executing court can pass a final decree and then pass an order to hand over possession.
But in this case, my lord, final decree is not passed.
You have a look at the execution.
Please.
Execution proceedings na nodbek neevu.
Please, sir.
Whether in the execution petition, whether the court has said, okay, draw a final decree anta helidara. Adanu nodbekalva. What is the stage of the suit now?
Stage suit pending, sir, still.
Pending, sorry, but what is the stage?
Not verified, my lord, sorry.
Yeah?
Verified, my lord.
Then
Suit is of 2008.
suit is filed in 357 of
2018, sir.
357 of 2018, Principal Civil Judge Sona Bhagewat. Check ಮಾಡಿ. But mutation set aside ಆಗೋಗ್ಬಿಟ್ಟಿದ್ಯಾ?
Mutation set aside again, sir.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
Al ಮಾಡಿಲ್ಲ, but we have directly approached to the court, my lord. Suit is filed.
Raise time.
Learn counsel for the respondents. Raise time. List on Saturday.
Week after next.
1ನೇ ತಾರೀಕು. ಬರಂಗಿದ್ರೆ ಬನ್ನಿ, ಇಲ್ಲ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. Yes, next.
PF is paid, your lordship. For respond number 7.
Huh?
Respond number 7, PF is paid, your lordship.
Learn counsel for the petitioner's paid process to issue notice to R7, Office Director to check, proceed and issue notice.
Much.
DP Ambekar. 11. Shivanand Patil. 10 night, huh?
For the petitioner.
11.
For the petitioner in this case.
Paid the process.
No, my lord told we are all sailing on the same. Sailing along with me, my lord.
Sachin Mahajan. And what are the facts?
My lord, the issue involved is very small, my lord. I am the owner of the house bearing CTS number 129, and defendant is the owner of CTS number 127. In between the two houses, there is a common wall, my lord. In that common wall, there is a small window. Through that window, I am using the air and light, my lord. And defendant is denying that there is no window at all. And I am saying that there is a window. So in order to ascertain that whether there is a window or no, I filed application under section 26, rule 9 for appointment of court commissioner.
Yes.
This is the crux of the case. Man.
That is rejected.
That got rejected. Man. And I'm using that window since from 20-25 years, my lord.
Evidence illide. Where is the evidence? Did you suggest to the plaintiff that there's a window? Did you suggest to the defendant Jayashri?
And he has denied in the written statement, my lord, but
cross examination photo gira ತೋರಿಸ್ಬಿಟ್ಟು suggest ಮಾಡಿದ್ರಾ?
ಸ್ಕೆಚ್ ಹಾಕಿದೀನಿ, ಅದು ಡಿನೈ ಮಾಡಿದ್ದಾರೆ.
Cross examination.
I don't have the cross examination.
How do you? The application for commissioner has to be looked into from the evidence, alva.
Need to identify whether the window is there or no, my lord. To ascertain that one,
You can take a photograph of the window.
yes, my lord. And again, they will deny that it is not that for any.
Have they denied? Will deny, Allah. Have they denied?
No.
If they have denied, then there's a need for commissioner. Have you seen the evidence?
No, my lord.
Mother?
I look into that, my lord.
Look into that under 2011 suit, Allah. And you kept the suit pending for so long. Saturday.
Right.
The Joint Counsel for the petitioner seeks time to secure the deposition of the defendant in the suit to ascertain whether any suggestions are made to the defendant about the existence of a window in the common wall. List on Saturday.
Interim order is in.
Interim order extend till the next date of hearing.
Grateful.
Ah.
Praise for time.
Huh?
Praise for time.
ಮಾಡ್ರಿ ಒಂದು
ಇಲ್ಲ ಎಲ್ಡ್ ಅಪ್ ಇನ್ ಕೊಡ್ತಾನೆ.
ನೀವೇ ಮಾಡ್ರಿ.
Next date.
ಮಾಡಿ ಪರವಾಗಿಲ್ಲ, ಏನಾಗುತ್ತೆ?
Next date, my lord. I will.
Please argue, attempt, let us see.
Next week.
You try it, mister.
I'm not prepared. Next week I will.
ಅರೆ ನಾನು ಹೇಳಿದೆ suit for injunction. Injunction is granted. Appellate court has confirmed it. What is a mistake? I dismiss ಮಾಡಲ್ಲ, but try ಮಾಡಿ. Try to convince me. First read paragraph number 2 in page number 11 of the suit.
The plaintiff has filed suit for
What?
permanent injunction against the defendant number 2, restraining him and his agents from obstructing the peaceful possession and enjoyment of the suit house property. Plaintiff bearing VPC number 255, measuring 30 into 40 feet of Daberi village in Vijaypur Taluk.
ಮುಂದೆ ಓದಿ.
Plaintiff is the absolute owner in possession of the house property bearing VPC number 255, measuring 30 into 40 feet of Daberi village in Vijaypur Taluk, as shown in the plaint, had sketch map letter ABCD portion. The said and sketch map is part and parcel of the plaint. The said house property is bounded as under towards east Government Hospital, towards west Ramnikam property, towards north Chavan land, towards south road. That the defendant number 1 was the owner of the suit property. Later on, the said house property was purchased by plaintiff from the defendant number 1 on 14/2/2018 before the sub-registrar Vijaypur as per the sale deed. The plaintiff has given worthy to the Gram Panchayat Aliabad for entering the plaintiff's name as per the sale deed. As per the worthy of plaintiff, the Gram Panchayat Aliabad entered the plaintiff's name in register number 9 of the Gram Panchayat Aliabad. The defendant number 1 is formal party in the suit because she was the previous owner of the suit property. After purchasing, the plaintiff reconstructed the house and constructed a shop on the first floor in the said property. That the defendant number 2, without any right, title or interest over the suit property of plaintiffs, is causing obstructions to the peaceful possession and enjoyment of the plaintiff's house property. That the defendant number 2 has been trying to high-handedly trespass and obstructing the peaceful possession of the plaintiff, even though the defendant number 2 absolutely in no manner has right, title and interest on the suit house property. On 15/6/2018, the defendant number 2 and his agents have been high-handedly trying to trespass and obstruct the peaceful possession of the plaintiff. The plaintiff has requested to the defendant number 2 not to obstruct her peaceful possession, but the defendant number 2 is adamant and influenced political person.
Page number 18.
18,
Para 12, 13A ಓದಿ.
13. That at the outset, defendant number 2 submits that defendant 2 named Muralidhar son of Bairu Dage is the absolute owner and in peaceful possession and enjoyment of the suit property bearing its VPC number 255 measuring 30 into 40 feet of Daberi village, Taluka district, Vijaypur, still today, and also the name of the defendant number 2 is appeared in the register 9 of the Gram Panchayat, Eliabad. Defendant number 2 is hereby producing the certified copy of register number 9 pertaining to the suit property issued by Aliabad Gram Panchayat Taluk and district Vijaypur, which is in the name of defendant number 2, and also taxpayer receipt handwritten RTC, Hath Naksha of suit property which are in the name of defendant number 2, and also endorsement given by the Gram Panchayat Aliabad. It is submitted that defendant number 2 is in possession of the said suit property and he has started 3 years ago the company called Siddhant Enterprises Distributors of Seeds, Fertilizers, Pesticides and Chemicals type of for all crops. The defendant number 2 has kept all material stock in the suit property. Defendant number 2 is hereby producing the list of material stocked in the suit property and photos along with CD. Therefore, such being the fact, plaintiff has got the interim order by misleading this honorable court and thereby obstructed defendant number 2 peaceful possession and locked the shop by using the honorable court order. It is further submitted that still today also defendant number 2's all material stocks worth of rupees 1 lakh is in the suit property. Moreover, plaintiffs averred in his plaintiff that defendant number 1 was the owner of the suit property and he purchased it. But in fact, defendant number 1 herself is or was not the owner of the suit property. It is further submitted that plaintiff creating a false document mislead this honorable court and thereby succeed in getting interim order by honorable court. Then defendant number 2 herewith furnishing the above said documents and further seeks honorable court to produce further documents. If
Agreed. Now we please come to para 10, page 25.
Para 10.
Para 10, page 20.
Page 25.
Oh.
On pursuit of the documents produced by both the parties, it is very surprised to see that PDO Aliabad by name B.R. Rathod has issued a certificate of ownership in respect of suit scheduled property in the name of plaintiff and also defendant number 2. With this regard, the summons was issued to PDO Aliabad for clarification. The PDO Aliabad appeared and filed affidavit stating that the name of the defendant number 2 is appearing in register number 9, but due to oversight, he has issued certificate in favor of the plaintiff. The PDO further stated in the affidavit that his predecessor by name MB Manuguli has not given any Hakku Bittu Patra as narrated in register 9. The PDO further produced a copy of the register 9 pertaining to the year 1998 to 1999 and 2010 to till today. On pursuit of the register 9 pertaining to the year 1998 and 1999, the name of the defendant number 2 is mutated in the place of defendant number 1. Under the specific narration, that name of the defendant 2 is entered on the basis of relinquishment. But the PDO in his affidavit specifically stated that no such relinquishment deed found in the records. Therefore, at this stage, it is difficult to believe the insertion of the name of the defendant number 2 in register number 9. In respect of the suit scheduled property, that the plaintiff in her affidavit clearly stated that she has purchased the suit scheduled property from the defendant number 1 by considering the explanation given by the PDO and non-availability relinquishment deed at this stage. It cannot be said that the name of the defendant number 2 is validly mutated in the register number 9. Therefore, in my view, without holding full-fledged trial regarding the entry of the name of the defendant number 2 in the register number 9, it is difficult to hold that defendant number 2 is the owner of the suit scheduled property. On the other hand, the plaintiff had produced the registered sale deed which prima facie disclosed the acquisition of the right. Therefore, in my view, the plaintiff has made out prima facie case.
Yeah, what is that you understood? Defendant number 1 ಮತ್ತೆ 2 ಅಣ್ಣ ತಮ್ಮಂದ್ರು. Defendant number 1 ಹೆಸರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇತ್ತು. ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಪ್ಲೇಂಟಿಫ್ ಸೇಲ್ ಮಾಡಿದ್ರು. ಸೇಲ್ ಮಾಡಿದ್ಮೇಲೆ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಹಕ್ಕು ಬಿಡುಗಡೆ ಪತ್ರ ಅಂತ ತಗೊಂಡೋಗಿ ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡು
Relinquishment.
ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡು he is obstructing the title of the or the possession of the plaintiff. What is wrong in granting the order of injunction? ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಏನು ಟೈಟ್ಲ್ ಇಲ್ಲ. ಟೈಟ್ಲ್ ಇಲ್ಲ. ಯಾರಿಂದ ಬಂತು ಟೈಟ್ಲು? D1 ಇಂದ. ಹೆಂಗ್ ಬಂತು? No document.
Relinquishment, no document.
D1 has sold it to the plaintiff. So therefore, why shouldn't injunction be granted? And you please see this one statement, page number 19. Page number 19, clause B. Defendant number 2 has kept all material stock in the suit property. Defendant number 2 is hereby producing the list. Such being the facts, plaintiff has got the interim order by misleading this honorable court and thereby obstructed defendant's suit possession and locked the shop by using this honorable court's order. So plaintiff is in possession virtually. ಮತ್ತೆ ಏನ್ ಮುಗಿಸ್ಬೋದಾ?
ಇಲ್ಲ, ಒಂದು ಟೈಮ್
ಶನಿವಾರ ದಯವಿಟ್ಟು ಒಂದು ಅಟೆಂಪ್ಟ್ ಮಾಡಿ, ಫೈಲ್ ಬಂದಾಗ ಓದ್ಬೇಕು. Counsel for the petition seeks time list on. Yeah. Is RS Kadaganchi?
One back, pardon your lordship. Serial number 7, there was interim order was there.
I think interim order not extend.
Me.
Yes.
Milords, here the petitioner is a Gram Panchayat member who previously had contested for the present post, and he has secured equal votes, and on the basis of chits, he lost the election. That is pending before this concerned civil court, the election petition. Now, I'll take my lord's attention to page number 9 and 10. This is the election notification that is issued by the designated officer, wherein in para 1, he says that the nomination shall be given to designated officer or to the officer whom he nominates on that day.
Please read.
Yes. Karnataka Panchayat Raj Abhiruddhi 19 ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಕಾರ ಯಾದಗಿರಿ ಜಿಲ್ಲೆಯ ನಗನೂರ್ ತಾಲೂಕಿನ ನಗನೂರ್ ಗ್ರಾಮದ ಪಂಚಾಯಿತಿ 2ನೇ ಅವಧಿಯ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸಲು ಈ ಕೆಳಗೆ ಕಾಣಿಸಿದ್ದಂತೆ ನಗನೂರ್ ಗ್ರಾಮದ ಪಂಚಾಯಿತಿ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ದಿನಾಂಕ 27/1/25 ಚುನಾವಣೆ ಸಭೆ ನಡೆಸಲಾಗುವುದು. ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯು ಅಲ್ಲವಾದರೆ ಗೊತ್ತುಪಡಿಸಿದ
ಇಲ್ಲವೇ
ಇಲ್ಲವಾದರೆ
ಇಲ್ಲವೇ
ಇಲ್ಲವೇ
ಇಲ್ಲವಾದರೆ ಅಂತ ಹೇಳಿ
ಇಲ್ಲವೇ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯವರಿಂದ ನಿರ್ಧರಿಸಲ್ಪಟ್ಟಿದ್ದ ಅಧಿಕಾರಿಗೆ ನೀಡತಕ್ಕದ್ದು. This is the
either the competent authority or any person authorized by the corporate authority.
Yes. Now, I'll take to page number 10, my lords. The notification that is issued in the last election was also of a same thing. In the first para, last 3 line, the same, copy paste. Here, if the rules are perused, my lords. Yes.
Rules of
Karnataka ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಚುನಾವಣೆ ನಿಯಮಗಳು 1995. I hope That's not,
ಇಲ್ವಾ?
it is 2024.
ತಗೊಳ್ಳಿ, ಇಸ್ಕೊಳ್ಳಿ.
This is the translated English copy also.
ಇದು ಕನ್ನಡ ಬರುತ್ತೆ ನಂಗೆ ಪರವಾಗಿಲ್ಲ. ಹಾ.
ಸ್ವಲ್ಪ ಹಿಂದಿ ಇತ್ತು ಅದಕ್ಕೆ. Milords, if rule 3 is taken first, there mentioned who is the designated officer. It is either the Tahsildar or the Deputy Commissioner.
ಅಥವಾ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ನಾಮ ನಿರ್ದೇಶಿಸಿದ ತಹಸೀಲ್ದಾರನ ದರ್ಜೆಗಿಂತ ಕಡಿಮೆ ಇಲ್ಲದ ಸರ್ಕಾರವು.
Yes. Here, in the case, Tahsildar is appointed as a designated officer. He again appoints the lower grade person there. That is wrong.
ಯಾರು? Whether the Tahsildar appoints?
Yes, madam. In the case here, Tahsildar is appointing. It is the Tahsildar who is the designated officer. I'll again take my lords to page number 9.
Page number?
9. The seal here. ಗೊರ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ ಹಾಗೂ ತಹಸೀಲ್ದಾರರು ಸುರಪೂರು.
Yes.
So this is wrong. This is wrong because it is against the law, because when we go to the entire rules right from 3, 4, 5, 6, 7, 8, my lords, here nomination has to be given to the designated officer. Scrutiny has to be done by him.
I didn't get your first point. You said the Tahsildar is the designated officer.
Yes.
How do you say
Yes.
that somebody other than the Tahsildar is delegated this power?
No, this notification is issued by Tahsildar. The election notice is issued by the Tahsildar. But there what he says that if the other officer comes also, the nomination shall be given to him. That is wrong.
ಎಲ್ಲಿದೆ ಓದಿ?
Yes, my lords. ನಾನು ಅದನ್ನೇ
ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ
ಇಲ್ಲವೇ ಗೊತ್ತುಪಡಿಸಿದ
ಅಧಿಕಾರಿಯವರಿಂದ ನಿರ್ಧರಿಸಲ್ಪಟ್ಟ
ಅಧಿಕಾರಿಗೆ ನಾಮಪತ್ರ ಸಲ್ಲಿಸಿ
ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ನಾಮಪತ್ರಗಳನ್ನು ಪ್ರಪತ್ರದಲ್ಲಿ ಸಲ್ಲಿಸಬಹುದು.
So the Tahsildar has got no powers to designate his power as a designated officer.
That is okay. ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ, but notice issue ಮಾಡೋದು ತಹಸೀಲ್ದಾರ್.
Yes, madam. The process. Now I am coming to the process after this notice is issued. Why I have taken my lord's attention to the election petition is because of such kind, the PDO has received the nomination. The election was conducted by PDO. After receiving such notice, somebody lower grade person goes and conduct the election, which is completely illegal. Here also, the same thing has happened. The designated officer can't delegate his power. But if this is set aside, it is only a matter of 8 days, because another notice can be issued. Let this system be set aside. Let this system be set aside. If this system is
let the government get information as to who has received the nominations.
My lord, who has?
Let the government get instructions.
Yes.
As to who has received the nominations from 18/1/2025. Like 27/1 is the election date.
Monday is the election date.
So therefore, let her get instructions. Have you made a statement anywhere in the writ petition?
Yes.
Have you made a statement anywhere in the writ petition that an officer below the rank of Tahsildar has received the nominations? ante ellaru helidira?
Sir, nomination ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಸೋಮವಾರ ಒಂದೇ ದಿನದಲ್ಲಿ it concludes. The election of the president concludes in only one day. ಬೆಳಿಗ್ಗೆ ನಾಮಿನೇಷನ್ ತಗೊಳ್ಳೋದು, ಸ್ಕ್ರೂಟಿನಿ ಮಾಡೋದು, ಅವಾಗಿಂದ ಅವಾಗ ಎಲೆಕ್ಷನ್ ಮಾಡೋದು, ಕೌಂಟಿಂಗ್ ಮಾಡೋದು. It is a process of only one day, that is on 27th. And complete process is done by only one person.
Issue notice, let the election be subject to the result of the writ petition.
Please.
HEGP is directed to accept notice for the respondents.
My lord, since
election to the post of.
My lords, only one point. My lords, I am not against the disposal of this writ petition. But let, my lords, this process, ಅಂದ್ರೆ ಒಂದ್ ಸರಿಯಾದ process 8 ದಿನ ಫರಕ್ ಆಗುತ್ತೆ ಅಥವಾ ಎರಡೇ ದಿನ ಫರಕ್ ಆಗ್ಬೋದು. ಅವ್ರು ಇನ್ನೂ ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡ್ಲಿ. ಅಂದ್ರೆ ಇನ್ನೊಂದು ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಆಗ್ಬಾರ್ದು ಅಂತ. ಲೆಟ್ ದಿಸ್ ಬಿ ಓನ್ಲಿ ಅವ್ರು ಒಂದ್ ದಿನದಲ್ಲೂ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡ್ತಾರೆ ಸರ್.
The elections that may be held to the post of president for the second term of Naganuru Gram Panchayat shall be subject to the result of this petition. Yes.
My lords, if not subject to the result of that election petition.
No. Subject to the result of this petition. Let us see on 27th, if the nominations are received by the Tahsildar.
Yes.
Then your writ petition goes.
My lords, then my writ petition is not maintainable. I have to go to election petition itself when I
Therefore,
challenge
then
the procedure.
challenge to this notice will go.
Yes.
You can always challenge the election petition, election. You can always challenge the election in the manner known to law.
May I submit that at that time my writ petition doesn't becomes infractious?
It becomes infractious.
Then the very.
No, just because you file a writ petition, we can't stay the election.
No, my lords.
Your case is very simple.
Yes.
Tahsildar is the designated authority.
Definitely.
Anybody other than Tahsildar cannot receive the nomination.
Yes.
Full stop.
Yes.
Correct?
Yes.
Now, we do not know whether Tahsildar is going to receive the nomination on 27th
Yes.
or any other officer other than Tahsildar is going to receive the nomination.
Yes.
So let us see what happens on 27th. If somebody else other than the Tahsildar receives the nomination,
Yes.
then you are bound to succeed.
Then again, ಈ 23 ಅಲ್ಲಿ ಒಂದು election petition ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
No, no,
ಇನ್ನೂ ತನಕ
next,
dispose
next. But could
If not,
Sangha-
direct them to issue other notification
No.
within 2 days.
Sangana Baswa be party.
Lordship, in serial number 1, specific direction is to me.
The learned HCGP is directed to secure information about
Regarding.
the officer who would be receiving the nominations at the elections that is to be held on 27th January 2025.
Please.
Yes.
My lord, in this case, the petitioners are the members of Respondent number 5 society. The name of the petitioner name entered in ineligible voter list.
ಅದೇನೋ ಮಾಡಿದ್ರು ನೋಡಮ್ಮ.
Seal number 20, the
HCGP is directed to accept notice for HCGP AG ಏನೋ.
SCGP.
HCGP is directed to accept notice for response 1, 2 and 3. Issue emergent notice to respond number 4 and 5. Interim order ಬೆಳಿಗ್ಗೆ ಒಂದು ಮಾಡಿದಿಲ್ಲ, ಸೇಮ್ interim order. ಯಾರು ಇವ್ರ ಕೇಸಲ್ಲಿ ಯಾರು?
seal number 20, my lord.
ಮಮದಾಪುರ್ ಕೇಸಲ್ಲ? ಅಲ್ಲ.
Legally hand delivery.
Yes, next. Vardhan.
Plaintiff's writ petition, my lord. There are 3, my lord, interim applications which are rejected. One is an application to implead, my lord, some of the defendants. And my lord, another application, my lord, my evidence was, my lord, closed. For that recalling, my lord, application was filed. And,
Cost ಕೊಟ್ಟಿದ್ದೀರಾ?
cost is paid, my lord. Memo is filed along with the order sheet of the trial court.
ಬರ್ಕೊಡಿ. The heirs of the deceased plaintiff in OS number 135 of 2015 on the file of so and so are before this court in this writ petition challenging an order dated 13/11/2020 and 24/9/2021 by which IAs 16 and 16, 20 and 21 filed by them to
My lord, 16 was for, my lord, impleading defendants 5 to 7.
implead defendants 5 to 7.
My lord, 20 was for, my lord, recalling of defendant witness DW1.
Recalling DW1 for further cross-examination.
For cross-examination.
For cross-examination and
my lord, reopening of plaintiff's side, my lord.
and to reopen the plaintiff's
Evidence.
evidence were rejected. Full stop. Next para. The suit in OS number 135 of 2015 was filed for
Declaration and injunction
declaration that the plaintiff is the absolute owner in an enjoyment
based on registered will deed.
in view of a will, in view of a testament dated 18/7/2009, executed by Srimati Rayava and for perpetual injunction. Full stop. The suit was contested by the defendant who denied the execution of the will in favor of the plaintiff and claimed that they had succeeded to the suit.
Yes, my lord. They claim that, my lord, from the original propositors by way of, my lord, another wife, my lord, they are
That they had succeeded to the suit
it-
property, and they had inherited the suit property. Full stop. Based on these contentions, the trial court framed issues and set down the case for trial. Full stop. Later, the plaintiff filed an application under Order 1, Rule 10(2) of CPC to implead proposed defendants 5, 6, and 7 on the ground that
on the ground that, my lord, defendants said that, my lord, they are necessary party, they were not arrayed as a party.
on the ground that the defendants had pleaded in their written statement that the proposed defendants 5, 6, and 7 were proper and necessary parties. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Paragraph 3 of the written statement, my lord, it will be at page number 15, my lord.
ಜ್ಯೋತಿ ಪ್ರಶಾಂತ್
Srikanth.
Full stop. The plaintiff also filed an application, bracket IA number 20, to recall DW1 for cross-examination and IA number 21 to recall the stage of the suit for evidence of the plaintiff. Full stop. All these three applications were rejected in terms of the order dated so and so. Being agreed with the same, the plaintiffs are before, the LRs of the plaintiff are before this court. Next, for the learned counsel for the plaintiff the LRs of plaintiff contended that the proposed defendants are the ones who were mentioned in the written statement filed by the defendants in the suit. He contends that since the suit was filed for declaration of title and injunction based on a will executed by Srimati Rudrava, Rayava, the plaintiff could not leave any other member of the defendants and therefore filed the instant application to implead the other members of the family of the defendants, who according to the defendants was proper and necessary for the adjudication of the suit. Full stop. He also contends that the plaintiff did not lead any evidence. Madlilva?
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ, they did not present.
He also contends that the defendant number 1 could not, DW1 could not be cross-examined.
Because of COVID, my lord, it was closed during COVID.
Could not be cross-examined due to the COVID-19 pandemic. And therefore she was discharged. Full stop. It is thus contended that it was necessary to recall DW1 for cross-examination. It also contends that the plaintiff is in possession of certain other evidence and the same required to be placed on record. And an opportunity had to be granted by allowing IA number 21. Full stop. Next para. The respondents, those served with the notice of this petition, have not appeared. Full stop. Next para. A perusal of the written statement filed by the defendants in the suit shows that the defendants had categorically stated that the proposed defendants were proper and necessary parties for the adjudication of the suit. And therefore, the suit without them was liable to be rejected for non-joinder of necessary parties. Full stop. Following this, full stop, the defendants, full stop, following this contention, the plaintiff had filed the instant application, though belatedly. Eಷ್ಟನೇ ಇಸ್ವಿಲ್ ಫೈಲ್ ಮಾಡಿದ್ದು?
Lord, it was filed in 19, rejected, my lord, in 21.
Filed belatedly. That too when the trial was underway. Full stop. Nonetheless, since the defendants had claimed that the proposed defendants were necessary parties, the court must have exercised jurisdiction under Order 1 Rule 10(2) of CPC and must have granted an opportunity to the plaintiff to implead the proposed defendants by placing the plaintiff on terms. Full stop. Similarly, the application filed by the
Page 40, my lord, type.
Page 40, no?
40, my lord, is the typed copy.
Similarly, the application filed by the plaintiff to recall DW1.
That was filed immediately. August was the order, September it was.
For cross-examination must have been entertained by the trial court by placing the plaintiff on terms, more particularly when plaintiff had sought for declaratory reliefs in respect of an immovable property. Full stop. Likewise, the application filed by the plaintiff to
Recall order of not holding that plaintiff evidence was taken as nil. It's at
plaintiff
page
evidence
40.
was taken as nil, though.
How's page 44.
To recall the stage of the suit and permit the plaintiff to lead evidence must have been allowed by placing the plaintiff on terms. So as to grant an opportunity to the plaintiff, the LRs of the plaintiff to establish their case. Full stop. Under the circumstances, this court is of the opinion that an opportunity should be granted to the plaintiffs to not only implead the proposed defendants, but also to recall PW1 for recording his evidence and also recall DW1 for further cross-examination. Full stop. This is however this is however subject to adjustment of cost of a sum of 10,000 deposited by the plaintiff before the trial court. Hence the following order. The writ petition is allowed. The impugned orders passed by the trial court dated so and so are set aside. And the application filed by the plaintiff to implead proposed defendants 5, 6, and 7, and the application to recall DW1 for further cross-examination, and the application to recall stage of the suit and lead evidence of the plaintiff. Bracket A number
I am 16, 20, 21.
15, 20 and 21 are allowed, subject to adjustment of costs deposited, subject to release of cost deposited by the, release of cost of rupees 10,000 deposited by the plaintiff to the defendants before the trial court.
No, it's already paid. The defendants are already.
Subject to already deposited ಅಂತ ಬರ್ದಿದೆ.
ಅವರಿಗೆ ಪೇಮೆಂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. Defendants have received that.
Received it, huh?
Yes.
ಹಂಗಿದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಬೇಡ. ಬೇಡ ರಿಲೀಸು ಬೇಡ. ರಿಸೀವ್ ಮಾಡಿದಾರಂತಲ್ಲ. Yes, next. I'll accordingly modify it. Ganesh SK. Sharana Basappa Bob Shetty.
Petition has become infructuous.
Infructuous.
Yes.
Suit dispose ಆಗಿದೆಯಾ?
Yes, ಆಗಿದೆ.
ಯಾವತ್ತು?
Sir.
The learned counsel for the respondent, Theatre respondent submits that the suit from which the present petition arises was disposed of on
26/7/2020.
26, 26, 8,
2020.
22. On 26/8/2022. Hence the petition is dismissed as having become infructuous. Yes. Ganesh Kalaburagi. Heir Biradar. There is no representation for the petitioner. Dismiss with Ray. List on. Mr. Mallabadi. Forty-four agenda. Huh? Next. 45 agenda. 46 R.S. Siddhapurkar. Rupa Sagar Patil. Even the OS number and tax security. OS number 1 stage. OS number stage 2. Lower court OS number, lower court present stage. Yes, please.
The petitioner was a civil contractor. He was interested with excavation of canal work. The total amount of contract was 4 crores 46 lakh 80,000. Out of that, 1 crore 47 lakhs and odd was paid. The final bill was raised, claiming 2 crores 82 lakhs. That includes the additional work carried out. It was not paid. Therefore, suit OS number 11 of 2007 was filed for recovery of that amount.
Yes.
That suit was dismissed on the ground of delay. Final bill dated to delay. Then the petitioner files first appeal before this honorable court. That was allowed. And after verifying the MV book, this honorable court comes to the conclusion that the petitioner is entitled for 74,52,992. That was ordered to be paid with 12% interest. That order was challenged before the Supreme Court. Supreme Court also dismissed the SLP. Thereafter, I filed execution petition. But in the execution petition, both parties filed calculation memo. The Lordship may kindly see Exhibit D.
Yes.
Respondents file a calculation memo. Exhibit D. Then I file a fresh calculation memo, calculating interest up to date of the hearing. The matter was heard. The executing court comes to the conclusion that the JDRs have already paid the entire amount. Only 15,426 rupees are to be paid.
Yes.
That is why annexure F. That order I have challenged on the ground that the calculation made by the JDR is wrong and the calculation made by me is correct. Therefore, as per the bills submitted.
No, now this court has said that you are entitled to 74 lakhs 52,992.
Correct.
Interest ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? 125.
Interest award ಆಗಿದೆ.
1 crore 62 lakh at annexure E, my lord, we have calculated the interest, page number 38,
ಅಲ್ಲಲ್ಲ,
that amount.
till the date of payment ಅಲ್ವಾ?
Till
The date of payment and
So-
amount is paid, total amount up to 24,019 we have calculated.
ಅಲ್ಲ 6/2/2001 ಇಂದ ಲೆಕ್ಕ ಹಾಕಿ ಇಲ್ಲೇನೆ.
ಹಾ.
6/2/2001
to 24,019, that is the last 2019, that is the last payment. 24,019.
ಎಲ್ಲಿದೆ ಇದು?
Lordship would get at annexure E, my lord, that is not disputed. Annexure E, page 38.
Annexure E ನಲ್ಲಿ ಎಲ್ಲಿದೆ?
Second, so serial number 2, interest at the rate of 12% per annum on decree amount from 6/2/2001 to 24/2019.
Total amount?
1 crore 62 lakhs 82,298. That is the interest at the rate of 12%. For that, we have added the cost awarded by this honorable court, then cost of copies, etc., etc. But total comes to 2 crore 40 lakhs 93,780. In that, my lord, we have deducted the statutory deductions. Total deductions would be 16 lakhs 28,230. And less the amount already paid, that is 1 crore 42 lakhs 69,421.
ಅದು ಬಿಟ್ಟು ತಾನೆ?
My lord, this was paid, my lord. They are admitted. This amount is
1
paid.
crore 42 lakhs
Yes,
deducted.
My lord, next again, the amount of rupees 17 lakh 76,330 is deposited on 16/9/2017. And on 16/2/2019, 26 lakhs 83,430 has been deposited. High court cost has been less the high court cost. Total amount due from KBGNL this date, 24/2019, is 26 lakhs 98,856. This amount is also now paid, my lord.
ಯಾವಾಗ?
It is paid on.
But what about the interest for that? When? ಅದಕ್ಕೂ ಕೊಡ್ಬೇಕಲ್ಲ interest?
This is calculated up to 20. Regarding this, I'll just once again verify on this amount whether interest has been paid or
26,
not. This is total amount due on 24/2019. Calculation was made up to 24/2019. On this amount, whether any amount interest has been paid or not, I will once verify.
ಅದಕ್ಕೆ ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡು
Counsel for the respondent 2 to 4 seeks time to verify
whether on balance amount of
whether the amount mentioned by the petitioner at annexure E.
But my lord, submission, my lord,
was
the trial court holds that I have not paid interest, but also it says at page number 44. In the said calculation memo, the interest is calculated by the JDR till the payment 24/2019, but calculated only
page 44.
44, my lord.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ?
There is something error in the at last 5 lines.
In the said calculation memo, interest
The
is not
interest is calculated by the JDR till 24/2019, but calculated only this the decree holder as per the memo of calculation dated 24/2000 claimed 26 lakh 98,000. As per the said calculation memo, the DHR by filing objection calculated the interest by decretal amount from 6/2/2019 to 24/2000. The said calculation is made till the date of payment by the JDR, which is correct, and the JDR is liable to pay. I'll just once verify regarding this, any interest has been paid on the balance amount of 26 lakhs 98,000. I'll verify and make submission on Friday.
Very cool. The learned counsel for the keyword, the learned counsel for the response 2 to 4 seeks time to verify whether a sum of rupees 26 lakhs 83,430 paid by the respondents
26 lakhs 98,856.
ನೀವು ಕಟ್ಟಿರೋದು ಎಷ್ಟು 2683 ಕಟ್ಟಿದ್ದೀರಾ?
ಅದಾದ್ಮೇಲೆ ಟೋಟಲ್ ಡ್ಯೂ ಮಲೋಡ್. Total due amount from KBJNL this date 24.
ನೀವು ಕಟ್ಟಿರೋದು ಎಷ್ಟು 2683 you have paid?
Yes, we have paid.
Whether any interest on a sum of rupees 2698,856 was paid by the respondents. List on yavat?
Friday or any date my lord.
Date you want?
31st, ma'am. 31st, ma'am.
Yavat ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ. ಗಣೇಶ್ ಕಲಬುರ್ಗಿ 47. Vikram Vijay Kumar. Anant Jagirdar. There is no representation for the petitioner and the respondent. List on date put. ಇದೇನೋ ಅಗಸ್ಟಿನ್ ಅವ್ರ ಕೊಲಿಗೆ ಒಂದೇ ಕಣ್ಣಲ್ಲಿ ಅಳ್ತಾ ಇದ್ರು ನೋಡಿ. ಅಗಸ್ಟಿನ್ ಇಸ್ ನಾಟ್ ಹಿಯರ್ ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು.
ಬೆಳಿಗ್ಗೆ ಅವ್ರ ಟೈಮ್ ಕೇಳಿದ್ರು 2013 ಮ್ಯಾಟರ್ ಅಂತ ತಾವು ಬೇಡ ಅಂದ್ಬಿಟ್ರೆ ವಿಲ್ ಹೇಳ್ತಾರೆ.
ಹುಡುಗ ಬರ್ಲೇ ಇಲ್ಲ ನೋಡು.
ಬರ್ಲೇ ಇಲ್ಲ.
Down counsel for the respondent number 1 seeks time.
Then interim order that has to.
List on so interim order granted release extend to the next date.
Interim order.
Interim order extended. Yes, Deepak Bharat, DP Ambekar, 50. Shivanand Patil. Ready na? Can we take it up?
Ready?
Ready. You are ready.
Small technical issue, my lords, blanket. The trial court has passed an wrong order, my lords, basing on which, my lords, suit was taken up for hearing on IA number 1, my lords. When the matter was posted for orders on IA number 1, which was, my lords, court dismissing the suit on want of pecuniary jurisdiction, my lords.
Dismissing the suit.
Yes. Due to inadvertently, my lords, the court bill, the council, my lords, had filed a miscellaneous appeal, my lords, which was held to be not maintainable. Being agreed by the both, my lords, I am before this honorable court, my lords. Though, my lords. Yes,
before we
subject
start
matter of the suit property is 2.5 crores.
Before we start with this point, my lord, I think so they have already also availed the remedy of appeal. They have also filed an, they have availed the remedy of filing another suit. The court had granted them the liberty to file before the appropriate court. Unfortunately, it should have restricted itself to that much only. You are entered, the plaint is returned, presented before the proper court to dismiss and bittidare.
2.5 crores anta ide.
2.5 crores elevation.
Lease amount, my lords. It's a leasehold rights, my lords. In the lease agreement, it was mentioned as 2.5 crores, my lords.
So what was the suit for?
Suit for, my lords, declaration, my lords, to declare the plaintiff as leasehold rights granted in favor of defendant number 2, my lords.
ಈ 2.5 crores ಅಂತ ಹೆಂಗ್ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ತಾರೆ?
ಅವ್ರು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನ.
ಅದೇ ಹೆಂಗೆ ಅಂತ?
Taking note of the leasehold.
Lately, everywhere they have taken out that reference.
But have a look at the.
Defendant number 1, in order to overcome its findings, has approached the plaintiff and taken a loan of 2 crores 50 lakhs.
Find out whether you already filed a suit.
They have already filed a suit. They are OS number 393 of 2021, if my learned friend is agreeable to that.
I'll have to.
They have already filed it before the principal civil judge.
OS number?
393 of 2021.
Madam, OS number 393 of 2021 on the file of?
Senior Civil Judge Bijapur.
Senior Civil Judge Bijapur. Tegiri.
OS number.
And they have also added another relief in addition to this present release. They have also sought for specific performance of contract to transfer the shares of the plaintiff.
There, my lords, there is an agreement between the parties, my lords, regarding the agreement for sale, my lords. That suit is different, my lords, might this suit. I'll have to verify and make my submission, my
So
lord.
let us see what is the stage. 393 same parties are ಏನು no.
Viresh Kumar.
No, when CPC matters are listed before the court, I think lawyers should look at the High Court website to find
Yes.
out the status of the suit.
In fact, earlier office used to be doing that.
ಎಲ್ಲ ನಾವೇ ಮಾಡ್ಬೇಕು, ನೀವೇನ್ ಮಾಡೋದು ಮತ್ತೆ?
ಎಲ್ಲರೂ ಒಂದು ಟ್ಯಾಗ್ ಹಚ್ಚಿಟ್ಬಿಡ್ತಿದ್ರು ಡಿಸ್ಪೋಸ್ಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಡ. ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾವು ವಿ ಓನ್ಲಿ ಜಸ್ಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್.
ನೀವೇನು ಮಾಡಂಗಿಲ್ಲ.
OS number 393.
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಇದೆ.
ರಾತ್ರಿ ಓದೋದೇ ಒಂದು ದೊಡ್ಡ ಕೆಲಸ.
ಒಳ್ಳೆ ಕತೆ.
Parties are
ಅಷ್ಟೊಂದೇ
Viresh Kumar
ಕಷ್ಟಪಡಕ್
versus Kalyan.
ಹೋಗ್ತೀರಿ.
My lords, parties are different, my lords. Viresh Kumar versus Kalyan Kumar. One of the party is, the respondent is one and the same, my lords, but the petitioner is different.
ವೀರಕುಮಾರ?
Yes, my lords.
ವೀರ್ ಕುಮಾರ್ ಇದ್ದಾರೆ.
ವೀರ್ ಕುಮಾರ್.
ಕ್ಲಾಸಿಕ್ ಅಡ್ವೊಕೇಟ್ ಅವನೇ ವೀರ್ ಕುಮಾರ್.
ವೀರ್ ಕುಮಾರ್ ಇದ್ದಾರೆ.
ಅದರ್ ಸೈಡ್ ಡಿಫೆಂಡೆಂಟ್ ಯಾರಮ್ಮ?
Defendant is same, my lords.
Kalyan
Defendant,
Kumar and,
Kalyan Kumar.
ಕಲ್ಯಾಣ್ ಕುಮಾರ್.
Yes,
ಕ್ಲೈಂಟ್ ರಿಲೀಫ್ ಸಿಗುತ್ತಾ? ಏನ್ ಕೇಳಿದಾರೆ ಅಂತ?
that
ರಿಲೀಫ್ ಶಾರ್ಟ್ ಫಾರ್
ಅದು ಗೊತ್ತಾಗಲ್ಲ, my lords.
ಪ್ರೇಯರ್ ಸಿಗುತ್ತಾ?
Prayer ಗೊತ್ತಾಗಲ್ಲ. Prayers
ಗೊತ್ತಾಗುತ್ತಂತೆ, ನೀವು ನೋಡಿಲ್ಲ ಅಷ್ಟೇ.
ಇಲ್ಲ, my lords. I have gone through the prayer ಗೊತ್ತಾಗಲ್ಲ.
ಫಸ್ಟ್ ಶೀಟ್ ಇರುತ್ತೆ ನೋಡಿ.
Prayer will not be mentioned in the. ಇಲ್ಲ ಇರಲ್ಲ. It is not there in the website, my lords.
ಮತ್ತೆ ಯಾವಾಗ ಹೇಳ್ತೀರ?
Monday, my lords.
Counsel for the petitioner seeks time to secure instructions list on.
Obliged.
KM Gate, Ravi Patil. There is no representation for the petitioner and the respondent number 1 to 3 list on. Arun Kumar Amargundappa. Ganesh Kalaburagi. Huh?
Petition by the defendant number 3 to 6
R
before the trial court. Yes,
Defend number?
3 to 6. Whereunder the application filed seeking to recast the issues under
Seeking-
order 14,
seek-
recast.
Recast the
Yes.
issue. What is the suit
Under order
for?
14, suit for declaration and possession, my lord,
Hmm.
filed by the plaintiff, that is respondent number 192 here.
Where are the issues?
Issues, my lord, is at page
Page 33.
yes, 33. Page 33.
Hmm.
In fact, my lord, it is after presenting suit, instituting suit, the defendants number 3 to 6 herein have filed their WS admitting entire claim of my lord plaintiff. And defendant number 192, they, my lord, denied the case of plaintiffs. In the written statement, in the plaint itself, my lord, plaintiffs have pleaded that these defendants, 3 to 6, are in permissive possession of the suit scheduled properties. At the same time, my lord, there is a denial by the, my lord, defendant number 192, that they are in possession of the suit scheduled properties.
Yes.
And in the written statement, these defendant number 3 to 6, since have admitted, they filed an application.
What does the plaintiff say in so far as defense 3 to 6?
3 to 6, we are in permissive possession. They also concedes that fact, my lord. May I request?
What does the plaintiff say?
Yes, yes, ma'am.
What does the plaintiff say about defendants 3 to 6?
We are in permissive possession, my lord.
What does the plaintiff
Yes,
say about defendants 3 to 6? Plaintiff ಏನಂತ ಹೇಳ್ತಾರೆ?
page 17, my lord. Para 10. At present, the defendant number 3 to 6 are in possession of the both suit lands, and their possession is permissive possession.
ಆಯ್ತು.
The defendants are,
Then
yes.
what does the defendant number 3 to 6 say?
3 to 6, we also admit the entire claim made by, set up by the plaintiff. And we also concede the fact that we are ready to hand over possession as and when, my lord, they require.
Correct, if there's, where does an issue arise?
Yes, madam. Issue arise, it is because defendant number 192, while filing their written statement, they denied these material facts.
That's all okay. Plaintiff says defendants 3 to 6
Please.
are in permissive possession.
Yes,
Defendants 3 to 6 admit that.
yes,
And they say, yes, we are in a permissive possession. How can defendants 3 to 6 ask the court to frame an issue whether they're in permissive possession? Please read the annexure F for the.
yes, yes. Annexure?
Annexure F is the application, thane.
Yes,
Please read the additional issue.
annexure F. Additional issue, whether defendant number 3 to 6 proves that they are in possession of suit lands with the permissive possession of plaintiff.
ನೀವು dispute ಮಾಡಿದ್ರೆ issue ಬರುತ್ತೆ.
Allah, my submission is, my lord, these defendant number 3 to 6 have stepped into the shoes of plaintiffs.
So
Therefore,
ಅವಾಗ issue ಬರೋದು ಯಾವಾಗ ಕೊಡ್ರಿ.
yes, when there is, my lord,
Does an issue arise?
assertion and denial by the, my lord.
When does the issue arise?
Yes,
ಓದಿ
14 rule 1, my lord.
ಓದಿ ಓದಿ 14 rule 1 ಓದಿ.
Framing of issues.
ಓದಿ.
Issues arise when a material proposition of fact or law is affirmed by one party and denied by the other.
ಎಲ್ಲಿ ಡಿನೈ ಮಾಡಿದ?
Yes,
ಎಲ್ಲಿ ಡಿನೈ ಮಾಡಿದ?
my lord, 3 to 6, my lord, they are including, my lord, plaintiffs, they assert that, my lord, they are in possession or, my lord, permissive possession. There is denial by the defendant number 19.
Correct. Application ಹಾಕಿರೋದು ಯಾರು?
ಅಲ್ಲ, ಅದು ಒಂದು
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು?
3 to 6.
Defendant number 1 and 2 ಹಾಕಿದ್ರೆ I can understand. Application is filed by defendants 3 to 6. The plaintiff filed a suit for declaration, recovery of possession.
Yes.
Correct?
Yes.
In the plaint, what did he say? He said defendants 3 to 6 are in permissive possession.
Yes.
Defendants 3 to 6 also admit that.
Yes.
So how can the defendants 3 to 6 again come before the court and say, please frame an issue whether we prove that we are in permissive possession anta?
There may be wrong in filing application, but, my lord, it is the duty of the court to frame an issue to that effect, so that, my lord, suit will be decided in a proper manner.
Issue ಹೆಂಗ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ರಿ.
ಅಲ್ಲ,
Defendant number 1 and 2 has not filed the application.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Defendant number 3, 4, 5, 6 ಹೆಂಗ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಕೇಳ್ತಿದ್ರು.
It may, filing of application may be wrong, my lord, but duty is casted on the.
What issue has to be framed? Please tell us.
Issue with regard to, my lord, whether the defendant 3 to 6 or plaintiffs are in possession, or, my lord, it is 192.
You are for defense 3 to 6.
Yes.
You are admitting that you are in permissive possession.
Yes, yes.
So what issue arises here clearly? What issue arises for consideration?
My lord, kindly look at, my lord, issues framed by the trial court itself. With regard to possession, there is no issue at all.
What? Page 33. What? Second issue what?
Recovery of possession ಅಂತಿದೆ.
ಇದೆಯಲ್ಲ?
ಅಲ್ಲ, recovery, whether they are at it.
ಇದೆಯಲ್ಲ, recovery of possession ಇದೆಯಲ್ಲ?
Whether defendant number 192 are in possession.
ಅದು ನೀವೇನ್ ಕೇಳ್ತೀರಾ ಅಂತ ನಾನು ಕೇಳ್ತಿರೋದು. Whether plaintiff is entitled for recovery of possession of the suit property from defendants.
Allah, this issue basically framed, it is because of, my lord, assertion made by the defendant number 3 to 6 that they are in permissive possession.
Sorry.
It is not because that defendant number 192 are in possession.
Defendant number plaintiff go, defendant 3 to 6 go, dispute is over.
Yes, yes.
Plaintiff go, defendant 3 to 6 go, dispute is over.
Yes, yes.
Because defendant says, yes, I am in permissive possession.
Yes.
So suit against defendants 3 to 6 has to be decreed.
Yes.
Correct?
Yes.
Defendant number 1 and 2 ಮೇಲೆ case ನಡಿಬೇಕು. Court has said whether the plaintiff is entitled for recovery of possession of the suit property from the defendants. How does this issue arise? ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲ, correct me if I am wrong, Arun.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
ತಪ್ಪಾಗಿದ್ರೆ
ಇಲ್ಲ,
correct
ಇಲ್ಲ.
ಮಾಡ್ಬೋದು.
ಇಲ್ಲ ಇಲ್ಲ.
You are free to correct.
No, no.
The defendants 3, 4, 5 and 6 in OS number 121 of 2016 on the file so and so are before this court challenging the correctness of an order dated so and so by which an application filed by them under order 14 rule 5 of CPC was rejected. Next para. The suit in OS number so and so was filed for declaration of title of the plaintiff to the suit property and for recovery of possession. The plaintiff contended that
Suit lands or
suit property belonged to his ancestors. Full stop. He contended that a tobacco company was established at Yemmiganur, and therefore his father and his grandfather migrated to Yemmiganur. Full stop. While leaving the village, they asked the defendants 3 to 6 to cultivate the suit lands and to give a share of the crop. The defendants 3 to 6 were therefore cultivating the suit property with the permission of the father of the plaintiff. The plaintiff claimed the defendants 1 and 2 were strangers and were not concerned with the suit property in any manner whatsoever. Full stop. The plaintiff claimed that the defendants 1 and 2 got the revenue records transferred to their names, claiming to be the legal heirs of the father of the plaintiff. Thereafter brought about several revenue records. Full stop. The plaintiff therefore claimed that he is entitled to a declaration that she is the owner of the suit properties and for eviction of the defendants from the suit property and for rectification of the revenue records. Full stop. Next para. The defendants 1 and 2 contested the suit and laid a claim to the suit property and denied the claim of the plaintiff. Full stop. The defendants 3 to 6 admitted that they were in permissive possession of the suit property. Full stop. Based on these contentions, the trial court framed the following issues, page 33. Later, the defendants 3 to 6 filed an application under Order 14, Rule 5 of CPC, suggesting an additional issue, which is as follows. Copy mode, page 34. This application was contested by the plaintiff, by the defendants 1 and 2, for the defendants 1 and 2, consequent to which the trial court rejected the application in terms of the impugned order on the ground that since the defendants 3 to 6 had prayed to decree the suit, the additional issue suggested by them does not arise. So being agreed with the said order, the defendants 3 to 6 are before this court. Next para. The learned counsel for the plaintiff defendants 3 to 6 contends that it was incumbent upon the court to frame an issue as to whether the defendants 3 to 6 were in permissive possession of the suit property or not. He submits that since the trial court failed to frame an issue, the defendants 3 to 6 were forced to file an application. Full stop. He contends that the defendants 1 and 2 have disputed the claim of the plaintiff, and therefore the court must have scanned the statement filed by the defendants 3 to 6 and must have framed an issue for the nature of possession of the defendants 3 to 6 so as to non-suit the defendants 1 and 2. Next, I have considered the respondent the LRs of the deceased plaintiff who are arrayed as respondents 1 to 3 in this writ petition, those served with the notice of this petition have not appeared. Full stop. Next para. An issue of fact or law arises when each material proposition is affirmed by one party and denied by the other. In the case on hand, plaintiff asserted that the defendants 3 to 6 were in permissive possession of the suit property, and the defendant 3 to 6 also admitted it in their written statement that they were in permissive possession of the suit property. Therefore, the question whether they were in permissive possession of the suit property or not did not arise, as the defendants 3 to 6. The trial court has therefore rightly held the additional issue suggested by the defendants 3 to 6 does not arise for consideration. Under the circumstances, no interference was warranted with the impugned order. Hence, the writ petition is dismissed.
Great.
Shivanand Patil, Anumesh Rao for respondents.
Mr. Chetan Kumar is at appearance.
Chaitanya Kumar.
Yes, madam.
ಏನ್ ಬಂದಿಲ್ವಲ್ಲ ಚೈತನ್ಯ ಕುಮಾರ್?
ಬಂದಿದ್ರು ಅವರು. I have informed him also.
Varun, find out if Chaitanya Kumar is there. He left, is it?
Where seen in the corridor?
Huh?
He's nowhere seen in the corridor. No. Morning he was there.
There is no representation for the response 1, 3 and 4. List down on date.
Seeing for an interim order, let Monday.
Monday.
Taken up on the orders list na order.
ಬರುತ್ತೆ, reach ಆಗಿದೆ. Next. R.S. Siddhapurkar, government advocate. Ready, huh? Ready, na? Amareshwar Temple Committee. Yes, please.
Lord, there is a temple known as Amareshwar Temple in Devar Bhopur village of Lingsur Taluk. A very old temple, my lord, has large extent of land around. Lord, the petitioner is a trust. They are interested in social service. They are distributing food and water to the devotees. Lord, in the year 1970, the trust approached the temple committee and requested them to allot a site for this social activity. Lord, it was allotted on 19/2/1970 and rupees 300 was collected from the trust, and we were allowed to carry out our social activities there. Then further down the lane, and one Anna Chhatra and one Kalyan Mandap were constructed by the trust in the very same place.
By the
Trust, petitioner trust. That was in the year 1970 itself. Not in the 1970s, the temple committee changed. They started interfering. Therefore, I had to file a suit in OS number 119 of 94 at the civil judge court at Raichur was dismissed and ultimately it came to this honorable court. This honorable court granted me an injunction order, reserved liberty to the temple committee to evict me in accordance with law. Thereafter, they filed a suit for eviction against me. I contested, I produced all documents, everything and everything. Arguments were, evidence was led, arguments were also heard. When it was posted for judgment, an application came to be filed by the government saying that this suit should be transferred to land grabbing court at Bangalore under section 20. That I opposed, saying that I am not a land grabber, I am there under a permissive possession. Therefore, land grabbing court will not have jurisdiction to decide this matter. Since you have heard the matter already, please pass a judgment. But without considering our objections properly in a right perspective, the IA number 7 filed by the government was allowed and the matter was ordered to be transferred to the land grabbing court. That order, my lord, I have challenged.
Yeah, land grabber, the definition is the word. Is not, how can you say that they are a land grabber?
I find the objection.
Well, first to find out who you are a land, please establish how the defendant is a land grabber.
One judgment of this honorable court, my lord.
How is a land grabber ಅಂತ ಹೇಳಿಲ್ವಲ್ರಿ?
ಹೇಳಿಲ್ಲ.
Objection ಅಲ್ಲಿ. Huh? How is a land grabber?
Next week. AG will argue.
AG.
Friday.
Council learned
Friday.
AG seeks time. List on Saturday.
There is a reported judgment on this point, my lord.
ನೋಡ್ಲಿ
Not
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಏನ್ ಬಿರಾದ್ರ ಅರ್ಜೆಂಟ್
section 20 ಅಲ್ಲಿ the court has to come to the conclusion that I am a land grabber. Then only it can run.
That is why I asked him how it's government land, how you are a grabber. Without considering that, how can they even say?
Yeah. Date of,
1ನೇ ತಾರೀಕು.
please, public.
There is no representation for the petitioner. There is no representation. ಇನ್ನೂ ಇದೆಯಾ? ಅರ್ಲಿ ಎಲ್ಲಿ ನೋಡಿರಿ? ಆಯ್ತಾಯ್ತು ಬರ್ಲಿ ಅವ್ರು.
53 madam. Sir, serial number 53 madam. ಮುಂಜಾನೆ ಬಂದು ಬಂದಿದ್ದೆ ಡೇಟ್ ಕೇಳಿದ್ರೆ ನೀವು ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ಬಂದು ನೀವೇ ಅರ್ಜಿ ಮಾಡಿ